Good morning, ladies and gentlemen, colleagues. The Joint Performance Committee is now in session. I'd like to welcome the members, our staff, and the guests, and a special thank you to the staff members and colleagues for accommodating the needs of the chair to adjust the calendar. If we are still in session at 11:30, we will recess until about 13:30 or until the 11th of January to allow the ALC Executive Subcommittee to address an issue that they need to get taken care of. So today we're going to be taking questions from committee and non-committee members alike in the order that we receive them in the queue. I'm not going to, give committee members preference over non-committee members because everybody has an interest in asking some questions. All of our witnesses will be sworn testimony when they come to the table. And members, if you would, please limit your questions to 2 or 3 without asking for a follow-up. Just go ahead and ask your questions in the interest of time and keep it to 2 or 3, or I'll cut you off and then get back in the queue if you still need to ask any questions. So at this point, I'm going to yield to my co-chair, the very Honorable Senator Kim Hammer, for any comments that he may have.
Have none. Thank you, Mr. Chair.
Thank you, Senator Hammer. So getting right with it, we'll call our first witness to the table. Oh, I'm sorry. We need to approve the minutes of the February 26th meeting. Do I have a motion? I have a motion and a second. All in favor, say aye. Aye. All opposed, seeing none, passes. And next up, Mr. Dubs Byer. If you'd come to the table, please. If you would, remain standing, raise your right hand. Do you solemnly swear the testimony you're about to give will be the whole truth, nothing but the truth, so help you God? Please take your seat, state your name and the position for the record.
My name is William Dubs Byers. I'm a member of the Board of Correction.
Thank you, Mr. Byers. Thanks for being here today. And my first question to you is, did Mr. Metazadigan provide you any advice on your testimony today?
We talked, yes, sir.
Okay. And did you meet with anyone to prepare your testimony today other than Mr. Metazadigan?
Not to prepare, no. I spoke with several individuals about coming here
So
today.
You did? Okay, thank you very much. Have you seen the list of witnesses being called to testify today?
Yes, sir.
Okay, and from the people on that list, who all are here today that you know
of? From the board, I know that Chairman Magnus is here. Lee Watson is here, board member. Brandon is here, board member. Lana McCaslin is here. She's a board member. Reverend Tyrone Broomfield is here. He's a board member. I've not seen Pastor Giles. He may be here. I don't know. Sherry Gray is here. She's our administrative assistant. Of course, from the Department of Correction, we have Chad Graves and Wade Hodge. I'd have to look at the list.
I think that pretty well covers it. Thank you. So, have you ever emailed or texted with Mr. Metazadigan?
Yes, sir.
Okay, so have you provided those communications to this committee?
Everything that I have has been provided, yes, sir.
Okay, thank you. Who altered the purported services contract that's in question?
Well, originally it was authored by the...
I'm not asking. I'm asking who altered the document. We know who it was originated with. Who altered the document?
Well, originally it was authored by staff in Chad Brown's office.
So my question is, who altered the purported document? So you have a document that's already made. I want to know who altered it after it was finalized.
That would be the attorney, Abton.
Okay, thank you. Any questions from the committee? please. Okay. Senator Gilmore, you're recognized.
Thank you, Mr. Chair. Thank you, Mr. Byers. So just following up on the contract, did the Board of Corrections vote on the purported services contract?
No, it did not.
Okay. Was there a vote on the engagement letters related to Mr. Metazadigan?
Yes.
Okay. Did any other board members vote to review the contract, the services contract?
Are you talking about the one that was presented to the procurement?
Yeah, I'm talking about the one that you just answered that they didn't vote on. So I'm asking if anybody else reviewed.
Say again, please.
Did anyone else review that services contract?
Not that I'm aware of. It was sent to Benny Magnus and also to Lee Watson. In my review of things, Lee did not review it, and Benny briefly reviewed it.
Okay. Mr. Chairman, I'll get back in the queue.
Thank you, Senator Gilmore. Representative Lundstrom.
Thank you, Chairman. Over here.
Yes, ma'am.
The contract that was changed, was there an addendum signed by the members once that contract was changed?
Was there an addendum what?
Addendum signed for the contract that was changed? When a contract is changed,
Yes.
people have to sign off on it. Was
Yes.
there addendum signing off on it?
Yes.
Has that been made public?
Is that what?
Has that been made public?
That's the contract that was presented to ALC. It was signed off by the attorney and also Chairman Magnus.
With the changes, an
the
addendum was
changes.
made to the contract with those changes, and
Yes,
that
ma'am.
was signed off. Okay, thank you.
Thank you, Representative Lundstrom and Representative Furman.
Thank you, Mr. Chair. I'm over here in the front row.
Okay. Sorry. Thank you.
Did the attorney communicate with the board about the changes he made to the contract?
And I apologize. I'm hard of hearing, so I'll ask to repeat a lot. I'm sorry. Ask again.
Said, did the attorney communicate with the board about the changes he made to the contract?
He sent it. No, not the board.
So do you find it problematic that he changed the contract to increase the price $7,000 and didn't communicate that to you guys?
No.
You don't find that problematic?
No.
Okay, can you help me understand how it's not? I mean, I sell real estate. If I agree to sell someone's house at 6% and then at closing it's 10% and I don't communicate that to my client, I think my client would be pretty unhappy with me.
It's my understanding that when it was first presented that it was only an estimate. They asked for an estimate, and then for the final, it was 207.
Okay, thank you.
Senator Bryant.
Thank you, Mr. Chair. So to follow on with his question, at what point would an increase be problematic? At what threshold would you take a step back as a board member or as a board and say this is problematic, that is not as the terms as the original contract?
I don't know. I can't answer that question. The form that was submitted was the final form, and it had the amount on it. That was not that form, that service contract was not approved by the board. It never had, one of those never has been approved by the board.
Okay. How long have you been on the board?
About 8 years.
8 years. Can you walk me through a typical practice when a contract for anything of significant value, such as this,
Sure.
comes to the board?
Sure. Usually a contract is brought before the board, a full contract is brought before the board, and it is reviewed. As a matter of fact, the medical contract is the most recent one. It was brought before the board, it was reviewed. There were some questions about it. There were a few changes made. It was approved by the board, and that's it. We have never submitted the documents to ALC that were submitted. That's all done by staff or by OSP. It's not done by us. We only approve the contract, which is which is what we did with the contract for the attorney. We approved the contract.
I thought your testimony was you did not approve it as a board, you just approved the
original contract.
the letter of engagement.
Well, I'm calling that a contract. We approved the letter of engagement or the contract with the.
So did the letter of engagement have all the stipulations of the contract, the terms, the amounts?
No,
So how do you have a contract without terms?
I don't know, Senator. I'm not. That's not in my wheelhouse. I don't know. I just know that we approved hiring an attorney.
Through a contract or through an engagement letter?
I don't know what the proper.
So your testimony is anytime we have a contract, you view it as a board and you go through the terms and you ask questions. Mm-hmm. In this case, you're telling me that you don't know if you did that or not.
I don't know what the vernacular is, the proper vernacular. It was my opinion that when we hired Abton, that we entered into a contract with him. You may call it an engagement letter. I'm not an attorney. I don't know the proper vernacular.
Okay. All right. Thank you, Mr. Chair. I'll get back in the queue.
Yeah, and so, Mr. Byers, the contract that the board approved, what was the amount on the contract?
We did not, on the original contract, that we did not approve. We did not approve a figure. There was not a figure on it.
How can you have a contract if there's not a figure on it?
I don't know.
You're on the board, right?
I am.
So that's kind of disturbing in itself. So anyway, my co-chair, Senator Hammer.
Morning. Dr. Byers, let me ask you, first of all, how is it that you and the board have found yourself in this situation in the first place, that you're dealing with a contract? Because listening to your testimony, I'm getting the impression this is the first time occurrence, or it's uncharted water for the board.
It is.
So being that it's uncharted water and a first time experience for the board, how is it that y'all found yourself in this position in the first place?
First of all, we submitted the engagement letter back in February. And at that time, there was nothing, and to the best of my knowledge, there was nothing said that anything else needed to be submitted until March 4th. March 4th, and I believe that was the day before the deadline to submit the documents to OSP, ALC. So the day before it was due, then it was told to us that it needed to be in this format.
Could I ask you, before you go on, who told you that?
I'm sorry?
Before you go on, who told you that?
It's in all the emails and everything is in the document that I prepared.
But for the record, who told you that?
Who told me personally?
Well, who told you personally, and then was that communicated to the board as a whole also?
No, it was not communicated to the board. It was handled by staff.
Okay. All right, well, go ahead. We're at March 4th now. Go ahead with.
Someone communicated with Mr. Armstrong, and I'm going to the best of my knowledge here, but somebody, Flora Johnson, I believe, communicated with Mr. Armstrong, who said that it needed to be submitted in this format, and that's when everything got kicked into high gear, because we actually had less than 24 hours to get the documents ready, signed, and presented. It was a hurried process. It should never have been done that quickly. And I think that was the source of the problems.
Okay, one more time. I heard, who is it that told you that? You said it was passed up to Ed Armstrong, but who was it that communicated that to you? Was it Chad Brown? Was it your attorney, or who was it?
Chad, probably Chad, but I can't remember exactly.
Okay.
Chad was our main communicator.
Okay, we'll get to it then. Thank you, Mr. Chair. I'll yield.
Thank you, Senator Hammer. And so I'm going back to my question earlier about this contract that the board reviewed. So I'm not an attorney, but I know a little bit about contracts, and there's like 3 elements of a contract. You have an offer, you have acceptance, and you have consideration. You said there was no dollar amount on that contract, so it wasn't a contract. So the board just reviewed the offer and acceptance, and you just fill in the blank later? Is that the case here?
There was, as I remember, there was no talk about an amount.
Okay. Senator Stone.
Yes, Mr. Magnus, going from memory, but I believe when that contract left your office, it had a dollar amount of $200,000 on it. Is that correct?
The final one that had the one that was presented to ALC had an amount of $207,000 on it.
But when it left your office before it was changed, it did not have $200,000?
$200,000, that is correct.
So you don't find that problematic that was changed? I mean, somebody made a unilateral decision to do that without your knowledge. That's not problematic to you?
Actually, it is not problematic, and because when that $200,000 was submitted, that was just an estimate. It was not, it's my understanding, it was not the final amount.
Well, my point is, that's Dr. Byers. I'm sorry, Dr. Byers. I called you Mr. Magnus. I apologize.
Thank you. That was a compliment.
Okay. Well, no worries. When that contract left, it had a $200,000 amount on it, and then when it came back, it had $207,000. How did the board arrive at that $200,000 before it was sent over? Because that must have been your expectations.
I'm sorry. Ask again.
All right. When the contract left out with the $200,000 amount on it, that must have been yours and the board's expectations. And then it came back with $207,000 on it. Is that still not problematic?
You're asking me? No, sir.
All right. Is it problematic to you that your attorney materially changed the contract without your knowledge?
It was changed. No, it was changed for good reason, and he can explain that. Okay. So I'll defer to him.
Thank you. Thank you, Mr. Chair.
Thank you, Senator Stone and Representative Bentley.
Thank you, Chairman. Over here, Mr. Byers.
Okay, thank you.
Thank you for being here today. I appreciate you being here to answer these questions. I want to back up just a little bit. I'm trying to understand the changes that were made by the board and things that were done. Were you, as a board member, made aware of the process that should have been taken originally, that you should have reached out to the Attorney General's office? Was that discussed by the board, that you should have reached out to the Attorney General's office before you hired your own attorney as a board?
Representative, if I may, all that is in litigation right now, and I'd rather not discuss that.
So you're not wanting to answer questions regarding what steps were taken by the board before you hired an attorney?
As I said, all that is in litigation. It's been ruled on by the circuit court that we were proper in doing it, but it's being appealed, and all that is in litigation. I'd rather not get into that.
Okay, thank you. Moving on to another question. So, you've stated that it is not concerning to you that this contract that was filled out for your attorney was not substantially changed. So is that your testimony, that was not concerning to you as a board member, that it was changed on substantially?
No, that is not a concern, because it was my thought that the original was just an estimate and not the final.
Okay, thank you, Chairman.
Representative Springer recognized.
Thank you, Mr. Chair. Good morning.
Good morning.
For the record, so that there can be some understanding, what was the basis for the board needing to hire outside counsel? Is that something that you can explain to us?
The original lawsuit was because of two changes in two laws. And it was Senate Bill 194, which changed that the secretary serves at the pleasure of the board and changed that to serve at the pleasure of the governor. The other one is Senate Bill 495, which states that the directors serve at the pleasure of the secretary. What those two laws did, and those were the only points that we had in contention with, okay? We support the PROTECT Act. And those were the only two things that we had contention with, because that took the authority away from the board and put it in the executive branch. It was our opinion that that was unconstitutional, violated Amendment 33. Amendment 33 gives authority to the board to oversee corrections. Those two laws, those two changes, changed that, and that's what we took exception to.
And that was the basis for you hiring counsel then?
Yes, to file, because we didn't feel like, since the Attorney General had come out like he did, in opposition to the board, that he could impartially represent us.
Thank you, Mr. Chair.
Co-Chair Senator Hammer. I'm sorry, I punched the wrong button. Senator Hester, are you in Dave Wallace's chair?
I am. Thank you. In the 3.5-hour ALC meeting, Representative Kavanaugh asked how many contracts the board has submitted since transformation 5 years ago. Your report did not give an answer to that. Do you know how many contracts you guys have worked through?
No, sir, I don't.
Okay, but it is something you've done many times.
We have approved contracts, yes. We've never submitted them in the process that was submitted to ALC.
Okay. Many of the speaker's questions from the 3.5-hour ALC meeting were not squarely answered. After completing your investigation, did you find that your attorney, Apton, made the sovereign immunity changes to the services contract?
Yes.
Thank you.
Senator Boyd, you're recognized.
Thank you, Mr. Chair. I want to change directions just a little bit to answer some unresolved ideas or issues for me. So, FOIA training. Does the Board of Corrections do initial or annual board training on Freedom of Information Act?
I'm not aware of it, no.
So you don't recall ever having a FOIA training anywhere along the line?
I don't recall.
Okay. So are you familiar with the definition of a meeting? What a meeting would be regarding the Board of Corrections?
Well, it's when board members get together.
How many board members constitutes the
Well, generally 2 or more.
2 or more. Okay, so 2 or more board members create a meeting, and that's what you testify here to today. Is that correct?
Yes, sir.
Okay. Next, who created the Board of Corrections? Did the legislature create the Board of Corrections, or did the Constitution create the Board of Corrections?
I believe the legislature created the Board of Corrections.
Okay, but it is your testimony that the Board of Corrections is a constitutional entity?
Yes.
Okay, thank you.
Senator Dismain. Oh, I'm sorry, Senator Dismain.
Thank you, Mr. Chairman, and I appreciate you coming today and then also working through the report that was provided. There were some things, though, in the report that, we specifically asked a question about. I'm not sure that we ever got a response. And really, before we got sidetracked with the changing of, the submission of the latest contract, we were trying to ask questions about the engagement and how it all came about. Because I think, in my mind, from what I'm beginning to even understand, even by reading the report, that there are really no procedures in place for the board, that you're not following procedures as a board, that essentially you allow the authority of 1 or 2 members to make the decisions for the board, which then takes away all of the checks and balances that should exist, for you to have the abilities and the functions that you have. So specifically, my questions would go back to the engagement letter and how that came about. Because I asked, how did we come about? How did we, hire the attorney that you have? and then I asked, well, where's the correspondence? And you know what I found in what was submitted back? No correspondence took place. I don't know if that means because it was all verbal. There was really no official board vote until after all the actions had taken place. So do y'all just not feel like you have to follow normal procedures? Have you been allowed to function without oversight for so long that we feel like that's just the normal course of business? I mean, my fear is, and I think what will prove itself out, is that what's happened with this contract, engagement letter, and whatever else with this attorney probably plays itself out in multiple places inside the Department of Correction, where there has been one or two members without the advisement or even knowledge of other members making significant decisions. So I'll go back. Just the basic question is, on the engagement letter and how that came about, can you walk me through the hiring of the attorney in what y'all believe to be the correct process?
Mm-hmm. As I remember, as I recall, when we got into a disagreement with the secretary, and we started taking action toward his dismissal. Actually, it was first of all put him on probation, and then dismissal. During that process, a board member, Lee, we discussed it, and he was the one who recommended Abton to be hired. It was done in open session, and it was done by the board.
Oh, I'm sorry. There you go. Go ahead, Senator.
Okay, well, what I would say, the little bit that I know about how Mr. Abton was hired was a lot more detailed even in your previous testimony. It wasn't that Mr. Watson walked into the room in a board meeting in an open discussion, y'all decided to hire Mr. Abton. It was that Mr. Magnus, I guess, empowered Mr. Watson to go out and find an attorney. See, this is where the problem is, right? I'm looking at two board members. I have one going this way and one going this way. One shaking their head no and one shaking their head yes. And let me tell you why. It's because you're not having real board meetings. And members don't understand what's happening on the board, and decisions are being unilaterally made. That is the problem. And so just to back it up, my understanding was that Mr. Magnus asked Mr. Watson to make a recommendation. Mr. Watson brings the recommendation to the board, and somehow it's agreed upon that no one else needs to be vetted. There needs to be no other discussion. The board does some kind of, makes some kind of decision to enter into an engagement with Mr. Abton. Okay, that's the way that I understand it. But what I've tried to ask is, well, show me the discussion of how we empowered Mr. Watson. Well, it doesn't exist. Show me the decision how we vetted 5 different attorneys or whatever we came to the conclusion to hire Mr. Abton. It doesn't exist. Talk to me about the conversations that were had between the attorney and Mr. Watson. They don't exist. Because it's all done outside of the light of what the people are able to see, which they should be able to see. So to get back to the question, is this the normal way that y'all make decisions and enter into contracts? Because set aside your constitutional thought of independence or whatever you may have, and maybe it conflicts with mine, you still have to follow procedures. Was this the normal procedures where we just empowered a board member through a conversation, by the way, that's not recorded and noted in any kind of minutes? There was no vote of the board that it should be Mr. Watson that was empowered. Is this just the normal way that we do things?
In this case, I would say yes.
You're good. Go ahead, Senator. Please.
Do you think that that's appropriate?
Well,
do you think it's appropriate because in your mind, what made you feel as though that this was the instance in which we bypass all of our procedures that should be in place?
Your
what
question,
rose to the level that we can have conversations amongst board members out of the public eye that are unrecorded and unknown?
I don't know that they were out of the public eye.
Well, they absolutely were, because I've got documentation here and I have nothing.
I was not involved in that, so you may have to answer some. I mean, you may have to ask some other players. I remember the board meeting where Mr. Lee recommended that we hire Abton.
Where was the board meeting that we even considered hiring an attorney? Did that exist?
Where was the board
Did we
meeting?
have a board meeting that said, hey, I think we need to have an attorney? Did that happen?
That was the board meeting.
No, sir. There was a board meeting in which you agreed to hire Abton. There was not a board meeting in which you agreed to hire an attorney, period. Was there?
It was my recollection that all that was handled at the same time.
Do you feel as though that this, even the engagement letters, back up to that, was handled appropriately?
I do.
Thank you.
Senator Hammer.
Thank you, Mr. Chair. Dr. Byers, why would the board, because my understanding, the way the conversation is playing out this morning, it's almost as though the original contract was an open-ended contract with no dollar amount established in it. Is that correct?
Yes, sir.
Why would the board initiate a contract with an open-ended, almost appearance of write your own check balance?
I can't answer that, Senator.
Was that discussed in the board meeting?
No. You mean the dollar amount?
Well, yes, a dollar amount.
No, not that I recall.
So y'all have come to ALC and asked for an original amount with an adjusted amount on it. But what if the amount, how would you have known what the total amount could have been, given the fact that it's in litigation and that could run up much higher than the numbers that have been presented to us? Was that discussed any in the board meeting?
No. As I recall, the fees of the attorney were discussed, the dollar amounts, but not a total dollar amount. How much per hour for him, how much for his assistants, that type of thing was discussed, but not the total dollar amount. That was not brought up until the documents were submitted to ALC.
So it could have ran higher than what it was because all y'all discussed was just the hourly rate without any. Do you, in hindsight, looking back, and I understand that your statement is that the board has never dealt with a situation such as this, was there any expression of concern by any of the board members that y'all were getting into something that could run into significant amount of money before it was even approved by ALC? Was that any part of the discussion in the board meeting?
No, sir. No, sir.
Okay, I'll yield for now. Thank you, Mr. Chair.
Thanks, Senator Hammer. So if a dollar amount wasn't discussed, how did the 200,000, how did that get in?
As I remember, Chad, the CFO, said that it had to be entered into the document that was submitted to ALC, and that's when he actually contacted Lee, our board member. He said it needed to get it from Abton. Lee said you need to contact Abton directly, and Chad contacted him directly and got that dollar figure and put in there.
Okay, and so how did the extra $7,000?
$7,000. You'll need to ask Abton about that. As I recall on the document, the $200,000 was just for attorney fees. $7,000 was for like research, copying, the office type fees that might come into play.
So did Mr. Metazadigan tell the board that he made the changes to the contract?
No.
Okay, and Representative Beatty, you're recognized.
Thank you, Mr. Chair. Dr. Byers, I'm to your right. Yes, sir.
Okay.
One, I want to thank you for coming today, and I've always found your testimony to be honest and truthful, and I think you do that to the best of your ability. My question is, based on some of the testimony you gave earlier to this committee, where you stated that you and the board supported the PROTECT Act. As I recall from testimony while the bill was being heard, that you specifically testified against the bill, as well as Chairman Magnus, in opposition to the bill, spoke against the bill. And I think the statement that you made said that it diminished the power of the board. Is that a correct statement?
Can I go back to your first statement about us testifying against the PROTECT Act?
Yes.
We did not voice our opposition to the PROTECT Act. As a matter of fact, if you go back and look at my testimony on the video, you'll see that I supported the PROTECT Act and applauded the legislature and Senator Gilmore and other sponsors of the bill for stepping up and putting the PROTECT Act before the people, before the legislature. I did not testify against the PROTECT Act. The only thing that I testified against were those two words in the PROTECT Act. The one that was scratched that said Board of Correction, that he reported to the Board of Correction and put in governor. That was the only thing that I testified against.
So, follow up. You did speak against the act, because that's in the act. I mean, you signed up and spoke against the bill.
Well, okay. If that's your interpretation, then that's correct.
Well, I know when we speak, you sign up to speak in support, or you sign up to speak against. So that's pretty self-explanatory. And you signed up to speak against. So I'm not going to debate that with you. But my question is, the comment about diminishing the power of the board, would you feel that that's a truthful statement?
Yes.
So what we basically have here is just a battle over power and retaining that power at the board level, or if that power is obtained at the executive level or the legislative level, when what we ought to be focused on is taking care of Arkansans and taking care of the Department of Corrections. So my question to you is, how can you look at the voters and Arkansas citizens and justify the expense and the cost that have been ran up? And I'm not talking about the $207,000 in legal fees. I'm talking about the drain, the tie-up in our court system, the expense at the Attorney General's office to look into this, the countless hours to provide FOIA information, all of the additional costs that have gone into this over a 5-letter word, power. How can you justify that?
That's not something we wanted, sir. We didn't want all this. We didn't want all this. I talked to the sponsor of the bill. I talked to somebody from the governor's office before the bill ever went before the committee and said, would you consider changing this?
And Representative Beatty and Mr. Byers, if we can, let's get the train back on the track. A question in relation to the issue that we're dealing with today.
Okay.
Anything else, Representative Beatty?
No, I just want him to clarify his comment that he was in support of the PROTECT Act.
Thank you, Mr. Beatty. Representative Eves, you're recognized.
Thank you, Mr. Chairman. I'm trying to go back to when we had the ALC Review Committee a few weeks ago, and at a meeting trying to decipher all this, it appears that you had submitted a contract or a request for us to review the contract that had a procurement method of request for qualifications, which we see often. But then when we got into the meeting, there was another contract that was in the portal that was submitted that had the procurement method changed to two things, one of them being emergency and one of them being exempt from law. Why was it changed from request for qualifications to these other two items? And in that procurement method, it looks like perhaps the services contract was printed out and then the words exempt from law were typed in next to the word emergency. Can you help me understand that?
No, no, sir, I can't. That would be a question you'd have to ask Apton. I don't know.
Is he here?
Yes, sir.
Can I ask him that question?
Yes, sir.
And Representative Eves, we'll have him on the agenda here shortly.
Okay.
Thank you.
One more question.
Yes, sir. Please go ahead.
Well, I'll wait till he comes up. Thank you.
Okay. Thank you, Representative Eves. And Senator Stone, you're recognized.
Yes, Dr. Byers, earlier you said that when two members got together, that constituted a meeting. When you have these two-member meetings, is the press notified?
Yes, sir.
Y'all take minutes of those two-member meetings?
That's
a yes or no question. Do you
As
take
far,
meetings?
as far as I know, yes, sir. As far as I know.
As far as you know? And how many members does it take to constitute a quorum according to your bylaws of your
I believe it's a majority. I believe it's 4. I don't know for sure.
So if it takes 4 to have a quorum, how are you having a two-member meeting?
I'm sorry?
If it takes 4 members to have a quorum, how are you having a two-member meeting and notifying the press and be able to get any business done?
A two-member meeting?
Well, that's what you said, that when 2 members got together, that constituted a meeting.
Sir, I can't answer that question. I know that when we cannot discuss board business with other members.
That is correct. So are you notifying the press when two members get together? Because you said earlier that 2 members constituted a meeting when they spoke.
I don't know. I don't know the answer to that.
Thank you, Mr. Chair.
Thank you, Senator Stone. And Mr. Byers, does the committee have copies of those minutes? Have they been provided to the committee?
I'm sorry?
Has the committee been provided the minutes of those 2 meetings that we're discussing?
I believe.
You stated minutes had been taken. Have they been provided to the committee? If not, can you provide those to the committee if you would, please? And so next we have Senator Gilmore.
Thank you, Mr. Chair. Thank you, Dr. Byers. So looking at your investigation, it's a bit troubling to me that throughout this document, in response to that hearing, there's a lot of things in here that says Dr. Byers' analysis will explain. Dr. Byers' analysis will explain. This is the document following the review committee hearing of ALC in response to our questions. You're familiar with the document I'm referring to?
I'm familiar that there was a
you
document.
sent us a document. I'll just clarify. You sent us a document in response to our questions with responses.
Okay.
You familiar with that?
I did not send that document. It was sent. I believe it was sent by Wade Hodge, the counselor for the Department of Correction. I believe that he was the one who got those answers together, and some of them were that my document would answer those questions.
Okay, but you were the investigator assigned to investigate this contract, were you not?
I was the one who provided the analysis, yes, sir.
Well, I think the words used were specifically there would be an investigation and you would do it sitting at that table with Chairman Magnus. Do you remember that?
Yes, sir.
Okay, so you were the investigator assigned to it. What board vote happened to ratify you as the investigator?
There was none.
Okay, so do you think it was the proper way to handle that?
Yes, sir.
You do?
Yes, sir.
So you don't think there needed to be any sort of board vote to say, hey, look, folks, we've got a problem. This was identified in the ALC review committee. We need to have a formal investigation on this. I mean, your own testimony in the last board meeting last week, you said, I'm not some investigator, but I did the best I could. Do you remember saying those words?
That's correct, yes, sir.
Okay. So do you think that it needed to be treated with any sort of more formal process? I mean, at least have a vote of the board?
No, sir.
Can you elaborate as to why?
Because Chairman Magnus can appoint different members to perform different tasks, and I think he has that prerogative.
Unilaterally, he can appoint without a vote or a discussion with the board. That's your testimony.
Yes, sir.
Okay, how often does that take place?
It takes place periodically when things come up. He appoints. We're different. Different board members are liaisons for different departments for the within the Department of Correction.
Mm-hmm.
I'm the agricultural liaison. He appointed me to that.
So does that, just for clarity's sake, because I didn't know that, does that have to do with overseeing, farmlands?
No.
Related? So what does that have to do
Not
with?
overseeing, just knowing what's going on. If something's happening in the farm, then they let me know if they're selling cattle or, whatever. It's just a courtesy to let somebody on the board know what's going on.
So that y'all are informed and therefore, I guess,
That's
can relay
correct.
that information to the board. Okay? So your testimony a second ago to Senator Stone's question was there is at times, and you said this, where 2 members would constitute a meeting, correct? 2 members
Correct.
constitute a meeting.
That's
what
my
you said.
understanding, yes.
How many times have members gotten together to have a meeting?
We have meetings once a month,
Okay.
normally.
Outside of your normal board meeting setting, how many times does that happen?
That we get together?
Mm-hmm.
Well, we got together out here. I mean, there are times we come in contact with each other.
But there's no formal
No.
formal meetings that you have
No,
to discuss various
No.
items related to the board?
no,
Okay. Nothing related to, say, other contracts that y'all review or look at?
no.
Never. Never. Your answer is never has that happened.
Not to my knowledge.
Okay. So circling back on some other line of testimony related to contracts. So your testimony was that y'all have never gone through this process before, the procurement process.
That's correct.
And as we identified, it's a cumbersome process to be sure. And the reason for that is to provide protection to Arkansans, the taxpayers, if you will. I think you would be understanding of that, that we have to have a process to make sure that every I is dotted, every T is crossed.
Yes, sir.
So that being said, clearly the Department of Corrections and the board go through that contract process all of the time. Would you agree with that?
We do.
Okay, but you testified a second ago that this is the first time you've ever gone through this process.
No. We go through, we approve contracts.
Uh-huh.
We've approved multiple contracts. We've never gone through this process of filling out these forms, SRV. We've never gone through that process to submit it to the ALC for the procurement process. We've never done that, to my knowledge.
Okay. That's interesting because that's how any contract, because that's the standard services agreement.
It's normally done by staff.
Okay, so you're saying the board has never done this. Okay. So going back to your investigative report, I mean, do you think that this investigation was all encompassing? Do you
No.
think? Okay. What do you think was missing?
One thing that was missing that I know of was I had written Mr. Armstrong an email asking about the process on his side, on the procurement side, and he sent back an email saying that a lot of his staff was on spring break. This has been several weeks ago, and that he would get back with me after spring break, and he didn't, and the document was completed, but he never got back with me, so I never followed up on it. So that's one thing that was missing.
Okay. So when compiling this report, I know you said Mr. Hodge, I believe, helped, I guess, compile some of this, your investigative report?
No, sir. I
thought
talked to
that's
I talked to Mr. Hodge, but I don't remember him helping me.
Well, I thought you said that the answers that where it says Mr. Byers' analysis will explain were
Yes.
his.
Those were his, but those were not part of my report. Those questions were asked at the ALC meeting, and
But
Wade.
it was sent to us as part of the report.
I'm sorry.
It was sent to us as part of the report.
Okay. Well, it was not. Maybe it was, but it was not. I did not do that part.
Okay.
Mr. Hodge did.
Okay. Who else helped compile this report?
Well, I got information from all the emails, all the phone conversations. I got information from Chad, from well, I can't remember everyone. I did send that. That was part of the report that I sent. Who all I talked to? I talked to Chad. I talked to people in his office, procurement people in his office. I talked to Lee I talked to.
I'm sorry, you talked to who?
Lee.
Lee, and that's Mr. Watson, fellow board member?
Mr. Watson, yes, sir.
Okay.
Asking about his communication with Abton. I talked to Abton. Again, there's a list of the people I visited with, but I don't recall all of them.
Okay.
And Senator Gilmore, your meter's about ran out. Can I put you
No,
back
understandable.
in the queue?
I yield, and we'll get back in the queue. Thank you, Chair.
Thank you, Senator Gilmore. And Senator Hester.
Thank you over here. Yes, sir. So, I asked a question earlier about, because Representative Kavanaugh asked it, how many contracts do you think you guys have done in the 5 years since transformation? You didn't give an answer then. I ask again now. You didn't give an answer. It's not in the report. Through Senator Disming's questioning, I think what we're getting at is, has the board approved 10 contracts in 5 years, 5,000 contracts in 5 years? What is the process? Is there a process? And if you've done many of these, it'd be great to know, then why wasn't the process followed? So I say all that to say, can you give me an idea of how many contracts the board has approved? You may not have it right now, but I would appreciate if you would get that to me.
I don't. We approve very few big contracts like the medical contract. We approve quite a few contracts like parole. The parole division they have to have leases and that type of thing. We approve those, and those are fairly frequent.
So you approve 10 contracts a month, 5?
No, not
100?
that many. Not that many. Probably one or two.
One or two a month. Okay. Over 5 years. That's good. In your memo, you found that Abton submitted the contract to Benny Magnus, Lee Watson, and Sherry Gray. Then Sherry signed Benny's name because he was traveling on the road and sent it to Chad Brown, who forwarded it to BLR.
Correct.
Is that correct? In the same memo, you also found that nobody reviewed the document after the changes were made.
Correct. Well, Mr. Magnus said that he did look it over, but not an extensive review.
So the board or Mr. Magnus didn't have an understanding of why sovereign immunity was waived. And there may be a good explanation. Maybe we'll hear that later today, but didn't have an understanding. Okay.
Correct.
That's all. Thank you.
Thank you, Senator Hester. And Senator Dotson, you're recognized.
Thank you, Mr. Chair. Dr. Byers, thanks for coming in for your testimony today. I must say, as I've listened to the hours of testimony, I wasn't able to make the last meeting, but I did listen to it, and your testimony this morning, I just keep coming up with more and more questions of how we got to this place. This is just a royal mess. This is definitely not the way that procedures should be handled. And, just a couple of things. I guess, just based off your testimony, you said the chair appoints a board member, just any board member, periodically to investigate different things or over different things. How is the rest of the board notified when the chairman makes some sort of appointment like that?
Generally, he makes it during the board meeting.
Okay.
He'll make the appointments during the board meeting.
So was there a board meeting that notified the rest of the board that the chairman was appointing you to investigate this particular matter?
No, that was done here at this table. Well, I'll let him testify as to how it went down.
And then earlier you had said that that I guess when you hired the attorney, it was done in the same meeting when you made the decision to hire an attorney. You picked that attorney in that same meeting. Was that on the December 8th when you issued the engagement letter?
That's what I recall. I'd have to look at all that to make sure that those dates.
So I guess what I find kind of troubling about that is you just randomly picked an attorney without qualification or knowledge of any of the expertise of that attorney.
Excuse me.
Based off the recommendation of one board member?
I think that randomly is not a good, maybe not a good term. I have a lot of confidence in Lee Watson. He's an attorney himself. I have a lot of confidence in what he thinks. So if he recommended it, then I would have confidence in that.
So since he's an attorney, he made the recommendation that the attorney that he was recommending had the expertise to handle this particular issue and take it all the way through, but no idea on the cost associated with it ahead of time or any contractual obligations. The board just voted to issue a letter of engagement blindly without any information.
Well, with not a total cost, no. We did, as I remember, we had what the hourly fees would be.
But you had no estimated total cost?
No.
Okay. And then you also said that you had never gone through this, or I guess the board members hadn't ever filled out the forms and gone through the procurement process and things like that. Why didn't you engage staff that were procurement experts that you have, working for you to do these sorts of things before you entered into an engagement letter with an attorney and what you've said is a contractual agreement? Obviously, it wasn't a contract, and that wasn't entered into until much later, asking it for us to ratify that. But why didn't you consult with your staff that does this normally all the time?
We did. We did consult with staff. Staff were the ones who originally submitted the skeleton version of these documents, and then they were the ones who ended up with the documents before they were loaded up into the portal.
But you didn't engage with the staff before you issued a letter of engagement in that initial board meeting.
I'm sorry?
You said you consulted with staff, but it was much after the fact, not on December 8th when you initially started this whole process and chose the attorney and entered a letter of engagement.
That's correct.
Okay.
As I remember.
But you don't know why you would rush that end of things, why the board didn't take a consultation with staff before they entered into an agreement.
And at which time, sir? I'm sorry.
Back in December 8th, when you initially started this process.
No, we did not consult with staff.
Why didn't you consult with staff at that time?
Because
I guess the question.
I don't. It was a board decision. It was a board decision. The board was hiring the attorney. We weren't hiring an attorney for the staff. As a matter of fact, at that time, Mr. Porphyry was going to be a defendant, so we did not consult with them.
Okay. Thank you, Mr. Chair.
Thank you, Senator Dotson. Representative Beatty, you're recognized.
Thank you, Mr. Chairman. Again, Dr. Byers, I'm to your right. Over here.
Oh, I'm sorry.
Yes, sir. Again, I want to commend you on the report and your investigation that you provided. 10 pages of transcript for minutes and timeline on each day of emails when they were received and maybe the content of those emails. So we have 10 pages of a timeline and transcript, and your summary assessment, basically 9 lines that you end with, I found no evidence of fraud or legal misconduct in this matter. My question is, one, what qualifications? Are you a fraud examiner? Are you legally trained to understand what legal misconduct could be? What training do you have to make that decision?
No, sir, I do not.
Secondly, again, I applaud you for attempting to do this. My concern is, and was this ever addressed, that maybe knowing the level of scrutiny that this report was going to receive from this committee and from the legislature, was there ever a discussion of maybe having an independent party, third party, perform this review? Because it seems like it would give more credibility and protection to the board to have a third party look into this. Were there ever any discussions on that?
No, sir.
And then secondly, on your report, your recommendation to establish a protocol for development and submission of procurement documents. Has that been completed as of yet?
No, sir.
When will that be done?
I can't give you a timeline, but it will be done in the near future.
Thank you, sir.
And Senator Hammer.
Dr. Byers, a lot of the testimony today seems like you were leaning heavily on your internal counsel that you have, or either Chad Brown or Mr. Hodges. During that conversation or during the discussion of the contract with the attorney that was hired, was the board ever cautioned that, look, this is not the right way to handle this by staff? Did they ever alert you that this could become the potential that it has become?
No, sir.
Did that ever cause you to, anywhere along the way, did the board ever have concern that the advice that you were receiving that led to the decision you made to hire the attorney in question caused any board members to want to hit the pause button?
Not that I recall, no.
Now that we are where we are, hindsight 2020, what would you have to say about that?
I think there are a lot of things we could have done. For one thing, we probably should never have presented that document to ALC.
Is that, how much of this do you think has contributed to the fact of a lack of understanding about the procurement process? And do you feel that as a board, you did not receive good information about the procurement process that has taken down the road that we are on?
Yes, sir. No, sir. We did not. The only thing that we were told during the process is we need to get these forms filled out and we need to get them uploaded.
And what created that sense of urgency?
Well, because we only had 24 hours to the deadline for it to get on the agenda.
Okay. All right. Thank you.
Thank you, Senator Hammer. And so to clarify, is it a lot of things that you could have done different or should have done different?
Should have, and could have.
Yeah, thank you. Representative Gazaway, you're recognized.
Thank you, Mr. Chairman. Thank you, Mr. Byers, for being here today. I want to follow up on some of the questions that Senator Dismang asked, specifically about the hiring of Mr. Abton. It sounds like to me, well, actually, let me go back. Let's think about how this whole thing started. There was a press conference held by the governor, as you're well aware, in November of 2023. In fact, the date that I have specifically, that press conference was held November the 17th of 2023, involving issues about adding additional beds in our prison system. Is that right?
Yes, sir.
And you said, and this was what I wrote, and I think it's an exact quote, that we didn't want this. That basically this whole thing that's happened and the way that this is unfolded is not what you wanted.
Correct.
Now, the press conference was held November 17th. The next week was the week of Thanksgiving. Can you point to anything that you did between November 17th, when that press conference was held, and December 8th, when you hired Abton as your attorney to sue the state, that you did in a spirit of cooperation to try to resolve this issue?
No, sir.
And so, you know, when you say that we didn't want this, I mean, I just find it completely incredulous that you sit down there and say, we didn't want this, when there was a press conference that was held on November 17th pointing out the displeasure with the fact that the board had not voted to add some additional beds. And in 3 weeks, you hired an attorney to sue the state. The next week, essentially, you suspended the Board of Corrections chair, or the secretary, Secretary Porphyry, and filed a lawsuit against the state. That is not a spirit of cooperation. Would you agree?
Senator, at that time we felt like that there was not a spirit of cooperation on either side.
Well, in order for there to be cooperation, it takes two parties, and you would be a party to that as the board, right?
That is correct.
And you could have come to the table with any number of solutions to this issue, once again, in a spirit of cooperation to try to resolve the obvious conflict that existed between the governor's office, the attorney general's office, the legislature, the board, and sat down and said, let's reason together and try to resolve this issue. But you didn't do that, did you?
I did not. I don't know if there were any other, you may ask some others, I don't know whether there were any other outreaches made.
The board as a whole did not do that.
That is correct.
And on December the 8th, you hired Abton as your attorney to sue the state. Is that correct?
That is correct.
All right. So on the day that you hire, on the December 8th meeting that you had to hire Abton, and this goes back to Senator Dismang's questions, my understanding of your testimony is that there were not two meetings. There wasn't a meeting to decide whether to hire an attorney.
Correct.
It was in the same meeting that you decided to hire an attorney that you also decided to hire Abton. Is that right?
I believe that's correct.
Okay. So you said earlier that the board, like many other boards and divisions of state government, are subject to FOIA, right?
Correct.
Were there discussions between you and other board members about hiring Abton prior to the December 8th meeting?
Not that I'm aware of.
And this is what's just unbelievable to me. I mean, it's either just a complete lack of sophistication and proper way of doing things, or either there had to be conversations. I don't see how one of the two has to be true. Maybe both are true. But I cannot believe that there was no discussion prior to the December 8th meeting of hiring an attorney to sue the state, and that attorney being Abton, before you held this meeting to contract with counsel. You're saying there was no discussion about that?
Not that I'm aware of.
Okay. How did you guys decide on Abton then? I mean, he was the only attorney that was brought to the meeting. Is that right?
He was recommended by Lee.
Okay. And so, to be clear, there was no separate meeting to decide to hire an attorney. At the meeting where you decided to hire an attorney, there was only one attorney there. Did you ever send out a request for qualifications?
No, sir.
Okay. No solicitations to the public for attorneys who would be interested in representing the Board of Corrections in this matter to present their experience and their qualifications? Didn't do any type of public solicitation?
No, sir.
No, prior to this meeting, no evaluation of what the attorney would charge, And again, we're talking about billing the Arkansas taxpayer here to decide what rate would be appropriate and to have other attorneys submit proposals to you who might do it cheaper than Mr. Abton. There was none of that.
Not to my knowledge.
So Mr. Abton shows up to the meeting on December 8th, and he's recommended by Mr. Watson to be retained by the board. Is that right?
That's as I recall, yes, sir.
Okay. And so you guys, in that meeting, without talking to any other attorneys, without knowing what any other attorneys would charge the Arkansas taxpayer to do this job, without having submitted any public requests for qualifications or to evaluating other attorneys' experience in handling matters like this, you just hire Abton that day. Is that right?
That is correct, yes, sir.
Okay. And you do that not through a formal contract, but I take it there was some type of engagement letter that was given to you guys that day?
Yes, sir.
Okay. So no formal contract was signed, and you go through no typical procurement process, and we ultimately get to March, and then you submit this contract through the state, through the appropriate channels. Is that kind of a correct timeline?
Yes, sir.
Okay. We'll get to the part about the altering of the contract soon enough, but I just have to say that's just a complete lack of transparency, complete lack of following any type of proper protocol to I think hire an attorney, and it's just shocking to me, quite honestly. But again, I appreciate you being here today. I have a lot more questions, but I don't want to monopolize the time. So, Mr. Chairman, I'll.
Thank you, Representative Gasway. And colleagues, we're going to take what's in the queue now, and then we're going to transition to our next witness, and we reserve the right to recall Mr. Byers to the table. So with that being said, Senator Dismang, you're recognized.
Thank you, Mr. Chairman. And just to follow up, because I want to make sure we have full understanding, and I've tried to find the board minutes for December 8th. I thought they were originally included, but they weren't. We'll get to take a look at those and see how, I respect the fact that it appears you had two board members that at least had questions and willing to vote no on December 8th in regards. And so your testimony is that the first time that you knew that you were going to hire an attorney was at the December 8th board meeting.
That is my recollection, yes, sir.
Okay. All right. And then, so how did you feel about that in the meeting? So this is, kind of out of the blue. You're given one shot, one person to consider. Did you think you thought that was appropriate?
Yes, sir.
Why would you think that would be appropriate?
Because it was recommended he was recommended by Lee, and he had the expertise that Lee said that he had the expertise that we were looking for.
So but December 8th was the first time that you were made aware that Mr. Watson was in charge of hiring an attorney.
Well, I don't know if he was in charge, but he was the one that recommended, yes.
So Mr. Watson, at the direction of the chairman, was charged with hiring or finding an attorney and bringing to you without any other board knowledge that you're in the process of hiring an attorney.
Well, I don't know that.
Well, but without your knowledge.
You may need to ask the chairman or Mr. Watson.
So prior to that. Okay. And so one thing I do want to go back and just make sure you're aware of what you voted on, because I believe that this is a very loosely ran board, especially when it comes to meetings, because I can read the minutes and tell that it is. Right? There's not a lot of formality that's happening. One member may interrupt another. There's lots of laughter, lots of good times. We joke around in here too, and that's perfectly fine. But we try to follow a process. But probably the most important thing that happened would be on page 3 of what you provided to us, and it's Mr. Watson, and because he's the actual one that, by the way, I don't know who Mr. Watson is, so I apologize. I've never seen him. There we go. I figured from the facial expressions that could be you, but I wasn't sure. But he's the one that actually makes the motion that the board reaffirm its contract with Hall Booth Law Firm, that we pay the bill upon review, submitted by the firm, and this is ongoing representation, so we understand there may be additional legal fees. So then he gets a second, and then y'all vote, and then there's lots of joking, or you don't vote yet, there's some discussion, there's some joking that goes back and forth. there. But one of the things that I just want to point back to, the only thing that staff was given the authority to do, the only thing that you gave authority to do in your vote was reaffirm its contract that it had, which that was substantially changed by almost everyone's opinion. I think even your own, that was substantially changed when it was uploaded. Did you vote to do anything beyond that besides reaffirm the contract? Did you believe you were voting to do anything else?
As I recall, no.
Because there was another board member that had concerns, I believe. Again, it's hard to kind of tell, but Mr. Broomfield, I'm not sure who that is either. But it looks like he had some reservations in a deal. And reading between the lines, I can only think that that those weren't shared amongst some of the other members. But his quote in those meetings were, "Won't take a minute. I don't want to do whatever takes place on I do want whatever takes place on this board to be done and in order. I don't want to break any laws." And then the board laughs. So the board laughs when Mr. Broomfield says he doesn't want to break any laws. "I want it done right." So done right would have required y'all to actually have a vote on a contract that you knew you were voting on. So if I'm going through the process, you have an engagement letter, y'all agree to that at some point. Not everyone. You have two board members that vote no. And then it comes before y'all. You figured out that you haven't followed the process. Mr. Broomfield, others wants it done correctly, the best I can tell. So then we bring it before the board. There's a vote. And we say we're going to just reaffirm the contract. In the meantime, the contract gets changed as it's resubmitted, and not a single person reviewed it. And that's what the testimony is. Is that correct? Not a single member of the board that made a vote to simply reaffirm a contract that I would argue they didn't have the authority to make, but you voted to reaffirm a contract, didn't review to notate that, or note that there were some changes to that contract. So you weren't even, you were asked, and then someone, again, I guess I would ask, what do you do about that? Because when I read what you say here, it's like, no harm, no foul, no big deal. That's the way that it reads. If you go to the conclusion, I think that's about the only way that we can interpret it.
Senator, I don't know how to answer your question.
You know what? You are at a disadvantage because every other person is going to have the opportunity to hear these questions before they come up here today. So I kind of feel sorry for you in that fact.
Thank you.
And sympathize. And because they're all going to be prepped and ready to go, right? I mean, but what it amounts to me, and I guess you guys just don't have processes in place. And I think it's by design, and I think that's what we're going to find out here. Thank you.
Senator Hammer.
The lack of processes in place defaults back to the fact that you take a lot of your advice and a lot of your direction from the staff that gives you direction as far as how to handle things. Is that a fair statement?
That's correct.
So the decisions that you made as a board, absent of having some one-on-one meetings with other members, falls back on the fact that you do what you do, you decide what you decide on the basis of the advice that's given you by the staff, that if you look at them and say, are we keeping it between the ditches? Are we staying within the laws? And you get the answer from the staff, yes. That includes procurement, handling of contracts, everything else. Is that a fair statement?
That's correct. Yes, sir.
So let me ask you, because I want to make sure that you're answering for yourself, because you're the one sitting there under oath and you answer for yourself. As far as any meetings where there were two board members, which in this case, that would be you. In the case where there were any kind of meetings where anything was discussed that the board was going to take action on, you yourself were not party to that. Is that your testimony?
That is correct.
But that is correct. That doesn't mean other board members maybe didn't do that. But as far as Dr. Byers, you were not party to those kind of meetings where two board members, you and one other, were discussing matters that were going to be voted on by the board.
That's correct.
Okay, thank you, Mr. Chair.
I'm sorry, Senator Hester.
Thank you, Mr. Byers. I think we've covered this ground a little bit, but it is the board's position that you did not have to seek the AG's approval to hire outside counsel because you You just didn't follow the rules because you didn't think he would give you a favorable ruling.
As I remember, we didn't seek that because we felt like that we had the authority to hire an attorney without his approval.
Okay, and so you do not, okay, so that answers my question. You do not believe you had to seek the Attorney General's opinion?
That is correct.
Or approval, okay. Thank you. And then I wish I would have done this at the end of my last questions. It's very difficult to be here today, to be doing what you're doing. I appreciate Senator Dismay acknowledging that. Is there any question you wish you'd ask? Is there anything you think you'd like to? Is there any question you wish someone would ask, or is there anything you'd like to be say, just in fairness?
The only question I would like to ask is, would you like to be excused?
Thank you, Senator Hester. And Representative Tara Shepherd.
Thank you, Mr. Chair. And thank you, Dr. Byers, for being here today. I am an auditor with the American Correctional Association. Are you familiar with the American Correctional?
I am.
Thank you. With that, the Arkansas Department of Corrections is accredited. Is that correct?
All of our institutions, including our central office and training academy, are accredited by the Arkansas Correctional Association.
Meaning that they are following certain standards in regards to how they are governing themselves.
Yes, ma'am.
The Arkansas Parole Board, are they accredited?
I believe they are.
Meaning they are following certain standards in how they are governing themselves.
Yes, ma'am.
It is troubling, the testimony that I have listened to this morning. So the question that I have is, are there standards clearly established for how the Arkansas Department of Corrections, the Board of Corrections, governs themselves to include entering into contracts?
I don't know if there are written rules governing the Board of Correction. We just know that we're an oversight board, and the departments, the divisions, come to the board.
Yes.
For approval on what they're doing.
Okay. So that takes me down another road. So it appears that some of the inconsistencies that we've heard here today is because there aren't clearly established guidelines for how the board governs itself.
There may not be.
Thank you.
And Representative Lundstrom, you're recognized.
Thank you. Following on the things that Representative Shepherd brought up, as a board, do you, when you begin your meetings, do you take roll?
I'm sorry?
When you begin your meetings, do you take roll?
There are 7 of us. Yet, I don't know whether a roll call is made or not, but we know who's there and who's
Somebody
not.
documents whose
Yes,
presence at
correct.
those meetings.
Yes.
And that shows up in your board minutes, correct?
It's supposed. I believe it does.
Well, aren't you secretary of the board, sir?
Yes, ma'am, I am.
As secretary of the board, aren't you responsible for board minutes and making sure that that's documented?
Yes, ma'am. I suppose they are, but it's yes, ma'am.
So I've been asking, where are the board minutes for the approvals of chair appointments, hiring, procurement, engagement letters, votes, prison issues? Where are the board minutes that we can take a look at this?
The board minutes are in the board office in Pine Bluff.
Wouldn't you think that would be useful to have here today or to present to all of us so that we could know what's going on? As secretary, don't you have copies of that?
No, ma'am, I don't. They're kept in the board office in Pine Bluff.
Well, I'm glad they're secure in Pine Bluff because they're not doing you a lot of good here, sir. Before you were agreed to pay this attorney $200,000, did the board meet and discuss what they thought they could afford and where this money was coming from?
No, ma'am. And no, the only thing that was discussed was the hourly rate, or the only thing that was presented was the hourly rate.
Where's this $200,000 going to come from?
It was originally, there was something that came from Little Rock, from procurement down to Chad Brown. Chad Brown, they said, we need some type of figure here, an estimate on a figure. Chad Brown contacted Lee Watson. Lee Watson told Chad he should contact Abton directly. He did, and that was what was supplied. The 200,000, as I understand it, was an estimate. The 207 was a corrected amount. It was an actual amount.
Okay, thank you. So in your budget, you have 200,000 sitting around to pay for attorneys?
No, ma'am.
So it's going to come from the taxpayers?
Yes, ma'am.
Okay, thank you.
Representative Richmond, you're recognized.
Thank you, Mr. Chair. I'm over here on your right front, board, directly to your front, right here.
Thank you.
Appreciate you being here, Doctor. Your testimony so far has been that there was no previous meetings or anything to discuss the hiring of a lawyer. So can you tell me how Mr. Abdon was aware to attend this meeting?
No, sir.
So you have no idea how he just showed up? Those lawyers, they're rascals, aren't they? They know where money is. They can always find a government check someplace. Was the procurement discussion that you just mentioned a second ago with Representative Lundstrom, was that before the December 8th meeting or after the December 8th meeting where this guy was hired?
I don't recall.
You don't recall? You just recall that there was a procurement meetings. You don't remember when it was?
All right. When
she was talking about the funding, the money that was going to be used, the $200,000 or whatever amount that you thought you might need. Was there a discussion before the December 8th meeting when this gentleman was hired about accessing money to pay for a lawyer? Was that before the December 8th meeting, or did that happen after the December 8th meeting?
I don't recall.
Okay. All right. Thank you.
And Senator Stone, you're recognized.
Dr. Byers, is a board member Alonzo Giles here today?
I don't know, sir.
Well,
I haven't seen him.
Okay, I believe that in America, you're innocent until proven guilty. But just by the sheer weight of lawsuits and plaintiffs that have filed and made accusations against board member Giles, do you think it diminishes the integrity of the board for him to continue to serve until he is proved innocent or guilty in our courts?
Sir, I'd prefer not to answer any questions about that.
Thank you, Mr. Chair.
Thank you, Senator Stone. And are y'all PREA compliant?
We are going through the PREA process right now. As a matter of fact, I think at our last board meeting we approved a contract with an agency with a group to go through and to determine if we are PREA compliant. If not, what we need to do to come into compliance.
So how long have you not been compliant?
I don't know.
Okay. $200,000, that'd hire about 5 or 6 correctional officers to the way I figure it. So anyway, Senator Hammer has a question.
A while ago, you were asked about if you were, I can't remember the board that you get accredited by.
American Correctional Association.
Right. Do they actually have jurisdiction, or does your accreditation, is it affected by state procurement laws and whether or not you are actually following state procurement laws? Do they have any jurisdiction in?
I don't believe so, but I don't know for sure.
Okay, so your accreditation would not be threatened by what's occurring in this discussion with whether or not state procurement laws have been violated or whether you did
Not
anything.
that I'm aware of.
All right, I just want to establish those 2 points never connect, and that doesn't affect. Okay, thank you. Thank you, Mr. Chair.
Thank you, Mr. Byers, and you're excused, and the board or the committee reserves the right to recall you for any other questions. But thank you for being here.
Thank you, Mr. Chairman.
And the committee calls Mr. Benny Magnus to the table, please. And Mr. Magnus, if you'll raise your right hand, do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please take your seat, state your name and your position for the record.
My name is Benny Magnus. I'm chairman of the Arkansas Board of Corrections.
Thank you, Mr. Magnus. Have you, did Mr. Metadazadigan help you prepare for your testimony today?
No, sir.
Did you meet with anyone to prepare for your testimony today?
No, sir.
And Mr. Metadazadigan did not discuss your testimony with you?
No, sir.
Okay, good deal. So, Mr. Magnus, have you ever emailed or texted with Mr. Metadazadigan?
Yes, sir.
Have those communications been provided to the committee?
If I still had them on my device, yes, sir.
Now, what was your answer again, please?
If I
They
still
either
had them
have
on,
or they have
if I still had them on the device, access to me, any emails or information goes to the DIS, State of Arkansas. So I check my phone and then have them check DIS to see if there's anything. Because not all the time, but sometimes I cancel deals, keep my phone clean, and don't keep a lot of emails or texts and stuff.
Well, if those emails are deleted, they can still capture those.
Yeah,
So-
DIS would have
Yeah.
them. That's the
So
reason
my
I
next
say.
question, Mr. Magnus, is: do you find it at all problematic that your attorney raised the price of the purported contract by $7,000 without your knowledge?
No, sir. I didn't.
You don't?
No, sir.
It's not problematic?
No, sir.
Okay.
I
So
can-
my next question is: do you find it at all problematic that your attorney materially changed the terms of the agreement and did not communicate those changes with you?
No, sir.
Okay, thank you. And Senator Dismang, you're recognized.
Thank you. And again, I wouldn't call it sidetracked, but I still think we've got to get back to the original, where did the engagement start, how did it start, and that sort of thing. But before I do that, just kind of very similar questions I asked before, and especially since you're the one that executed the contract. There was a motion made that essentially that you would reaffirm the contract with Mr. Apton.
Yes, sir.
In committee.
Yes, sir.
And then, so that's what your authority, that you were given the authority, I suppose, to execute a identical contract.
Correct, sir.
And you executed a contract that was materially different. Is that correct?
Well, sir, as you know, the contract that we signed at the board or voted on had an hourly rate, and the procurement document that I signed.
Now, let's just set aside on the
Okay.
amounts.
Okay.
I mean, I think it's a lot of money, but I'm not going to, him all around on the amounts. What I'm talking, there were other provisions in that contract that I believe changed the scope of work that he was doing for you in the favor of him, which you did not have the authority to make. You had the board's approval to reaffirm the current contract.
Correct, sir.
Not exceed what was in the current contract. Is that correct?
Yes, sir.
Do you agree that what you ultimately signed, and what was brought before ALC exceeded the authority that was given to you by the board to just reaffirm the contract?
When I reviewed it before I turned it into ALC, I did not feel that way. No, sir. And still don't.
So you did review the contract before you sent it over and were familiar with all the changes that Mr. Apton made?
The comments you just made, that I knew Mr. Afton was going to make changes to the document or had a place for the contractor to sign.
That was the only change he was to make, was to sign the contract, correct?
No, sir. I believe he had a place for comments, if I remember correctly. I only seen it prior to his bringing the contract back. In other words,
what you had the authority to send.
Yes, I got one contract, and it was supposedly, lack of better words,
just a document to save our space at ALC on the agenda. And
I'm familiar.
And then I got another contract that I didn't spend a lot of time reviewing. And at that point, I can't remember where I got it at. It was like 11 o'clock in the day or some time. And knowingly that that document would be sent to the attorney to fill out. His comments and sign. Then I got it back, and as I said, the report shows that I was on the road, and I pulled over and reviewed the document again.
So
At that point, I told my assistant to go ahead and put my name on it and send it to Mr. Brown.
So you reviewed a contract and executed a document that you didn't have the authority to execute because the board had only given you authority to reaffirm a contract, not make substantial adjustments to the contract. So I think I fully understand that at this point. At what point did you task Mr. Watson with finding an attorney?
The way this deal happened going down the road to trying to terminate Mr. Perfia or to hire an attorney was over stretches of months, not automatically like it feels like. We kept trying to work with Mr. Perfia, and he just would do things.
I'm not asking about him. I'm asking at what point did you charge Mr. Watson with hiring an attorney?
After one of the executive meetings, I asked him, Mr. Watson, my understanding is he's an employment attorney. It's obvious he couldn't, and a contract attorney. I asked him to find someone, him as a legal liaison, find somebody that had some.
What meeting did that occur in?
One of the executive sessions.
So you had an executive meeting in which you discussed firing your director, and then after that, you met with Mr. Watson and discussed hiring an attorney.
No, sir. At the executive meeting, which it was just some of the performance of Mr. Perfia, and his lack of. See, you're
I do have that in front of me, and so I think I'll help jog your memory because that meeting was on March 8th, and that's the meeting in which Mr. Phelps moved that y'all go into executive session. It was seconded by Dr. Gass, and then y'all went into executive session to discuss the employment, some employment issues, right? And in that meeting, y'all met at 11:10 and left the executive session at 11:40, so you were there for approximately 30 minutes. Upon exiting that meeting, so in a 30-minute window, Mr. Watson moved that because of the conflict of interest with the Attorney General, that y'all hire outside counsel. And it was in that same meeting, right after it started at 11:57, that then you voted to then go ahead and hire Mr. Apton. And I apologize, I just don't want to try to butcher the last name, and I will. I've got a real weird one myself. So it was all in about a 30-minute window that, from my understanding, from what you're telling me now then, that you charged Mr. Watson with finding an attorney. We found the attorney in that 30-minute window, and by golly, we hired him within the hour.
No, sir.
That's on paper.
That's not, I'm trying to explain it, and it's some of the prior meetings of executive session when we were discussing Mr. Perfia's performance. I asked Mr. Watson to start looking at a possible litigator of employment law, and he started researching at that point. It wasn't at that meeting. It was prior to that.
Well, Mr. Byers said that didn't happen just a few minutes ago. His first knowledge
I think that
you had charged Mr. Watson with hiring an attorney was when you hired an attorney.
Well, sir.
I think it was asked 10 different ways by 10 different people, and the same response was given every single time by Mr. Byers, that he did not know that was going to happen until it happened.
Well, sir, I understand that may be his testimony, and I know Mr. Byers is honest and will be forthcoming on everything he says. I'm just telling you, when I appointed or asked Mr. Watson to start looking into an attorney in case things didn't change with Mr. Perfia was way prior to that meeting that day.
Do you keep recordings of your executive meetings?
No, sir. We were told that we can't discuss.
No,
or to-
I'm asking, is there a
No, sir.
written
No,
documentation
sir.
of any kind kept for anyone, even if it's not subject to FOIA? Or at least you believe it not to be?
No, sir.
So then, now we've got, because of the lack of process, one board member saying something happened and another saying something else happened, and we're unable to reconcile that because there is no documentation whatsoever. Because, I mean, it would be understandable that if there were a discussion about hiring an attorney, that's clearly not part of the executive committee function.
First of all,
Or not executive.
I said after one of the
Session.
executive session meetings, as being chairman, I asked Mr. Lee Watson to look into possible attorneys if we needed to.
I'll stand down for the moment. I know you've got other people and you've been gracious.
Okay, thank you, Senator. And Senator Stone, you're recognized.
You lit up Gilmore. If you were trying to get Stone, I can wait.
Oh, Senator Gilmore, you're recognized. I had my numbers mixed up. Thank you.
No worries. Thank you. Mr. Magnus, thank you for being here and willing to testify. I just sort of want to go back to what Senator Dismay was asking. So on the December 8th board meeting, where Mr. Abton Metazodigan was hired, so I want to get your understanding of this, because in his own billing, he shows that there was 8 hours or so of 8.5 or so hours of work billed on that day. So I'm trying to figure out when that work commenced. So if he wasn't hired until that board meeting, if there was no conversations or anything going on, how did we get to those billable hours?
You need to ask him that.
Well, I will, but I'm asking you. Do you have any thoughts?
No, sir. We asked him, well, wait a minute. I'm sure that when he was first contacted by Mr. Watson, he may or may not have done some research. I'm only guessing. And that's what I feel like you asked me to do, is just guess. But, so I can't tell you.
But are you not even curious as to that either? Because I mean, that's kind of curious to me that, and I will certainly ask Mr. Metazodigan that question, probably Mr. Watson as well. But I'm just trying to get chain of events.
Well, sir, unfortunately, in my business career, I've had to hire too many attorneys, and I don't find
that is
this to be
unfortunate.
nothing we've done so far with Afton seems to be out of line with what I've dealt with my entire life in the business community. So the only difference being is a process that the Board of Correction has never done in the 25 years that I've been on the board. This is the first time any of this has come up. The first time I've been asked or have signed a procurement document in 25 years. We were told, sometimes I get to thinking I take this as the same as a courtroom. So I hate to say hearsay, but I was told that we had to go through this process of this, filling out this procurement document to put it in front of ALC. Never have I, in 25 years as chairman, I've signed contracts, a lot of big contracts. I've never, ever signed a procurement document in 25 years or asked to sign one.
That's interesting to me, because that is the standard process for procuring a contract. I mean, the contract in question in all of this is a, quote, standard service agreement.
Yes, sir. My understanding that either staff fills it out But on service contracts, the normal process is OSP fills it out. I don't know if that's completely correct. That's what I've been told since then. But I know this, if my memory serves me right, I've never signed, that I can remember, a procurement document. Now, there may be one out there because the board itself doesn't normally contract with a vendor. We approve the contract. The vendor is normally the agency. So therefore, the agency would normally, if there is a signed procurement to put in place, the agency would sign that procurement document, not us. And no agency has ever, that I remember, brought a document back and said, we got to have your approval to sign this procurement document. And as far as we have items come before us sometimes that we approve a contract up to $300,000. So the actual contract or sales price might be $285,000, might be something, but we give the agency authority to spend up to X number of dollars.
Sure.
We just did one the other day for PREA, for the PREA contract. If I memory serves me right, it's $300,000 or either $350,000 that and they had gotten estimates that could run as much as $600,000, but we were only authorizing the agency at that time to spend $350,000.
Okay, so y'all handle contracts and approve contracts all the time. I mean, medical contract's a pretty big contract. I know you probably review that thoroughly, right?
Unfortunately, it happens every 10 years, and I've read every page of it.
Well, that's good.
But it only happens every 10 years.
Sure. Well, that's good because, I mean, I'm glad to know that you do because that's a pretty big contract, as you know. But you didn't read this one, and so I'm trying to figure out if I may ask my question, sir. I'm trying to figure out if this one was so out of the norm, then why didn't you look at it?
Well, sir, I can only answer that basically maybe two ways. If there's any error in this process of this procurement document, it rests on me. I'm the chairman of the board. I'm the last one that touched it. I'm the last one that sent it to staff. If there's anything in error, it falls on me. And I can only tell you that, did I review it? Did I read and understand all the legal termination that was on it that day? No, sir, I did not. But it was my understanding that that was a document to send to ALC that our contract would stand on its own. That was my understanding. Now, I know that I'm sitting here today. I won't do it this way again. I don't know that y'all can be intimidating, and we're all here trying to tell the truth and do the right thing. I've done it for 25 years now, and it's not the first time I've been in front of these committees, unfortunately.
Well, I for one, appreciate you being here, and I understand this is not a fun process for anybody. And frankly, I don't think anybody wants to be sitting here even asking these questions.
No.
I hope you appreciate that from our side.
No, I understand, have always understand the legislature's position of holding us accountable. Y'all have to do that. You need to do that. I'm just telling you that was, and I get your point. So much out of the ordinary. Why didn't you pay more attention to it? I didn't. I thought it was basically just a form to get it at ALC. And I'm not saying anybody told me that, or I'm not relying on anybody. It's the same, again, I said a while ago, if it falls on anybody, it falls on me.
So one final question, Mr. Chair, and I'll get back in the queue to allow for others to speak. So at what point do you recall when you made Mr. Watson the quote litigation liaison, I think was the way, or
Yes,
or a legal liaison? I forget exactly. I think it was one of the two terms.
Yes, sir. As chair, over the years, I have assigned people different liaisons to look into different matters. And I do that to try to equally out to all the board members some responsibility. But it happened somewhat after one of the executive sessions where we had several executive sessions about employees. Mr. Pafia had come up several times in his performance. After one of them, I had asked him, you need to start trying to probably look for us someone in employment law is the way I think I remember putting it to him. I didn't know that I would be looking for somebody to go to the Supreme Court. The $200,000 estimate, was my understanding, was an estimate for him to go to the end of this, to the end of the Supreme
Real
Court.
quick, so that part wasn't my question. I want to follow back. So at what point did that happen? Did you ask Mr. Watson? What meeting did that happen in?
I can't tell you, sir.
You don't remember the meeting where you designated him as that?
No, sir. And the reason is there were several different. There were several different. I'm even looking for the term now. Executive session, where Mr. Pafia's performance came up, and it would have been after one of those.
So it would have been after one of those meetings?
Yes, sir.
Okay. So can you find the minutes of where that meeting happened between you and Mr. Watson? Because
sir, it wasn't a meeting. It was me telling him to serve as a litigation liaison and start trying to find us something.
Okay. I'm sorry. I thought that happened in a formal meeting.
No, sir. No,
okay.
sir. No,
so that
sir.
That happened just one-on-one.
Yes, and I do that. I don't say regularly, but at the end of like April coming up, at our April meeting, I will appoint, and we got a couple of new members. I will appoint different liaisons for different agencies. And for example, if the liaison for that we feel like is important is the farm. The liaison for corrections. When there's an issue going on, the director has to call me and the liaison.
Sure.
Has to call both of us to inform of an issue. That way, and then I kind of if there's something they want or need, let that liaison take the lead for that agency or that entity that I've made them liaison over.
Okay. So you will designate a board member, and I promise, Mr. Chair, I'm wrapping this up, so I'm going to preempt any sort of call down. And Mr. Magnus, I'm sure as chair, you have to call members out and tell them to be quiet at times too. So I'm going to shut up here in a second, I promise. So you will, at board meetings, you'll designate an individual to be a liaison. But in this case, you had a conversation with Mr. Watson, told him, hey, we need to find somebody, and then you designated him at a board meeting to be the liaison, correct?
Yes, sir.
Thank you very much.
Thank you, Senator. And Senator Hammer, you're up.
Thank you. And thanks for being here, Mr. Magnus. A couple quick questions. On the procurement of the contract, were you ever, or was the board ever notified or warned before the contract was initiated that it was going to violate procurement laws by your internal legal counsel?
No, sir. No, sir.
So Mr. Brown never, and Mr. Brown is your legal attorney?
No,
He's
sir.
not. Okay.
He's our CFO.
CFO, okay.
It's my understanding that I probably should let him answer this, but normally legal person does look it over in the agency. I'm not sure we had named a legal person at the secretary's office at that time.
Okay.
We were in changeover, and I'd like Mr. Brown to say that, but nobody told us that it was wrong. I know in conversations with Mr. Brown, he was telling me that procurement is telling me we got to do this. Procurement's got to tell me we got to do this. So we were trying to follow the instructions we were being given by procurement, in my mind, what Mr. Brown was hearing.
Did Mr. Brown ever provide you with a memo that said you were about to break the procurement law, or you have broken the procurement law by the way in which you went about initiating this contract with the attorney?
No, sir.
Never issued you a memo?
No, sir.
Never gave you anything in the board meeting, verbally or in writing?
No, sir.
Okay, thank you.
Thank you, Senator Hammer. And Mr. Magnus, does the board have policies and procedures established in writing or bylaws, how you're meeting? I'm up here, I'm the chairman, right here.
Oh, okay, yeah, excuse me, I'm sorry, I'm sorry.
Do y'all have that available?
No, sir.
You don't? You don't have policies and procedures or bylaws?
We have
on how meetings are
policies that
conducted?
the board follows and requires the agencies to follow, but I guess I was a member of the Board of Corrections for 5 years before I became chairman, and I'm guided most generally by our board attorney, Mark Colbert, if there's anything I need to be doing differently, or and other than that, I just followed the practices of the prior chairman.
So just because it's always been done that way, even though it may not be conducted right, so you don't have any policies, procedures, or bylaws about how your meetings should
We
be
have
conducted?
bylaws and instructions that guide our some of the agencies and stuff like that. And for example, my authority to be able to appoint a liaison, but I don't read them, every year. I don't,
Well, I thought you just said that y'all didn't have any policies or procedures.
Well, we do, because in memory, again.
Can you provide those to the committee, please?
I think that
Okay, great.
Ms. Tyler can, yes.
Okay, thank
Yeah.
you. And just a little bit of housekeeping. Committee, we have a number in the queue, so I probably wouldn't get back in the queue. If you're not already in there, we'll try to clean that up, and then we'll take a break for lunch from 11:30 to I want to say 1300, but it's 1 o'clock. And our first witness up after lunch will be Mr. Medazadigan, and he has some obligations this afternoon, so we'll try to clean that up. And lunch will be provided in the back, thanks to Marty Garrity and BLR's got that taken care of. And with that being said, Representative Beatty, you're up.
Thank you, Mr. Chairman. I'm over here,
Yes, sir.
Chairman Magnus. One, thank you for being here today. Thank you for your 25 years of service to the Board of Corrections. My question is, going back to some of the questions and statements from Senator Dismayne and Representative Gasaway, on the timeline from the November 17th press conference through the December 8th meeting, what conversations did you have with other board members or other involved parties regarding the hiring and engagement of an attorney to deal with the issues that you had problems with?
I think it was just assumed. I don't remember any great conversations or any conversations with the board, but I think when the board met together, it was just assumed that there was, from the remarks the Attorney General made at the press conference, that he wasn't going to be able to represent us in a biased way. And then also that we felt like, as a constitutional board, we did not have to get his permission to go outside. I believe the statute is, I've not read it, but statute 711. And I can't remember which year now, but it just says a constitutional officer, which we believe we were, did not have to go through the Attorney General to be represented.
Okay. My question is, do you provide your board members with a set agenda for each meeting that they get prior to the meeting, or they show up and then the agenda
No,
is set?
there's an agenda, but at times when something comes up, we vote to suspend the rules and place something on the agenda, and that sometimes happens.
So on the December 8th meeting, was the hiring of an attorney a specific agenda item, or was that something you suspended the rules and added to the agenda?
I'd have to refer to the record. I don't recall. I don't recall that if it was, I know there's been some testimony that Afton was there that day. If Afton was there that day, that more than likely was on the agenda.
So he was there. Do you know who invited him to attend that meeting?
I can't remember, honestly, whether I did or it was Mr. Watson. I can't tell you that. I'm sorry.
Okay. So a decision and the whole decision to hire an attorney and what got us into this position was just based on assumptions made by the board?
I think that in representing the board, especially in because of the constitutionality of our issue, was this an assumption from the board that we felt like that we needed some representation and we weren't going to be getting it through our normal process with Attorney General.
I'll get out of the queue. I have other questions. I'll get back in.
Thank you, Mr. Beatty. And Mr. Magnus, can you ask your staff to provide the agendas from your all your meetings since 1 December to BLR staff, please?
Yeah, Miss Gray, our administrative assistant's in the audience, and I'm sure she wrote that down as soon as it's asked.
Yes, thank you. And Representative Lundstrom, you're recognized.
Good morning, Mr. Magnus.
Good morning.
I'm going to go back to these board minutes. Do you write down at the board minutes the number of the members that are present?
Miss Gray does.
Okay. And then do you record all that information that's happened, the items in the board, what you voted on?
Miss Gray does. We run a tape. In fact, we're looking at trying to get a little better tape system. Sometimes but yes, ma'am.
Okay. Could we get the board minutes for the last year?
She's in the audience, and I'm sure if she's wrote it down right now, we will do whatever. We have always done everything you all have asked us to do.
Thank you. Well, Mr. Byers noted that they were in Pine Bluff, so.
We're actually in Whitehall.
Okay. Well, I sure would like to see those board minutes.
Okay. Yes,
All right.
ma'am.
Thank you.
Thank you, Representative Lundstrom. And Representative Springer, you're recognized.
Thank you, Mr. Chair. I'm here.
Yes, ma'am.
Okay. I'm looking at some documents that have been shared with us, Exhibit C2, and attached to the Exhibit C2 is an order from the court in the Circuit Court of Pulaski County, 11th Division. There's an order from Judge Patricia James, and in that order, she rules about your having hired special counsel. Are you familiar with this?
Yes,
order?
ma'am, I am. I was in the court that day, yes, ma'am.
Okay.
And testified in that trial.
Okay, so I'm just curious to know, is this order on appeal? Do you understand what
Yes,
that means?
yes, it's appealed to the Supreme Court, yes,
It
ma'am.
is on appeal to the
Yes,
Supreme
ma'am.
Court. All right, thank you.
And my understanding, the ruling didn't establish who you hire as an attorney or to give you the authority to circumvent procurement laws. Is that correct?
It's my understanding of 711, any constitutional officer or board can go outside the Attorney General to hire their own staff, and that was her ruling.
My question is, she did not tell
No,
you
sir.
that you did not have to follow procurement laws. Is that correct?
No, sir.
Thank you. And Representative Gazaway.
Thank you, Mr. Chairman. Thank you, Mr. Magnus, for being here. I want to go back to the December the 8th meeting. That's the meeting where you hired Mr. Abton. It sounds like to me, from what you've said here today, that you had conversations with Mr. Watson prior to that meeting, tasking him with finding an attorney for the board. Is that fair?
Yes, sir.
Okay. And those conversations took place outside of a public meeting.
Yes, sir.
And those conversations were about hiring an attorney to sue the state. Is that right?
No, that's not correct. It was to find us legal counsel, and because of our predicament with Mr. Perfia at the time, that was my concern. That if we had to, the Board of Corrections has terminated directors before, but it never was in the position that we were in, with the governor claiming that she was his supervisor and we claiming we were their supervisor. So I basically wanted some legal advice on what would happen if we terminated him. And that was my reasoning for asking Mr. Watson, which it's my understanding, has been my understanding for years that I have the authority to appoint a liaison to look into a matter, and that's what I did.
Okay. Well, let me just say, I want to take a little bit of issue with that. Truly, I find it hard to believe that that's the only reason that you hired Mr. Abton at the time, was to get advice about how to deal with Secretary Porphyry, because you hired Mr. Abton on December 8th, and I happen to have Mr. Abton's billing, and on the very day he was hired, he billed 6 hours drafting a complaint. That's a lawsuit. That's to sue the state on the day he was hired. But it's your testimony here today that y'all just hired Mr. Abton to get some advice about Secretary Porphyry. Why then would he bill 6 hours drafting a complaint suing the state on the day he was hired, if that's the only reason you hired him?
Sir, when you asked a question, I answered it the best that I can remember and recall. The hiring of, or looking for an attorney started because of Mr. Porphyria. I didn't say that's where it ended. It ended with, yes, that we felt like, hire an attorney. You got to remember, probably it was prior to even the November press conference. No, it would have had to have been after because of our position with how we felt about the Attorney General. So somewhere between November and December the 8th, November the 17th or 8th, is when I probably asked Mr. Watson to look into hiring some representation. And he may remember, when y'all get him up here, maybe remember a different date.
So what was that date again?
I've been told that the press release was on November the 17th. Not that this matters to you, but I was actually at Mayo at the time that all that took place.
Sorry to hear that. So it sounds like there were these conversations about hiring an attorney that started to take place immediately after that press conference of November the 17th. Is that right?
I don't recall when I asked Mr. Watson to be the litigation liaison to be looking for some representation advice.
Okay. And all these
I just know that it was after one of the executive sessions we had when Mr. Porphyria's name came back up in his performance.
All right. So all these conversations were happening offline, off the record, not in a public meeting about retaining a lawyer. That's fair to say, right?
Sir, it's my understanding, has been my understanding for years on the FOI, is I can call a board member and give them information. And a lot more than that anymore. I just call my administrative executives and let her call the board members but in the past, many years ago, there was something going on. I would call the staff, call the board members and tell them, give them information, but I'd always tell them, make sure that you do not tell me how you'd vote or what you think about it. I'm giving you basic information. And that's how I operated for a while. And used to. I try to go through my administrative assistant anymore because I don't want to get even close.
All right, I appreciate that, but I have a limited amount of time, so let me just move on real quick. Back to what we were talking about earlier. On the day Mr. Abton was hired, he billed 6 hours drafting a complaint to sue the state of Arkansas. You say that you didn't hire him with any expectation that he was going to sue the state. You just wanted advice about Secretary Porphyry. Did he not tell you that on the day he was hired that he was drafting a complaint to sue the state of Arkansas?
Sir, he may have. I don't remember. Again, I wish you would ask him that question. He can probably remember who told him what and how that came about, because I don't remember.
Well, he was doing it at the rate of $285 an hour.
I knew what the rate was, yes, sir.
And that alone was $1,710 on day one to the taxpayer to just draft a complaint to sue the state of Arkansas. And you had no idea that he was doing that?
I'll let him answer that question. I think that would be more proper. I think he could give you more clear who told him to do it and when and how. And I'll be glad to come back up if he explains it.
I mean, we've established you're the chairman of the board.
Yes, sir.
I would expect that you would know what your attorney is doing, who you just hired. None of that was communicated to you?
I would say that Mr. Watson, maybe as being the liaison, as I normally, how I usually operate, has worked with him more than I have. But yes, I worked a lot with Afton as well. But I'd say that Mr. Watson might have more communications with Afton than I do.
And then there's just the general concern about how you hired Mr. Abton, why you hired Mr. Abton, and the whole process around that. Again, we went over this with Mr. Byers, but there was no public solicitation by the board for an attorney. Is that right?
No, sir.
There was no request for qualifications to be submitted where you could evaluate a number of attorneys. I mean, there's lots of good firms in Arkansas, lots of good firms in Little Rock. You've got the Friday firm, you've got Wright Lindsay Jennings, you've got Mitchell Williams, you've got the Rose Law Firm. I mean, there's a number of firms that engage in employment law, that are recognized experts in their field, that probably would have been interested in this business. Didn't consult with any of them, did you?
No, sir.
You brought one attorney to the meeting, Mr. Abton.
Yes. And I don't know if this makes any difference or not. I just hired an attorney for a project, and I understand that's my private deal, but I got recommendations from certain attorneys, and I contacted that one person. That's who I went to. I didn't meet with many of them. I met with the one person that seemed to be the best recommendation, and I found that Afton has done my unfortunate position of having to hire attorneys in the past, that he's done a really good job. I've been well pleased with him.
Well, and I think you bring up a very important distinction. I mean, you said earlier, the number of attorneys that you've hired over the years in your private business, which is certainly one thing. But in this case, you're doing the public's business.
Yes, sir.
And you're paying that attorney, or purport to pay that attorney, with the public's money. And so you have obligations to the public in the way that you hire that attorney, in the rate that you negotiate with that attorney. I mean, would you agree with that?
Say that again, sir.
You have obligations to the public in the way that you go about hiring that attorney, in the rate that you're going to pay that attorney. In a number of different aspects, you have completely different obligations to the public when you're doing public business that you don't have when you're engaged in your private business. Would you agree with that?
I agree that anytime you hire legal representation, you have an obligation to hire the person that you feel like would be the best to represent your cause. That's what, and that cause, in my mind, is the same cause for the state of Arkansas and the citizens of Arkansas.
But the distinction here is that you have an obligation to the people, because as the Board of Correction, you are a board of the state of Arkansas. So you have obligations to the people that are higher than maybe what you would have in your private business. I think that's fair to say. And so, once again, I find it very concerning that having those obligations to the people, doing the public's business, purporting to spend the public's money on an attorney, you didn't request qualifications, you didn't ask for a number of attorneys to submit proposals to you. You brought one attorney to the meeting and you hired him on that day. You had multiple conversations about hiring this attorney with Mr. Watson before he was ever hired. You sit down there today and you say that you only hired him to consult about Secretary Porphyry when he spent 6 hours on the very day he was hired drafting a complaint to sue the state of Arkansas. I mean, it's unbelievable.
Representative Gasaway, I don't want to be argumentative in any way. I've testified that that's what it started to be. That's not what it ended up. And I think Mr. Watson or Afton can tell you when it changed to be part of a lawsuit to protect our rights under Amendment 33. I know what the conversation was from myself to Mr. Watson about trying to look for somebody that had some expertise or something in this field. And that's what I'm testifying to. And you're trying to paint it that we didn't do anything just hired him on September the 8th. And that's not where it started. And I want to just try to make sure, without being in any way argumentative, that that's not what it started out to be.
And thank you, Mr. Magnus. And Representative Gasaway, we've got 4 left. Okay, one more question, then we'll move on. We've got 4 more left in the queue.
Thank you, Mr. Chairman. And I appreciate that, Mr. Magnus. I mean, I'll just say, you've been chairman of this board for a long time. You've served on the board for a long time. You've owned an oil company. You're a sophisticated businessman. Dr. Byers is indeed a doctor. You have an attorney that serves on your board. And it just appears to me that you guys are just doing business over there willy-nilly. You're not observing any standard protocols for boards and commissions and the way that they should operate. Again, I just find it hard to believe that you guys have operated in the way that you have, but I appreciate you being here today. Thank you, Mr. Chairman.
Thank you, Mr. Gasaway. And Mr. Magnus, so was there any agreement for Mr. Metazadigan to continue to represent you in your personal business?
No, sir.
Okay. And
wait a minute. I have called him on one item and asked him for a recommendation for a specialized attorney in another field, and he's found me that person. Yes.
Okay. And Senator Dismay, you're recognized.
All right, thank you. I mean, I think earlier you were trying to say, hey, if the blame falls anywhere, it falls with me. I'm not sure that I completely disagree, but I would think it falls more to the lack of process, which I think you've heard repeatedly throughout today. The processes don't exist. You can't even acknowledge they don't exist. You just refer back to your attorney if you feel like you get off track. And I think you can kind of read through the minutes and the transcripts and know that there's nothing really firm or hard fast about how y'all are conducting business at this point.
Senator,
yes, sir.
I'd like to address that, please. I want to make sure y'all understand. There's nobody who really wants to be me right now. My name is on a lawsuit that sued the governor of the state of Arkansas that I supported.
Yeah.
Okay? This whole process from start to finish, I'd like for people to understand that the board has never been through this process before, ever. Not even close. We've never really had any big disagreements with the executive staff, excuse me.
Well,
I just want to make sure that it's the procedures and stuff and the operation of the board is ran professional and does take care of serious business. And that's why I said a while ago, if there's any fault to play in this document, or maybe from day one, I mean, I reached out to try to get to the governor and for whatever reason, I didn't get to talk to her. My fault, her staff fault, whose fault? I don't care at this point. I just know that we do business for the Department of Corrections. We're all dedicated. We don't get paid, and we have different people, different lines of their life that they bring to the table and concerns, but we try to run it for professional. I want to make clear I got 17 months left on this board. I hope I don't ever have to sue another governor. 17 months, because I don't like being here, and I don't every bit of it was completely 100% unusual.
And just for clarification too, from our perspective as we sit here, and I won't speak for other members, but I'll speak for myself. What you're suing is based on a law that we passed. And widely was passed with large margins. And so you may say it's the governor, but the governor was actually following the law
Yes, sir.
that we established.
Yes, sir.
Right. So she can't, and that goes back into the checks and balances.
But
which
that's
is-
who we had to go to for
Well,
legal,
which is perfectly fine.
legal remedy.
But understand, as
Yeah.
we sit here right now, my perspective, what you're saying is clearly different than yours, or we wouldn't have been voting for a law that we passed.
Yes, sir.
Now, maybe there's buyers or mowers amongst, a few members, but I think largely everyone thinks we passed a constitutional law, or we wouldn't have passed the law. I mean, we're also sworn to uphold certain different areas. But one thing that I do have a question, I just want confirmation is, so this whole hiring of the attorney happened in a 3-minute span. The
That's
best
what-
I can
yes, sir.
tell.
Yes, sir.
Yes, sir?
If you say, I don't have the timeline in front of me.
I'm what you say, actually, because y'all approved the minutes after the fact. So, again, just kind of go through the timeline one more time.
Meeting-wise, you could be correct. Yes, sir.
Well, but the rest of that, I've asked for other documents to be provided to me of the interaction between Apton and Watson, interaction between Apton and you. Those don't exist. I know they don't exist because I feel like y'all would have given them to me if they did exist, because you wouldn't want to break the law.
Absolutely.
And that would have
If
been
we had them,
breaking
you would
the
get them.
law. So, but they don't exist, which means to me the only thing that I can do is assume that this conversation, when it started being public, and there's only 3 minutes in which this conversation was made available to the public. And then that is very, very limited, and I'm asking now for the recording of that 3 minutes so I can better understand. But y'all went into executive session at 11:10. You broke from executive session at 11:40. You immediately went to lunch. Was the employment of, or the hiring of Mr. Apton or contracting with him discussed in that lunch break amongst the members?
I don't remember. No, I wouldn't. That would be outside the scope of what we can do.
Yeah, well, you couldn't have talked about it in an executive session because it wasn't based on the employment of a particular individual. So you couldn't have talked about.
We couldn't have talked about it in
Yeah, so
executive.
there's no, again, I go back to, there is literally a 3-minute window in which the world is brought into the conversation that's been happening for, my understanding, months. Some would say not at all. And in that, it's just a very quick thing. But I will point out that the motion was made to hire an attorney for employment, or personnel matters. And then that grew, and maybe you can make the argument and stretch, but Amendment 33 was not discussed in the motion. And my question, did you understand when you were making that, when Mr. Watson made that motion and he said personnel matters, that we were also planning on then suing based on Amendment 33? Did you understand that at the time?
Yes, at the time we hired him.
I can't find anywhere else that y'all discussed these matters.
Well, it was discussed that we hire an attorney to represent us in
personnel matters.
No, that's where it started.
No, sir. I'm reading your minutes. The only
meeting?
public document that we have is the minutes from a 3-minute conclusion. 3
Well,
minutes.
You got it
And
in front of you.
doesn't
I know at some point.
It doesn't finish.
That, yes. Well,
and doesn't say Amendment 33.
Okay.
And then it doesn't say FOIA. So there were, that was a weird thing where the actions were taking place. You go back and retroactively make it, and all these other things through an engagement letter. But at that time, you were aware when you said personnel matters that you meant Amendment 33.
Well, Senator, in my opinion, it was all the same. Because, again, we felt like Mr. Pafia would do opposite what the board requested him to do. And I don't like to get into that. But so one it was one and the same.
Okay. All right, that's fine. And then, so one thing I want to ask, because what the board allowed you to have the authority to do when you had made the final approval of the contract was to reaffirm the contract that was in place.
Correct.
And in that contract, it says we're going to follow the laws of the state of Arkansas as they're written, essentially. I mean, I'm paraphrasing, but that's what it says in the engagement letter.
Okay.
And then when we have the contract before us that brought to ALC that you then signed, it says, well, in fact, we're not going to follow all the laws of the state of Arkansas. We would like to have some of these exceptions. So it's a material change in the contract. That's how I view it. And so in that, just as an example, because we talked about a minute ago that you guys essentially approved the thresholds for contracts, which is really no different than what the board did for you when they said you can reaffirm what we've already said we're going to do. What would you do if you found out that your director, staff, whoever it was that was in charge of signing the contract, y'all had set a limit as a board. You said, we're only going to do this. This is what we give you the authority to sign on a matter up to here. What if they came back and the contract that they executed actually exceeded the authority that you gave them? What would you do? What action should be taken?
First of all, he wouldn't get paid. And because we've never had that happen, somebody exceed what the board.
Well, you did. You exceeded the authority that the board gave you by reaffirming, not simply reaffirming a contract, but granting greater latitude, what was expressly written in the original engagement letter.
Okay, I understand what you're saying, and I take exception. I understand what you're saying. But again, we were asked to put an estimate of what the amount would be.
No. I'm not.
You're not talking about the procurement document.
No, I am. I am willing to demand bills for a substantial rate. There was a exceptional amount of money that was put on that contract, and they were trying to capture in the moment what that looked like. I don't think it's appropriate that the $7,000 was added, but I'll just sidestep all of that. In the original engagement letter, it says that they're going to follow the laws of the state of Arkansas.
Okay.
Right? Contract will. And then in what you originally signed and was brought forward to us, which is what you were reaffirming, by the way, you had been granted permission to reaffirm that. And then what was brought to us actually said, no, we will follow the laws of the state of Arkansas with these exceptions. And those exceptions were notated on what you signed and presented forward. My question to you is, if that were to happen in a normal business, board approves, contract thresholds, what it's going to look like, and then the director decided on their own unilaterally to increase those thresholds, what would be the consequence?
Well, he couldn't exceed.
He couldn't do it.
He couldn't exceed the thresholds.
I agree.
Of the contract. I think, again.
Then I think we're saying the same thing. That's where there's to me, you may not see that as a substantial problem, but the board granted you permission to do something. You've exceeded the authority that the board granted you.
I may have.
Yes, sir.
Again, I accept, as I said before, I accept full responsibility. Well, every April we vote to who the chairman is, so they can remove me if they want to.
So thank you, Senator Dismang. And so, Mr. Magnus, what befuzzles me is that you got a lot of very educated people on your board. It didn't cross anybody's mind to consult with somebody about procurement laws in the state of Arkansas, or y'all just did it?
Well, sir, we thought we were because
you thought you were. That's what gets a lot of people in trouble because you think and you don't consult with the experts. So with that being said, let's move on to Senator Stone.
Yes, Mr. Magnus. I have, Mr. Chairman, thank you, and I have two questions, if you will allow. Mr. Magnus said you have stated that you're not familiar with the RFQ or procurement process with the state, but as a businessman that's done business with the state, how could you not be familiar with the RFQ?
Well, I have never done business with the state as a businessman because I'm not required. I can't do it. I mean,
you've never done business with the state of Arkansas personally or any of your companies?
One short time when there was a problem with getting fuel delivered, not the sale of purchase, but the delivery of fuel. I signed and got an exemption from DFNA and Governor Beebe to make sure the fuel got to the farm for a short period of time. I don't know if it was 60 days, 30 days, whatever, because they were having trouble. I don't remember what the trouble was, but yes, sir. I did business with the state of Arkansas for out of 25 years, maybe, I don't remember, 60 days, something like that. There was some kind of problem. I don't remember.
Okay, and my second question.
And by the way, I didn't put any profit on it. And that was one thing I insisted in my office, that they not do that, that if we were ever checked, that it was. But yes, sir, I did do it one time for about 60 days.
Okay. And my second question is, I want to ask you the question that I asked Dr. Byers a while ago in regards to Alonzo Giles.
Mm-hmm.
In light of the allegations against him, in your opinion as chairman, does his continued service diminish the integrity of the Board of Corrections?
No, sir, it doesn't in my mind, because I've known Mr. Giles for probably 28 years, and I've also think I know some of his defense, and I believe the man to be completely non-liable of the stuff that he has been put in front of him. And again, it's civil litigation, and I think that he should be given the opportunity to defend himself. If he's found liable, I think he ought to resign immediately.
This is really not relevant to what our discussions today, so let's go ahead and move on. My apologies,
Well,
Senator Hester, you're up.
I was just thinking
Senator
that
Hester.
the answer ought to be an enthusiastic yes, and Dr. Byers, if you think he's not going to do anything, instead of refusal to answer or to just kind of walk around in circles. I mean, if you got confidence in him, you should just say yes.
Thank
I
you,
have
Senator
confidence in
Stone.
him, yes. I'm sorry.
Thank you, Senator Stone. Let's
Thank
move
you.
on to Senator Hester, please. I'm sorry.
I believe this has been covered before in these meetings, but you continue to say Mr. Profura. Who is that?
Secretary, it used to be Secretary Pafia, is now working at the governor's office.
Okay, are you talking about Secretary Profuri?
Pafia, yeah.
Profuri.
Yeah, Pafia, yeah.
Yeah, we wouldn't allow him to come in here and mispronounce your name and call you Chairman Magna.
Sir, I'm sorry.
Well,
Senator,
I think it speaks to the disrespect that you guys have for each other. But anyway, is it true that once he was terminated, you guys implemented the very policies that you terminated him for?
No, sir, not completely.
Not completely.
No,
Okay.
sir. I never said that everything he said or done was wrong, but I did say that he succeeded his authority as secretary and direct direction of the board, and he went ahead and done stuff anyway.
Thank you.
Thank you, Senator Hester. Representative Beatty, and then Senator Bryant will recess for lunch.
That's not me with the hammer, just so you know, Barry. One, Mr. Chairman, I want to thank Senator Hester for the comment on the pronunciation of Profuri. I mean, I think maybe communication is something we've seen as a problem here. Communication among board members and maybe communications with the secretary. So it would be helpful to hear you pronounce the name Profuri. It's something simple at least once during this testimony. But I guess my problem is, you said you had reached out to the governor to talk about the PROTECT Act. When was that? Was that prior to the press release or the press conference, or was it after the
No, it
press
was prior,
conference?
sir.
Sir?
It was prior.
It was prior?
Yeah, I never reached out to the governor's office after the press release. Okay. But I did try to reach out to her during the legislation. And I actually, Mr. Gilmore was here. I went and talked to Mr. Gilmore.
Yes, sir. And
Senator Gilmore, I'm sorry.
Yeah.
I don't get any more trouble.
And you testified against, in opposition to the bill in committee as well.
Well, sir, I think that's a fallacy in y'all's committee meetings, because it has, you can't put down for, you only have the choice for or against. If it had a third item for comments, I would have chose it, because I've been dealing with justice system. In January will be my 50th year. And our problem has been reoccurring or inmates or offenders that keep coming back. And so with that said, that's something that the Protect Arkansas addressed. Right. So it's hard to paint us in the picture in the position that we were against it. It's only your document, since we were going to talk about one item of it, that that we were against the whole act, because I can assure you, my heart and soul was for most of the act except for those changes.
So, just to follow back up, I guess the problem that I have, and I would think that most members of this committee would have, is the fact that after that press conference, you, as chairman of Board of Corrections, never reached out for a conversation with the governor, the AG, in any discussions about the press conference or anything else, because you just felt like they were against you. And your whole problem was who Secretary Proferi answered to. Is that a correct statement?
It's not just who you asked to, but the Board of Corrections sets the population for each institution.
Well, I'm not getting into the operations of what your issue is. I'm just saying you did not communicate with the governor, the AG, or even if we know with Secretary Proferi.
I did, with Mr. Profia.
And gentlemen, we could debate this issue. We could debate this issue till next Tuesday. So we're going to move on to Senator Bryant. Oh, I'm sorry.
Yeah, thank you, Mr. Chair. Chairman Magnus, thank you again for being here. I was just looking, typically I can go to an agency that has a board or commission and I can see very pronounced transparency and communication very quickly, readily. This General Assembly does that as well through BLR. They put all the information, legislative audit puts all their information. Is there anywhere logistically that you manage or have oversight that places any of this communication for your board meeting minutes on a platform, on a website? I noticed your prison transfer board does, your victims restitution board does, but I don't see anything specifically for the board you represent.
No, sir. The board has just now voted to go on like a YouTube or something like that and go live where it's recorded on that and people can watch it. Because we're open to the public. But it's just that we've just voted last board member meeting to go on. I hate to say YouTube site, but something like that will broadcast live for our meetings.
Okay, because it's difficult from previous meetings and this meeting that is obvious because we don't have. It's like we got holes in the FOIA request. We got holes in meeting minutes that we can't piece all the puzzles together, and either they didn't exist or they do exist and they're being withheld, and we don't want to assume that. So I guess my question is, have you yourself, your council, or any member that you know of FOIA'd members of the General Assembly for information regarding our conversations, whether internally or to other agencies that you're aware of?
Say that again. I didn't understand it.
Have you yourself or members of your committee that you're aware of or your new council FOIA'd members of the General Assembly for our internal communications for this matter?
Not that I know of.
Not that you know. Okay.
Yeah.
All right. Thank you.
I didn't know that we could FOIA you all. So anyway.
I think that answered the question. Yeah. So, Mr. Magnus, since you take minutes of your board meetings, can you provide the committee with all the board meeting minutes where you were elected to be chairman, please?
Yes, sir, we will.
And that's documented in the minutes from when you were elected?
Yes, sir.
Okay, thank you. And members, we're going to excuse Mr. Magnus with the ability to recall you if necessary, since we have the ALC Executive Subcommittee to be convening immediately after we take a recess. So I would also caution the members or the witnesses about discussing your testimony outside of this room. And with that being said, we'll stand in recess until 1300 when we will take Mr. Medezadigan testimony. Thank you. The joint performance review is called back into session. And, well, you've been in trouble, Mr. Metazodigan, if I decided to call somebody else, huh? So, thank you for being here today. So if you'd stand up and raise your right hand. Do you solemnly swear the testimony you're about to give will be the whole truth, nothing but the truth, so help you God? And please take your seat, state your name and your position for the record, please.
Thank you, Mr. Chairman Berry. My name is Abton Metazodigan. I'm a partner with Hall Booth Smith. And just to get something out of the way, I'm very comfortable with Abton. If anyone wants to just dispense with Metazodigan, and I'd say if
I've been practicing the Metazodigan so much that I'm going to use Metazodigan. So
I think my family saw the alphabet and they said, "Ooh, let's just take all the letters. Z sounds fun." But if you don't feel comfortable with it, Abton's fine, and I'm not going to take any offense.
Good. Okay, thank you. So a few questions to get started, and we'd start taking questions from the members. But Mr. Metazodigan, have you provided any advice to other members of the board on their testimony for today?
I wouldn't say advice. I've talked to them to make sure, there's a confusion about whether the meeting would be today or yesterday.
So basically you talked about timing of the meeting and so forth, but not anything relevant to the matter at hand.
Not about the content of what they might say.
Okay, thank you. So did you meet with anybody to prepare for today? Anybody on the board? Do you have any meetings or anything?
No, sir.
Okay, good deal. All right, and I'll take questions from the committee. Go ahead. And Senator Dismay.
Yeah, and it's just really, I think you heard some of the testimony. Like I said, you're in a better position, maybe our first two folks. When did your contact with the board about possible, representation begin?
If I may just speak freely and just kind of tell you how this came to pass. Let me just say, I know, before all this, I knew no one on the board, personally, professionally, or otherwise, directly or indirectly. I'd never met Mr. Magnus until December 8. I was sitting at my desk one day at work. I got a call from a name I didn't understand or didn't recognize. My caller ID, it said Lee Watson. To be honest with you, I was a little annoyed that day because I had a few calls from other folks looking for a plaintiff's employment attorney, and I'm not that. So I get a lot of those type of cold calls. I thought he was going to be another one. Almost didn't answer. I answered, and at the time I was teaching at the law school. I teach employment law. I studied under Professor Terrence Kane. Was the best employment law professor I ever had, and taught me a lot about the law. And I had been teaching for about 6 years. I obviously have a number of constitutional litigations pending, and I got a call from Lee. And Mr. Watson said, "Hey, you don't know me. I'm on the Board of Corrections. We have a bit of a challenge with Secretary Proferi, and it's a unique employment law that has a confluence in constitutional law. Do you know anything about Amendment 33? Would you be willing to consult with me?" And honestly, in that moment, it's not uncommon as a law professor. I get lots of calls to answer questions for the media, and work on pro bono issues, whatever it might be. There's a lot of what I'll call informal consultation. I'm always clear to say I'm not wearing my lawyer hat. I'm wearing my professor hat when we're talking. And I didn't know anything about Amendment 33, but I was curious, and I said, "Look, let me take some time and look at this and see what's going on. I'd be happy to talk to you, down the road." This would have been, in my best recollection, on or about or around November 9, November 10, somewhere around there. Please don't hold me to that date, but I can accurately represent it was in the early part of November, prior to November 17. And so I had done some research. I looked at it quickly. There's an Encyclopedia of Arkansas article. I did a little bit of Westlaw research, and to me, it was. And please take no offense to this. I understand the awkwardness of the fact that I challenged a law that y'all passed by a substantial majority, and so I appreciate the awkwardness of it. And please don't take offense to what I say. I'm not trying to argue or castigate or anything. I truly want to be here and be respectful and answer your questions to the best of my ability, and that's what I will do. But I looked at it quickly, and I thought there was some incompatibility in the laws that were passed. So the law continued, even after amended before the challenge, continued to have the Secretary of Corrections position be approved or final approval by the Board of Corrections, which didn't make constitutional sense to me because of that incompatibility if it's the governor who has the final say over the person or the management of it. And so it just didn't make sense. And so I said, I had a few conversations with Mr. Watson. Maybe, when I say a few, maybe one or two. It was mostly, hey, I've read Amendment 33. Yeah, this is interesting. But there's no action. There's no call to action. There's no concept of hiring me. I was a little, frankly, suspicious of. I didn't know who he was. I'd never met him before. I had another lawsuit against the state, and I didn't know if he was a friend of someone who was calling to try to get me to something. I don't know. But I talked to him, and I was struck by how dutiful and respectful he was of the Constitution. And that's really the heart of our conversations have been, he's a constitutionalist, I'm a constitutionalist, and I took an oath, the same as everyone here, to uphold and defend the Constitution. As a lawyer, you can appreciate, to take up the cause of the defenseless and the oppressed, to not reject matters personal for myself that might call me into meetings like this. And I really appreciated that we have government actors who care about the Constitution in a way that I'd never really truly seen before. And that was kind of the heart of the conversation. And then on November 17, the press conference occurred. And I don't want to pick arguments or make arguments, but just a couple observations for you. As a matter of employment law, Secretary Proferi was at and spoke at this press conference, castigating in some ways the board to which he is at least answerable.
But here, practice. I want to get back to let's stick to the timeline, not the narrative, because that's what I'm asking about.
Sure.
And I want to be really clear with you about my position with you. Okay, like you are in a very different position than every member of the board that comes up here, because what they have done is sidestep the laws of the state of Arkansas. It's not necessarily your responsibility to be the one that confirms if you're reaffirming a contract or not. That was their responsibility to look at it. And so, like I said, I don't want you, from my perspective, to think that I don't need to litigate any of the case. I don't need to litigate why you felt you were compelled to go on, and take him on as a client. I can be for all of that. I mean, I think financially it was probably beneficial. But, in the end, if those things align, then you got a home run, right? Your beliefs in your pay. But I would say, so I'm at November 9th, got a phone call. November 17th, you watched a press conference. In between those two dates, there were maybe a couple of conversations with Mr. Watson. Were there any of those by email? All phone calls?
I don't believe so. I think phone calls, the first time I met Mr. Watson in person may have been, please don't quote me on this, it may have been either like Saturday or Sunday, or I don't know, some day during the week, I'm not sure, between, I believe, November 17 and November 20, and I could be mistaken about that. Maybe
that's
some action after that.
You have more information than anyone else so far. Sorry. So we're now at November 20th.
November 20 is the date on which Chairman Magnus issued his letter to the governor, inviting the governor to meet and speak about these issues to avoid the constitutional conflict that also painted the history of Amendment 33. I had a hand.
So you assisted
I had a hand
Mr. Watson
in
in
reviewing
drafting.
and making some kind of nits. I was the editor-in-chief of the law review, so I made some nits and some edits to the document.
But that was pro bono work. You don't have any contract employees.
No, not at all. Just as, again, law professor interested, and again, all Mr. Chairman Magnus's content, just some revisions and edits that made it flow a little better. That was November 20. I must have had some type of, I'm certain I had some phone call with Lee, Mr. Watson, excuse me, between November 20 and December 8, which is the date on which my engagement agreement was signed.
Yeah.
And now that I think of it, maybe it was prior to December 8, right before the December 8 meeting where I met with Mr. Watson over pizza in person. I really just wanted to see who he was face to face because I didn't know him. I don't like to take on clients over the phone, so I'd like to have at least just know who they are. I was never the conversation that Mr. Watson and I had was, again, just kind of pro bono, kind of just interested, kind of watching this. And then there were different events, maybe in the media, or different statements made. I think the Attorney General made a number of statements that, from my perspective, from an ethics perspective, very interesting, because the Attorney General actively, even to this day, actively represents these folks. I'm not aware of any state ever where you can castigate your own clients like that and then sue them. And so I think we may have had conversations around that between November 20 and December 8, just kind of following it along. And then I believe around that time, the December 8 timeframe, the governor had given Secretary Proferi some directive to open additional space up before the board's deliberative processes had concluded on whether or not that was an appropriate decision to make.
Okay.
And at that juncture, I took an old engagement agreement that I had used for other public entities, and I will tell you, I have represented every branch of Arkansas government in my practice, every branch. And so I took the exact same engagement agreement and I made some minor modifications to it. In part, number one, specifically remove language around sovereign immunity, intentionally, because I expected, to be frank with you, I expected that we would be here at some point. It's not lost on me that.
I understand. You're suing a board on behalf of a law that we passed. I get it.
Y'all
and we're
passed,
not litigating
the
that.
governor
Like,
signed.
I'm only care about timeline. I don't care about the narrative.
Yes, sir. Okay. And so on December 8, I had known that there was going to be a board meeting that day. I didn't know, and I had not spoken to anyone other than Lee. I may have spoken to Benny that day for the first time. I wanted to know what he was all about. I Googled him, and that was the extent of my knowledge of Mr. Magnus, or Chairman Magnus. And I think we may have met face-to-face that day before the meeting for the same purpose. I really just wanted to know his story, who he is, how long he's been with the board. Met that day. No one had promised me anything. No one had said anything. What I was told is that we'll see what happens. They hadn't talked about hiring an attorney. As I understand it, as a board, they had several conversations around, prior to all this, around Secretary Proferi's performance deficiencies. And I think those conversations always led to the point of what do we do about it after these laws were passed. And that's why I made the engagement agreement readily available to them. You'll notice it doesn't have a date on it because I think I just gave it to Lee and said, hey, if this is something you'll ever need, here it is. You can consider it. It's at a discounted rate, by the way, and there are all elements of a contract are in my engagement agreement. And an engagement agreement
I'm not worried about
is
your
absolutely a
engagement
contract, but there is an hourly rate, and it's a discounted hourly rate. My normal rate's $350. I do a lower rate for public service work like this, which is a rate that I think this body wouldn't ordinarily have a
And
concern
if you
with.
just answer the senator's question.
Yes.
We don't need to just keep it succinct. We don't need the narrative like the senator said.
And Joe, so to be specific, so you understand where I'm coming from. Now we can pursue a completely different path, and this is not my goal. My goal is I've had testimony so far. We're going to have continued testimony. I believe that the proper protocols weren't followed to even hire you. Is that your fault? No, I don't believe that it is. So my basic questions are, and you've given me the timeline I think that I needed to get to where I am. So we're good at that point. We're at December 8th.
So December 8th is the date on which the board goes into executive session, speaks about Secretary Proferi's employment, comes out of executive session, and makes two votes. One vote to hire outside counsel, and the second vote to hire me specifically.
A 3-minute meeting.
Pardon?
It was a 3-minute meeting.
If that's your representation.
No. It's not mine. It's the minutes of the. Now, it would be awful if they're not true and accurate, but that's what the minutes say.
I was there, so it wouldn't surprise me.
That sounds good. About right. Yeah.
Sure.
Okay.
I think on December 8, the Attorney General's office, and particularly Deputy Attorney General Dorley Chandler, called Mark Colbert, the compliance administrator for the Board of Corrections, and advised of her opinion that the board was violating 702, 2516-702. On December 11, We received a letter from the Attorney General issued a letter, and I think it was sent to me as well, more or less saying the same things. On December 14, I issued a letter to the Attorney General advising of two things. Number one, of the board's position relative to 2516-711, and of the fact that the only person of whom I'm aware who's ever actually violated 702 is Dorley Chandler in a case titled 2600
I do
Holdings.
not need
I'm
the
trying. I'm
narrative.
just trying to give
I
you
need the timeline.
and that's the timeline. So that was December 14.
But I don't need the narrative behind the timeline.
Sure.
What I am mostly interested in, because, and I'll just put it this way, so it's very succinct. I mean, and we're on the same page. It's been told to me and represented to me that there is no correspondence between you and Lee Watson or really anyone else with the board that didn't happen by the phone. So thus, none of it can be provided to the legislature. There's an engagement letter and a few other little things that happened. But as far as the conversations, which I'm really interested in, is, how did Mr. Watson come to pick you? How did that conversation play out? Did you meet with the board that day on December 8th, or did they meet in a 30-minute executive session, come out of that and decide to hire you in 3 minutes? And so you're also representing there was no communication other than verbal between you and the board prior to you being engaged as their attorney.
I want to answer your question without providing a narrative.
Thank you.
And so, from a timeline perspective, I'll put it this way: if there is any written record of any communication that I've had with the board or its members individually, it has been turned over.
Okay.
At the same time, I represent a number of public entities, and I understand the extreme costs associated with complying with FOIA requests. And I also understood that it would be saving taxpayer dollars if we were exercising appropriate data hygiene that I've learned from Attorney General FOIA presentations. And
Okay.
so, to the extent that there were records, I'm not suggesting that we never emailed. If there were any, they were deleted. And it saves money so that every time I get a FOIA request, which has been substantial, 10 so far from the Attorney General alone, I don't have to go back and pull a history or years worth of these documents. And that's my standard practice.
So on your side, you would have no documentation because you have a practice of deleting the emails. Is that
Correct.
what you're saying?
Correct.
Okay.
As is the common practice of every government attorney and participant of whom I'm aware.
That's enlightening. I had no idea, and that's good to know. Okay, so you are not able to provide any backup then to the questioning. You don't have anything in record, so when it comes time when we're talking to the members, we'll make sure to ask those questions.
I don't want to paint with such a broad brush, Senator, respectfully. I do have records, and I'm not certain that you have requested all of them. I am certain that the Attorney General has, and all of those records have been turned over to the Attorney General, and I believe all records that this body has requested have also been turned over. So I haven't gone back.
Mine were never reviewed. Mine were the board members who said they had nothing.
Pardon?
So mine were of the board members through legislative counsel who said they had no records. There are no records of your communications of any kind or how we led ourselves up to the hiring process of you, other than some board minutes and a letter of engagement and those types of things. And so if you don't have them, that's fine with me. It's a continuing question I'll have for additional members as we move through.
If there are records, they were turned over to the Attorney General when they requested them, or whomever requested them in a FOIA request, and I assume that that's the same information that was turned over to you. I also did not go back and cross-reference the thousands of pages that were requested by each body at different times.
No, mine were pretty simple. So, again, let me just reiterate, I asked for nothing through the Attorney General's office. I asked through Legislative Counsel, which is, our vehicle to do such things. Okay, so, but you're saying there was no written communication, just one more time, because I think you told me there was nothing that's FOIA-able because you delete them. Was there any written communication between you and any board members prior to December 8th?
If there were any written communications, it would have been only between me and Mr. Watson.
Not if, were there? I understand.
I am certain that there were text messages. I am certain that Mr. Watson and I texted, hey, do you have time for a call?
Perfect.
And I would delete those things.
Right.
Absolutely.
I'm not asking you. You understand, I tried, and I'm not being articulate. I'm not saying it well enough. You do what you do, okay? It is not your responsibility to make sure that board members act like board members and act appropriately and follow protocol or even follow procurement law. That is not your responsibility. And so I think you heard in the line of questioning earlier, that's what I'm mostly interested in. And so my question is just a simple yes or no. So now, there probably were some text messages between you and Mr. Watson.
What I would consider to be kind of ministerial type, hey, do you have time for a call? Something like that.
Okay.
But again, to the extent that there were those communications, and I think there were, just on kind of coordinating, like, hey, can you talk to me? Those would have been deleted.
And like when you did the markup for the response to the governor's press conference, I think that's what you said, that you helped kind of mark up that document a little bit. How was that handled? Did y'all trade communications back and forth, or?
I think I called Lee, and I think we spoke over the phone.
You just called and had him red line through and said this needs to come into play and this doesn't. So he sent you, though, a copy of it so that you were able to see it?
No, we met for pizza at one point, and he had some copy of something, and I think I provided some notes to him.
And so he gave that to you. He gave you a copy of the document.
I think it was like a lot of like copy and paste from like Arkansas Encyclopedia, like just kind of it looked like a data dump to me. I don't really know, just kind of some different pieces of information.
All right, I'll leave it to Mr. Watson. I understand, and I appreciate the fact, you're forthcoming. Your policy is to delete emails, texts, and all those things.
Yes, sir.
So they're not subject to FOIA. I completely understand. All right, thank you for your time.
Thank you, Senator Dismain. And Mr. Metazadigan, how much is the Department of Corrections paying you to be here today?
The Department of Corrections is the defendant in the lawsuit. I don't represent the Department of Corrections, and so the first answer to your question is nothing. If you were asking about the Board of Corrections,
well, I mean, Board of Corrections, you know what I mean.
Same. So far, that's what we're here to talk about. Is I've not been paid anything yet. My rate is $285 an hour.
But is that what you're billing the Board of Corrections right now for you to be sitting there as $285 an hour?
I think it'd be appropriate, General Berry. I think that'd be fair. I had billable work that I should have been doing and could have been doing today, but instead I was asked to come here and talk about.
So what time did you start billing?
Pardon?
What time did you start billing the Board of Corrections?
It's actually funny. I wrote down on my sheet here 1 p.m. Because I think that's fair. That the time I'm sitting here answering your questions. So until you're done asking me questions, I will keep the meter on. And it's something that I think if the board has a problem with, they can ask me to strike it or just strike it from the bill, and I won't have a problem with it. I think it's fair that I be compensated for the time that I spend representing the Board of Corrections.
So did you bill, are you going to bill the Board of Corrections for the time that you spent preparing for this meeting?
To be frank with you, Representative Berry, General Berry, I haven't spent much time preparing for this meeting.
Okay. Senator Hammer.
Thank you. Good afternoon. Question with regards to that. Based on the contract that was presented to ALC that was not authorized or approved, do you then intend to go back and adjust your contract amount?
Without offering a narrative, can I provide some explanation that I think would help everyone understand?
If we can do it in about 2 minutes or less, would be great. Yes, sir.
I will. So my contract is my December 8 engagement agreement. That is the contract. It was supplemented on December 22 after the Attorney General sued his own clients that brought this brought the second supplemental agreement to the fore. What I want this body to appreciate is that it is impossible for me to understand or to be able to look into a crystal ball and to tell you what the litigation is going to cost. This litigation, and frankly, you have certain procurement rules that don't apply if the measure would cost under $70,000 or $75,000. This lawsuit very well could have and should have cost under $70,000 if the Attorney General was not, number one, attempting to drive this narrative about the cost. That's what's happening. They have filed motion after motion after motion after motion, it's like going back to the Magna Carta to try to explain the law in some of these filings for them. There is a statute, 25-1106, that defines what a constitutional board is. That statute defines the Board of Corrections as a constitutional board. Probably have devoted 20 pages each on what that means, constitutional board. It's not that hard. And so I cannot sit here and tell you what this lawsuit or this representation will ultimately cost. It's like Newton's laws here. For every action, there is an equal and opposite reaction.
Okay.
I have endeavored at every opportunity to ask the Attorney General to streamline this, to stop fighting, to reach agreement so that we can avoid unnecessary fights.
Okay, I tell you what, dude, let's stop here because you're billing us by the hour and the clock is running up. So let me just ask you some very pointed questions. Under the current contract that you have, I'm not sure how it is that you're going to be able to bill on the basis of the current contract because of the scope of which that contract was authorized by the board to do. So I think we might have some issues there, number one. And then the second thing is, in your testimony, Senator Dismayne, I understood you to say you were, proficient in dealing with, with government entities. There was a memo that was sent by Mr. Brown, I think, advising the board that there were some concerns about, the contract and that it didn't necessarily align with the law. And that was on January 19th. Were you privileged to that memo, number one? And number two, did you respond to the board and say, hey, you know what, there's a point here. I mean, you acknowledge that you're proficient in it. So in a couple of minutes or less, could you answer the question, please?
I became aware of that memo, I believe, a few days after it was issued by Mr. Brown. I know it was dated January 19. Also dated January 19 is Judge James's order finding that Section 25-16-711, which says when there are disagreements with constitutional officer and the Attorney General, they can hire special counsel to resolve the matter by litigation, and that Judge James found that statute applied. Mr. Brown's analysis effectively parroted what the Attorney General's arguments were. That is not surprising to me because Mr. Brown is represented by the Attorney General as a defendant in this lawsuit. And so I don't agree with the premise of the procurement analysis memo. I'm not here to argue or debate that. I think there are a number of questions. For instance, 711 has a repealer clause. It was passed in 1975. 702 was passed during the Great Depression. The Secretary of State of Arkansas has argued to a court that 711 repealed 702. And so there's a substantial question of whether 702 is even lawfully enforceable or the law of Arkansas to this day. So there's a fundamental issue in Mr. Brown's analysis there. There's a separate issue, and I don't mean to disrespect this body or the power that you have. And that's what governments are all about. It's about the allocation of power. This body has the power of the purse and the accountability of being able to call folks up to answer these questions, and that's what the legislature enjoys in its exercise of power. In that specific way, the Attorney General has opined, it's opinion number 2007-007, that...
Could I interrupt you and just say what we're going to end up doing is agreeing to disagree. You have an opinion about Mr. Brown's memo. All I needed to know was that you were aware that memo had been sent, and you did not advise the board differently after you became aware of that memo. Yes or no?
The only thing I would have advised, I think this is my advice.
Just yes or no, that's all. You are aware of it, but you didn't give the board direction that we need to stop. Is that correct?
I don't know that I can answer it with a yes or no. Can I have 20 seconds to answer?
20 seconds, yes, sir.
So number one, I was aware of the memo.
Okay.
Number two, I don't believe that I advised the board one way or the other about the memo. It's not my scope and not my place. I'm not a procurement expert, and I wasn't hired to be one. I have a very specific and limited defined position here as special counsel, so I defer those questions to their staff and the people who are experts there. But number three, I do disagree with it, and I think to answer your question truthfully and forthright, I believe the only thing that I have said to the board is that I don't have a substantial degree of confidence that this process will result in my bills being paid, and that there is still another branch of government that might have a say about that.
Okay. All right. Thank you for your respectful dialogue. Thank you.
And to follow up on my question a minute ago, so the Department of Corrections is paying, the Board of Corrections does not have an appropriation. And you may want to keep your comments a little succinct anyway, because the scope of work from your own letter of engagement does not cover paying you for appearing in front of a joint performance review for the Board of Corrections. So did you know that?
if you'd like me to take a moment to
Well,
read
no,
the engagement agreement.
obviously you did not know that because the way you answered my question earlier. So I'm going to defer to Representative Gazaway.
Thank you, Mr. Chairman. Thank you, Mr. Abton, for being here today. Couple of questions. I want to go back to how this all started. So it sounds like prior to the November 15th press conference, you were already engaging in talks with the Board of Correction. Is that right?
No, Representative Gazaway. On the November 17th press conference, prior to that, I had engaged in academic discourse with Lee Watson specifically and only.
Okay. What did that consist of?
As I said before, he told me about Amendment 33 and the concerns they had around Secretary Porfiry, former Secretary Porfiry, and was interested in if I had opinions about the incompatibility between the statutes that this body passed and the Constitution.
And did you have opinions?
I didn't know anything about it at the time when we first spoke. After he called, I was kind of interested, did some Googling, did some research. I spent a lot of time. It's more than you want to know, but my wife was pregnant, and this is my fleeting last couple months of time to be able to stay up late and to do these things. And so I was just academically interested and researched and read some material after that initial conversation.
Okay. And so you formed opinions, and I take it that you related those back to Mr. Watson.
Yes.
And you knew Mr. Watson, of course, was a member of the Board of Correction.
He identified himself as a member of the Board of Corrections, but to be more clear, he was, in my view, asking advice on how he individually should proceed given his more specific duties as an attorney. And so it wasn't, I think I understand the nature of your question. It wasn't to advise the board on anything. I think he was an interested, curious, the way it was presented to me, just seemed curious, seemed interested, and wanted to know if there was some collaboration that I'd be willing to have with him in that dialogue.
Okay, so you've represented entities of this state before. Is that correct?
Correct, yes.
May still represent them now. Do you represent other entities of the state now?
I don't want to get into any client confidences.
Okay, so you put in the certification that you submitted along with the contract, the services agreement. There was a mention that your firm represents UAMS, ADFA, and then you're advising the Board of Corrections. Is that correct?
Correct.
Okay, so, I mean, just to break this down, so you're a licensed attorney, obviously. You kind of cast yourself as a law professor, but
I don't mean to interrupt you. I don't mean to paint a false picture. I'm an adjunct, and I get paid, I think, like $2,661 per semester to teach a 3-hour class.
What class do you teach there?
Employment law.
Okay, so you teach one class at the law school, but otherwise you're an attorney engaged in the private practice of law. Correct?
Yes.
You routinely, and your firm represents entities of the state, correct?
Different branches or entities or boards or bodies, et cetera, yes.
Okay. You have a member of the Board of Corrections who's coming to you asking you questions about Amendment 33. You're formulating opinions, doing research, and providing him answers. And you do, and the way I've heard you couch it thus far is that you did that as this purely academic exercise because you are, of course, a law professor. I mean, do you understand how absurd that sounds when you represent other entities of the state and you're contacted by a sitting member of a state board for advice about issues involving state government? That this was some academic exercise as a law professor? I mean, would you have us believe that?
Yes, because it's the truth. It might not be the answer that you want to hear, but that's the truth, Representative Gazaway, respectfully. I'm not here to paint, and when folks call for those types for advice, I generally want a retainer agreement. When folks call to collaborate and discuss, and at that level, which it was, because I obviously was well aware that he couldn't hire me, had no authority to do so. The board would need to make those decisions as a collective. In that way, very much so, it was my choice to invest my free academic time into that process. I care deeply about employment law issues. I'm kind of a nerd about it. I think it's the most important area of law. And I was fascinated by the discussion. He didn't give me research assignments and ask me to research questions for him. It was more about getting caught up to speed to understand the nature of the Board of Corrections, its history, and the foundation of Amendment 33. So I don't want to misrepresent to you what those initial discussions were. I viewed them as very academic. And if I don't know that I can answer it another what I felt in my heart and soul.
So when you think about the formation of an attorney-client relationship, I mean, you have someone who's asking you advice, you're providing them with research and opinions. Do you believe that you formed an attorney-client relationship?
I didn't provide advice or research. In some ways, perhaps that could be more of I understand what you're saying, certainly more of a concern if you're dealing with a layperson. But Lee Watson is a very well-practiced attorney and has a substantial degree of experience. And so in some ways, for instance, and I won't go into it, but Representative Yazaway, I could contact you and ask you and engage in ethics consultation advice, and that would be a perfectly reasonable thing that does not create an attorney-client relationship.
I just wanted to get your opinion about whether or not you believe in this instance that you formed an attorney-client relationship.
I believe my relationship with the board was formed on December 8 after they executed my contract.
Okay. I have a few more, Mr. Chairman.
Go ahead, please.
Appreciate the latitude. Thank you. So it sounds like there was some continued communication that occurred in and around the time of the November 17th press conference. Is that right?
Yes, between
you and members of the board?
No, between me and Lee Watson.
Okay. And what was that about?
It was about, number one, the press conference. I've never seen a lawyer, for instance, go on TV and blast their own client and said there were failures. As a matter of legal ethics, Mr. Watson and I had several discussions about the Attorney General's misconduct in that respect. And so we had several conversations about that. And then those conversations continued along those lines because the Attorney General was quoted several times in the papers after the fact, before December 8, castigating his own clients again. And so we had more conversation about his legal duties as a lawyer under Rule 8.4 to report misconduct to the Office of Professional Conduct.
Okay. So once again, it sounds like you're providing some kind of legal advice to Mr. Watson.
Not advice at all. Mr. Watson is a lawyer in his own right. I think he wanted a sounding board, and we engaged in those discussions.
Okay. I guess, let me get to the point. What's really hard for me to understand is you supposedly were hired on December the 8th, right?
Not supposedly. I was hired on December the 8th.
Okay. You were hired on December the 8th, according to your testimony, and you billed over 8 hours drafting, or 6 hours drafting a complaint on December the 8th.
Yes.
So Mr. Magnus testified earlier that you were just hired to give them employment law advice. And on the very day you're hired, following a 3-minute public meeting, you're drafting a complaint and spending 6 hours on it.
So if I could say two things. Number one, on the 3-minute meeting, I have nothing to say about that. That's the board's deliberations. My understanding is that they had months of internal discussions, appropriate executive session discussions regarding Joe Porfiri's employment. And so it wasn't just, I think we're not writing on a blank slate. That's one point that I want to make. Number two, I stayed up very late that night because I expected that this would get hot quickly. Chairman Magnus identified a constitutional crisis. In my research process, I wanted to become more familiar with the specifics. And so drafting the complaint was, it could be called research. It was the document, the ultimate production or the ultimate work product they ultimately created based on the expenditure of time that day. But I left that meeting and I went to my home office and I worked. I didn't see my wife that night. I worked up until, I think, frankly, past past midnight. So every minute of my time and my team's time that's represented on those billings is accurate, and they were justified. We spent an inordinate amount of time on nights, weekends, working on this. One of my associates, from December 8th onward, took only Christmas Day off. The day my daughter was born, on December 28th, I was working from the hospital for the board. And the day I took her home from the NICU, on January 4th, I was in court. I left court and went and picked my wife and daughter up from the NICU and drove them home. Every minute.
And excuse me, Mr. If we could do away, your daughter, the hospital, the NICU, and all that, it's not relevant to the discussion. So just answer Representative Gasaway's question and then move on, okay? We'll get through this a lot faster.
Respectfully, Joe Barry, I will do my best to do so. It is relevant to me. It is my we're talking about the expenditure of my time, and I want you to know that every minute was accounted for and appropriate.
Okay, look, and I appreciate that. If this were a trial, I would object that your answer is not responsive to my question. However, we're not. The point is, and the point that I was making was that it seems as if there was very little discussion when I listened to the testimony prior to December 8th when you were hired, yet on December 8th you're spending 6 hours drafting a complaint, which I find hard to believe could happen unless there had been, in fact, extensive discussion about what the subject of that complaint would be, and so on and so forth. And I'm not interested in your opinion in that. That's the statement. And I just find it hard to believe, and I'm entitled to that opinion. So that's one. Let's go on to the contract and the markings that were made on the contract that was submitted to the state. You made markings on a standard form agreement that was submitted to the state for this services contract regarding sovereign immunity, didn't you?
I'm sorry. My contract is December 8th, and I want to be clear about the terminology, Representative Gasaway, and I'm trying to answer your questions as respectfully and as directly as I can. My contract is December 8th and December 22, the engagement agreement and the supplementation to it. On March 5th, late in the evening, and really on March 6th for all practical purposes, I get this document, and I'm told to sign it. I looked at it, and I had a lot of questions that I heard all of you ask too. What RFQ? What bid? What are they talking about? These are things that didn't make any sense to me. And again, like I said, I've represented the state in every branch of government before. I've never gone through this process ever. It did not make sense to me, and I did not want to misrepresent anything to anyone. When I received that document, I was in the middle of union negotiations that day. I took to leave that to come deal with this because I was told it had to be done that day. And I had a lot of questions about it. And I had, more than that, a lot of problems with what it said. For instance, the defendant, the Department of Corrections, was initially labeled as the party that I would be engaged with. They're a defendant. I cannot represent them. They would be the person who'd be approving the billings. I've never heard of the defendant getting to approve the plaintiff's attorney's billings. And on the changes that I made, I want to be very clear about this. My engagement agreements did not reflect or recite a waiver of sovereign immunity. What I made edits to, the revisions, they're not alterations, nothing that was submitted to I don't know what was uploaded to the portal or by whom. I got a document to sign, I made edits to it, and I sent it back in. That's a standard practice for an attorney, but what I wrote, let's be clear about what I wrote on the document. I wrote, if applicable, next to sovereign immunity. And it's really not up to us or to any lawyers or to anyone to suggest, you couldn't, let's just say, Representative Gasaway, you agreed with me that we shouldn't have sovereign immunity apply here. We could have any contract that says that. It will not matter because the Supreme Court ultimately gets to make that decision. What is unique here is that, again, for sovereign immunity, it's a vestige of monarchical tyranny. And so it's the idea you can't sue the king. Well, this is a lawsuit between one constitutional body and other constitutional officers. So I don't know whether sovereign immunity really applies here. And so I thought, if applicable, is a fair compromise that didn't really alter or change anything. It either applies or it doesn't, and we could agree or disagree all day whether it should or shouldn't. At the end of the day, the Supreme Court makes that decision.
Okay, the question was this. This is a standard State of Arkansas services contract that is submitted in instances like this. It's a standard form agreement, and you made your own markings on the standard form agreement that was submitted through this process, didn't you?
Of course.
Okay. And some of those relate specifically to the issue of sovereign immunity, as you've discussed. And your markings were if applicable. And so I guess my question to you is, do you not believe that the court has answered this? I mean, question very clearly about sovereign immunity and the state's inability to waive sovereign immunity?
I don't think the Supreme Court has ever addressed a situation quite like this one, where the statute, there are two things. If you really want my answer, there's some nuanced legal understanding to it. I was trying to get to it, but
let me ask you this. Are you familiar with the Andrews case?
Yes.
Okay. And you know, in the Andrews case, the Supreme Court quoted specifically, "We conclude that Nelson Brothers, Fairbanks, and the Arkansas Department of Human Services are the correct precedent for this court to follow in its conclusion that the General Assembly cannot waive the state's sovereign immunity pursuant to Article 5, Section 20. To the extent that other cases conflict with this holding, we overrule those opinions. Further, this court has held that suits subjecting the state to financial liability are barred by sovereign immunity, and plaintiffs like Andrews with these causes of action, quote, have a proper avenue for redress against state action, which is to file a claim with the Arkansas Claims Commission," end quote. That's clear. That's existing Supreme Court precedent involving a board and an employee. That seems to be clear. Is that unclear in some way?
Representative Gasaway, I don't know that I'll change your opinion, but I'd like to explain mine, if I could just have a moment to do so. Number one, Andrews has been walked back a bit. Number two, this is a unique situation involving an intergovernment fight between two different branches of the government. And so the idea of sovereign immunity has a unique, it's just a question that's never really, to my knowledge, been answered. Number three, the statute, 711, says shall be paid a reasonable compensation. That question has never been answered by the Supreme Court. I think it's something that we need to understand whether in this intergovernment dispute, the Andrews position, which has been walked back by multiple decisions since then, would continue to apply. And the final part of this that I want to make clear is, and if you can refer to the Attorney General's opinion letter 2007-007, and it stands for the proposition that with respect to constitutional bodies under Amendment 33, while the legislature controls the power of the purse, that is to a point. And so I think the Attorney General's conclusion in that opinion is that you couldn't, for instance, completely defund the University of Arkansas. And by extension, the legislature wouldn't have the authority or the power to completely defund a constitutional body in such a way that would prevent the Constitutional Board from exercising its constitutional duties. That's effectively the thesis or the premise of Representative Westerman's lawsuit involving the rates of congressional pay at $174,000. In the same vein, Representative Gasaway, if you accept the premise of the 2007-007 opinion letter, if the legislature can't accomplish directly the defunding, it can't indirectly, the Attorney General opines that it can't indirectly accomplish the same ends. And so, for instance, if a procurement rule or a statute that says the Attorney General represents everyone would apply to such an extent that it would impede on the board's ability to perform its constitutional duty, then I think that there is a fair argument that sovereign immunity wouldn't apply there either. And again, these are very nuanced legal issues. I was attempting to maintain the status quo, and just that, if applicable. And so I don't think that really changed anything. The choice of law provision of the engagement agreement said that Arkansas law would apply without respect to conflicts of laws issues, and I think that that's consistent. I think the revisions I supplied to the ratification document on March 6th are completely consistent with my engagement agreements. All right, that's all. Thanks.
Thank you, Representative Gasway. And I believe it was Rick Crawford in the lawsuit, not Bruce Westerman. Is that correct?
After I said that, I'm so sorry. You're right.
Okay.
I'm sorry.
Senator Gilmore.
Thank you, Mr. Chair. And I want to circle back to that too. I mean, that sort of is a big misspeak in invoking a sitting congressman who didn't file a lawsuit. So thank you for clarifying that.
To Representative Westerman, please accept my profuse apologies if you're listening to this. I did not.
Yeah, and that's federal litigation as well. So, we've heard throughout this discussion that you did alter the contract. You admitted to that.
No, sir.
No to what?
So, Senator Gilmore, a contract, as you heard earlier, requires offer, acceptance, and consideration.
Okay.
At that point, what I had a contract. That's on December 28 and December 22.
Well, that was an engagement letter.
That's a contract, sir.
Respectfully, it's an engagement letter, and you called it as such in some of your testimony.
An engagement agreement is a contract, Senator Gilmore. What I received on effectively March 6th, was an effort, I believe, driven by the defendant to change the terms of the agreement to which the board and I had already entered into. I didn't make changes to a contract because there was no signature on that contract at that time. What I had was a proposal, an offer, and I made a counteroffer.
Was your client aware of that?
I think you heard testimony from Chairman Magnus that he did review the revisions I supplied. However, this is a unique circumstance where, again, the defendant in this case, the Department of Corrections, is attempting to tell us how to get on with the engagement. I want to, if I could, just clear something up.
Well, if you would just answer my question, if you don't mind, please.
So, I forwarded the document to. If you read my email, it's very clear.
I have, yes.
I forwarded it to Ms. Gray and asked her to send it to Mr. Brown, the defendant. It is not my duty, as I believe Senator Dismang said, to educate Mr. Brown or anyone else about procurement law. And I would have expected that Mr. Brown would have, read what I sent. And it was very clear. I think the starting point of this case is to receive a document back to conform to the provisions that I had.
Edited by the defendant?
Whomever is guiding this process, who's telling us to do it, by Office of State Procurement, whomever is involved. I knew very little. I got an email on March 5th, late in the evening, really read it on March 6th, told me to sign this thing. That's it. So I don't have much insight into this procurement process. But I did not alter a contract. I made...
Well, I'm sorry.
As a practicing lawyer, I revise and counteroffers frequently, and that's what I did here. I did nothing different from my standard practice.
Okay. If I may, then explain to me the difference, if you would. I'm not a lawyer, so I'm not a sophisticated party in these instances. What is the difference
between
altering or not altering?
Altering,
because if I may, you do admit to adding text into the standard services agreement which signed supersedes all other agreements.
Right. And so altering something, I think the focus of the word, I don't mean to get semantic with you, you mentioned a contract. Again, the contract is the offer, acceptance, and consideration. I made counter revisions to a standard form document, which I do all the time, in a way that I intended to not gain any advantage or change any of the status quo, to simply maintain the status quo because there are very complicated constitutional issues undergirding all this. I did not want to damage the board's position in any litigation by this document.
So, having said all that, there were changes made to this document, which you, I guess, anticipated your client to review.
I anticipated before my client would review it. The Board of Corrections, they're experts in corrections. They're not experts in procurement. They have people for that. And so I expected those people to do their jobs. And so my email was a notification to them of the document that I had sent.
And what did your email state?
I can read it to you if you'd like me to.
Please.
I believe it said, please see attached.
Okay.
And
I believe that's what it
please-
said as well.
And then please send this to Chad Brown.
And I believe that's what it said as well.
And I didn't want to move from a ministerial discussion about, let's say I'm suing the Department of Finance Administration. I still feel very comfortable from an ethics perspective going to get my license plate tags from the Revenue Office. That seems reasonable to me. In the same way, when Mr. Brown called and asked me what number to put in the fee section, I felt comfortable providing that ministerial answer, which was $200,000. I did not feel like it would be appropriate ethically for me to sit and provide a substantive legal explanation to Mr. Brown without the Attorney General's discussion. And frankly, my suspicion is that the Attorney General was telling Mr. Brown what to do the whole time and very much involved in it. And so I didn't want to cross any lines. And so I thought from an ethics perspective that the most appropriate thing to do would be for me to send that email as it was. And I expected that I'd have an opportunity to call Mr. Magnus or anyone else before anything was signed. I did not appreciate that there wouldn't be an opportunity for Mr. Brown to submit a finalized execution copy or something else. And I certainly had no idea that Mr. Brown or whomever uploaded anything to this portal to the portal for this body or any other body to review. In my view, we were still engaged in that discussion.
All right. So if I may get back to the question here. So your duty, you're right. I don't think your duty is to explain to Mr. Brown, quite frankly, anything, given the circumstances that we're dealing with today. I think your duty would have been to explain to the board members that you purported here to represent. You didn't do that by all indication what we have in writing and email. If that did take place, how, when, and where?
It did not.
Okay.
At that time. Since then, there's an email that I think you already also have.
I've read it.
That has that provides an explanation.
And I heard your explanation at the board meeting as well, where you talked about a lot of things. So is there not some duty that you have then to articulate or to lay out the reasoning at the time you send the contract back with substantial edits, even edits made to areas that are, quote, non-negotiable in that service agreement, things that, quite frankly, are not editable in the document?
Non-negotiable to whom? I get standard term contracts all the time that say non-negotiable, but by the end of the day,
we're talking about, respectfully, sir, we're talking about a document that's there to protect the people of Arkansas and the taxpayers of Arkansas.
And again, you heard Representative Gazaway describe the Andrews case, where whether the contract says we waive sovereign immunity or not.
So you agree with Andrews?
No, because the Supreme Court's walked Andrews back a bit since then.
Okay. So have they walked that portion back?
I don't want to misspeak. There are aspects of Andrews that have been addressed, but more than anything else, Andrews did not address any case like this one, where it is an intragovernment dispute. And to be more frank, I think this is an important discussion, and that's why I'm here to answer your questions. And I'm trying to.
And I appreciate you being here.
But this is something that has happened once this century, and twice, to my knowledge, twice in the last 100 years. The last time an Amendment 33 action was filed was in 1995 by the University of Central Arkansas.
And if I can, let's get back to the contract. So
the procurement document.
The service agreement.
Okay.
Yeah. The one that once signed supersedes, per the terms of that agreement, supersedes any other agreements. That's what the document says.
I think until or unless, I think the board certainly could vote to nullify that document, and I think the parties could agree to do so and just stand on my engagement agreements, and I think that that's something that could also be done. So retroactivity or future application, those are things that can be addressed between the parties and the allocation of liabilities, et cetera.
Okay. So you agree, I guess, clearly that moving forward, because you've mentioned 7-11 quite a bit, you've mentioned Amendment 33, all of this clearly being litigated. So, I mean, I presume then you agree with Judge James's order when she says that Amendment 33 created the Board of Corrections.
Of course, it did. So I hear, Senator Dismay, I hear what you say, and I heard the answer whether the legislature created the Board of Corrections. I think I understand what you're saying.
No, real quick, let's get back to it, because you answered my question when I said what Judge James said, and you said you agree.
I agree with her order.
Fair. Thank you. That's all I ask.
Senator Hammer.
The one thing I'm trying to get my mind around is when you said, and by the way, I hope your daughter's doing well. I don't ever want to be, I hope she's doing well and your wife's doing well. The one thing I guess I'm trying to get my mind around is if the first thing you had to do was go into research mode, given your history of dealing with multiple government entities, what made you, in your opinion, more qualified that you would be the one that would be hired without interviewing any other attorneys by the board?
I can't speak to the board's deliberative processes. I'm not certain that I understand your question about what made me more qualified or going into research mode. The research mode was on more ancillary issues, such as whether there'd be an ex parte temporary restraining order, or a preliminary injunction which requires notice to the parties, or whether it'd be such a motion at all, or more strategic issues surrounding what types of motions or under which rules we would proceed. And so those are more, what would constitute irreparable harm that was imminent. Those are the types of issues and things I was looking at. But as far as what would make me more qualified, I can only just recite my experience. I've been hired by numerous bodies of the government to serve as their special counsel. And I think this body is certainly aware of that. And I think that's a question that I would defer to Mr. Watson or my own experience and resume.
Okay, thank you.
And Senator Dismay.
Thank you. And we can just go through some yes or no's. And I do appreciate some of the discussion, though, the fact that you were suing the board, or you're suing a department that then was going to be compelled to then pay you to sue the department. There's some really interesting gymnastics in seeing how that would work. I'm disappointed that Mr. Watson or someone with the board didn't advise that didn't have their own appropriation to even follow through with payment before they solicited your services. But back to the solicitation of services. So Mr. Magnus was very clear that he had charged Mr. Watson with hiring an attorney, not to go out and have conversations about, what do you think about this, or what do you think about that, or hey, there's this adjunct professor over here that's going to be really engaged, want to do things for us because we're right down his alley for free. He said he wanted to go hire an attorney, right? And this happened several months, which follows pretty well with the timeline. So this isn't your conversations, these were his. And so I'm going to go through the timeline and just ask a simple question on each one of these dates, and it's just yes or no. And the question is, did y'all have a conversation about bringing you on as an attorney? Okay? The initial meeting, November 9th, 2023, was there any discussion about hiring you?
No.
Okay. And then we went to the 17th. There was a couple of phone calls in between that. Was there any discussion about hiring you on November 17th?
No.
Okay. And then we go to November 20th, which if I'm reading my notes right, was that the day of the press conference?
No, November 17th is the day of the press conference.
Okay.
November 20th is the date on which Chairman Magnus issued his letter in response to that conference, and no.
And in that conversation, even though you were helping kind of draft up a response, they had not advised or asked you to. So far to this date, even though well in advance of this, Mr. Watson was charged with trying to find you to hire you, he had never mentioned that the board wanted to bring you on as an attorney.
To my knowledge and my recollection, no, Senator Dismay.
Okay.
I don't think there's any discussion of that. I think that frankly ratcheted up after. I think, to be frank with you, I think the board was hopeful that the governor would be able to help calm the seas with all this. But to be clear, this is not a fight with the governor. I think this is just an internal employment issue with Secretary Porfiry. And my recollection was that after November 20.
Because I know that your time's valuable, and I just want to get to yes or no.
After November 20 is maybe when I think December, I don't know if it was like December 5, December 8, whatever date that
sometime pretty So maybe a few days before the December 8th meeting, Mr. Watson finally disclosed, hey, I've been using you for free so far, but we're probably going to have to hire someone. I've been supposed to hire someone for a while. Would you like to come on as our attorney?
That's certainly, no, that's not the conversation. No.
Did he ask you? So you're saying, so on November 5th, he asked you to, would you look at representing us, or can we get a copy of the engagement letter?
I don't think I'd ever spoken to Mr. Watson by November 5th.
December 5th.
December 5th. To be frank with you, and I'm trying to answer your questions yes or no, I very well may have just printed an engagement agreement and said, here, if you guys need this, here it is.
Oh.
I don't know that he actually solicited one from me. I just said, here, it's more of like a discussion, like this is what mine would look like if you have other alterations to it, et cetera.
So Mr. Watson didn't ask you at any point to come on as the attorney. You asked him if maybe these things are getting complicated enough, I should come on as the attorney.
There may have, and again, I'm trying to answer, to my recollection, there's a lot happening then. It may have been we may have kind of jointly reached that discussion point, but I remember giving him a copy of my engagement agreement. This is what it would look like.
But he may not have solicited it. You just gave it to him. I said, hey.
I would defer to Mr. Watson's memory on that.
Okay.
I truly don't recall if he solicited it or not, but I know that I was thinking that I just didn't know how they could. You've got the Attorney General yelling at you on TV. I didn't know what they were supposed to do with that, and so I thought they'd need counsel.
I mean, and the first thing, and unfortunately, and I wish they'd advised you, they don't have an appropriation to even pay you. And then you turned around and sued the entity to pay you, that they're using for the vehicle to pay you, the Department of Corrections. The board, who you only represent, you've made very, very clear today that you do not represent the Department of Corrections, and in fact, you think they're in cahoots with the Attorney General and probably working against you in some ways, or the board.
I wouldn't say cahoots. They're represented by the Attorney General.
Exactly, which then puts us in this weird, realm that we're in. But, you do not represent them.
100%,
right?
I do not represent them.
And so the contract that was going back and forth, even though they had charged Mr. Brown and Mr. Watson, by the way, you emailed it to him to ask him to review it too, or here it is. I think he was one of the ones that were CC'd, if I remember the email correctly. But even to your own point, you wouldn't have expected Mr. Brown. I mean, the contract was never between Mr. Brown and the Department of Corrections and you. It was between the board and you, which they didn't have the authority to create.
So Mr. Brown was given a directive, I believe, on January 22 by the board. I could be wrong on the date, January 25, whatever day that meeting was, to do what he was supposed to do in getting the bills paid. And so he reports and is answerable to the board, which is obviously kind of the underlying issue here.
So, and we're going to have these discussions about Amendment 33, and this is really for the board as we move through and have these conversations. I mean, you hired an attorney that you didn't have the authority to hire with money that wasn't yours, and then turn around and sued yourself, which then complicates the whole issue of Amendment 33 and independence and what that's even supposed to look like or mean. But with that, I appreciate it. I think that what I'm going to take from this as we move forward is that you're actually the one that, well, we'll wait and talk to Mr. Watson, but you may have been the one that actually solicited the want to represent the board in these matters, turning around and suing the state of Arkansas Department of Corrections.
I don't know that I would use the word solicitation. I think it was like, it's pretty clear this is getting hot. This is a copy of my engagement agreement. This is what it looks like.
Which is soliciting. I mean, that's what, I
didn't solicit Lee Watson for anything. And Lee Watson can't do anything on his own. I merely provided information. This is what my contract looks like.
Okay.
Not a solicitation.
I'm not an attorney, and there's some nuanced reason you've answered that question that way, but I will find out why. Thank you.
Just to be accurate.
So, and I'd be very interested to see where you're going to get that $200,000 from as time goes along. So, Senator English.
Oh, thank you. So you had talked a little bit about the fact that you represent you work with a lot of different state agencies, UAMS and ADFA and all that.
The disclosure is that my firm represents UAMS and ADFA. I do not represent either of those entities.
So I guess my question is, each of those agencies has a general counsel And it's my understanding that the Attorney General's office is supposed to represent them. In what capacity would your firm be representing UAMS or ADFA or any of these other state agencies? In what capacity?
On specialized legal issues, for instance, immigration compliance matters, the best immigration attorneys in the state are Misty Borkowski and George Ernst, and they are my partners, and they do a lot of immigration work to help bring talent to Arkansas.
So when you do a contract or your firm does a contract, do you have to go through an RFP process before, and your firm applies for those contracts?
Senator English, and as someone, as your constituent, by the way, just appreciative of someone from North Little Rock here. I want to answer your question, but be clear about it. Yes, absolutely, we respond to RFQs frequently, and that is the method through which we obtain that work, where the Attorney General is supposed to be the default attorney. I'm not suggesting, well, I do believe that it would be helpful to the bar if the legislature clarified 702 and 711. It's been a long time since I've been given a fair look, but to be clear with you, 711 says when a constitutional officer has a disagreement with the Attorney General about the application of a law to it, they're allowed to hire special counsel and resolve the matter by litigation. And so the RFQs aren't where we have a disagreement with the Attorney General about the application of a law. It's to support and assist the Attorney General, given our unique abilities and specialties, so that we can do the work of the state, so we can bring these employees here. And so that's one context. In other contexts, and again, I don't want to name specifically which entities I personally have represented, but I know several of you know at least one of them. And again, I can say that I've worked with each branch of government. And in my experience, I have not received that work through an RFQ process. I didn't go through an RFQ process to represent, I'll just leave it there. I didn't go through an RFQ process in each of the instances in which I've been hired to represent different arms of the government.
So that's typically how we do things, is we issue an RFP, and firms would answer that. So what you're saying is that you are working with a lot of state agencies in almost exactly the same format where you just get chosen. Is that right?
I can't explain to you
I'm
why.
thinking we're all sitting in this room here, and we kind of know what the process is. So I guess my question is, does somebody just arbitrarily decide at ADFA that you're the person that they need and they hire you?
I wouldn't say it's arbitrary. I would say it's based on my experience and abilities.
But aren't there a whole lot of other lawyers probably with good experience and backgrounds? So, it would seem that's kind of the process I thought we use, is that we it's what we do here in the legislature, to make sure that we are allowing other folks to come to the table and give us their qualifications.
And I, in the interest of...
My question is, have you ever done a contract with any other state agency that looks like this? Have gone through this process?
Oh, no, I have never done a contract with a state agency that has gone through procurement, but I have gone through several. I've done a lot of work using a nearly identical copy of my engagement agreement for multiple government branches. And I'll leave it there. I don't want to say more, but if you know what I'm talking about, I can confirm, but I'm not going to volunteer that information.
Okay, I have a hard time understanding how, if you have been working with state agencies before, you would not understand what that process was, and you would automatically think that this process that you all have been going through is appropriate, and that there is no RFP process, or we're going to talk to a lot of different people, or anything like that.
In certain circumstances, my understanding is that when the amount or the anticipated amount of the agreement is below a certain threshold involving professional services for constitutional officers, a different set of procurement rules apply. That is my understanding, but I would defer in part to, I would almost want to ask, I'm not sure if Director Garrity is here, but I'd almost want to ask her. I don't know. I don't know what process would be followed in every case, but I can tell you that my process with the board has been consistent with every other instance in which I have been hired by a similarly situated arm of the government.
So we might say the Attorney General's office, or we might say the Secretary of State's office or the Treasurer's office, but not the Department of Finance and Administration?
So
there's a difference there between those agencies or those constitutional offices and what the process is with the Department of Finance and Administration?
I believe the procurement law makes a delineation between constitutional officers and departments. Constitutional departments, I think, is the term used in the legislation, and non-constitutional departments. So yes, to answer your question, the Department of Finance and Administration hasn't been tested yet, but I actually think it now might be a constitutional department, given Amendment 98. But neither here nor there. I don't think anyone anticipates it or construes it as a constitutional department. So a different set of procurement rules would apply for DFNA than it might apply for the Secretary of State, for instance.
But having worked with a lot of different state agencies, I would assume that you would understand what the process was there, and you probably think in your firm's mind that this is the process we're going to have to go through in order for our firm or you to be hired by some agency, whether it's a constitutional office or whether it's a state agency.
So yes, in the ordinary course, let's take the immigration work, for example. In the ordinary course, I think there's like some yearly procurement, an RFQ, and a response that is provided. That's standard where it is not involving a constitutional officer or office or department with a disagreement involving the Attorney General. In those cases, the Attorney General signs off and approves our hiring. In this situation, what I want to say, and I don't know if it's answering your question, but what I'd like to identify is that there was an emergency. On December, I believe it was December 11th, the governor gave a directive to Secretary Proferi to open additional prison beds up. And that, coupled with Act 659's effective date of 1/1/24, and the need to get the litigation served, required an emergency action that didn't leave an opportunity for this RFQ process or an RFP process. I cannot tell you who else the board...
Who made that decision, that was an emergency?
I believe the board did on December 14 when they voted to tell me to file suit.
Well, I think we have some real questions. I have some real questions in my mind that the process and how anybody could think that this process was okay when this is not the process we use with everything else. So thank you.
Thank you, Senator.
Thank you, Senator English. And Mr. Medezadigan, what cabinet level secretary agencies have you represented?
I don't feel comfortable answering that question.
We're the ones that pay the bills. I'm not asking you any specific litigation. I'm asking you what secretary, cabinet level positions have you provided services for?
The executive subcommittee of the ALC.
And?
Others that I'm not comfortable disclosing.
Okay. All right. Senator Petty.
Thank you, Mr. Chair. And I want to I'm just going to make a statement. I understand what you're saying about this is a unique situation, but I'm going to go out on a limb here and say that the vast majority, if not all, of your previous work has gone through this, and it may be as simple as an attachment, but somebody from your firm probably signed the agreement at that juncture for those contracts.
I can affirmatively represent to you that in some of the work that I've done for different branches of government, no one in my firm has signed a document like that in the work that I have done. I am certain, and I'm certain for the UAMS work or the immigration work, those types of things that we have, I can tell you definitively that for the work that I have done, I have not. I've never seen a document like that presented to me for signature before. I didn't receive one from this body when I was hired to be its special counsel, or the ALC, excuse me.
Okay, and we could obviously verify that with staff here if we want to do that. That was just a piggyback. So a couple of things that you have said that kind of bothers me, and I just want to give you opportunity to clarify, and that is going back to the sovereign immunity. In the beginning, early on in your testimony, it was almost as if that was a nonchalant, almost irrelevant tenet of the law, the way I took it, because you were making these minor modifications, and that was not a big deal. And I just wanted you to clarify if that was your intent or if I just misunderstood.
Oh, I don't mean to say sovereign immunity is not a big deal. It is certainly an important issue. I am just not, I don't wear a black robe to work, and the people who do answer those questions. I don't. And so whether we all can sign some contract that says it's waived or it's not waived, the Andrews case says it doesn't truly matter what we say. It's really up to the courts to decide. And so that's why I thought if it maintains the status, if sovereign immunity applies, then it applies. But if it doesn't, then it wouldn't. And I think that's a question that the Supreme Court, a different branch of government, makes. And again, coming from a position of a constitutionalist, I defer to that branch to make those decisions. And so I don't take it lightly, and I appreciate the opportunity to answer the question. I do think it's important. I think it has substantial, critical applications in most facets of the law. In this one particular one, I'm uncomfortable making a statement about it because it's not my place. That duty is of the Supreme Courts to decide that question, and obviously we have active litigation involving it.
But at least in some vein, you question whether that would be applicable in this situation, and that's why it was even addressed.
So I think, to unpack it a little bit, what we have are two parties to the contract. Myself, for my firm rather, and the Board of Corrections. I would like to get paid for the work I've done, and they would like to pay me for the work I've done. And so I don't anticipate a necessary fight with the client where they want to pay and I would like to be paid. And so I don't anticipate sovereign immunity really being an issue here. I think the consistent position of the board is that they hired me to do work. I did a lot of it, as well as my team, and that they would like me to be paid for that work. And so I don't anticipate a fight with the Board of Corrections about paying me. They have voiced a desire to do so.
Okay, and so the sovereign immunity, and Mr. Chair, if you don't mind, I've got one more question here, or line of question, but the sovereign immunity applicability here is in terms of payment of your fees and not some litigation related to liability or anything else that we're opening up a big can of worms.
I think as a matter of contract law, it would probably be construed only to apply to a dispute between me and the Board of Corrections.
Okay, and so you articulated you don't wear a robe, and I respect that. And I'm not an attorney either, but I do think that where my next question or line of questions here does relate to where your expertise is, and it's in contract. And the other thing that you said that kind of bothered me in reading these, there was a disagreement as to whether this was a services agreement or the engagement letter or what controlled. Are you the way I understood your testimony, your engagement letter controlled your services. And that was the controlling document that you agreed with the board on for your services. But yet this document, this exhibit, there are two, one that was not signed and then one that you admitted that you had helped or added some edits on. Throughout the document, it says contract. It says contract. It says contract. As a matter of fact, it even, on one of the pages, you added to it at the top your engagement letter. So to me, and I'm not an attorney, I would think that this is going to become the controlling document with the supplement of your original engagement letter. And again, I don't want to chase a rabbit hole, but the fact that you said that this really wasn't a contract, but yet throughout the document it says it's a contract, and there were the staff, the procurement staff, we are pretty confident, and the report we heard from earlier says that they prepared it, but there was some substantial changes. For example, emergency. I heard you in your testimony talk about emergency. That was added after you added it.
If I could speak to that,
But
I believe the document that I received, I don't think anything in that box was checked. It was blank.
Actually, it says request for qualifications.
I believe if I saw that today, just when I was sitting here, I believe in the version that was sent to me, that part was blank. And it was there's a drop-down menu. I believe, it's my recollection. I could be wrong. I can verify that as soon as get out of here. But there was a drop-down menu. And again, if it did say RFQ, that's not accurate. That was not accurate. There was no RFQ. This was an emergency.
I got you.
And so
RFQ, blank or RFQ.
It has a contract number. It talks about a bid. It was all over the place with terms that I had not seen, nor had we agreed to. But I had been working for the board for months at this point, operating under my engagement agreement.
Did you strike the bid and the RFQ and the items that you had like you did sovereign immunity?
I didn't strike sovereign immunity. I also
edited the language in the non-negotiable section.
I wrote, if applicable. So I don't think it really changed the substance either way. I did, if you look at the documents that were submitted, I did email Ms. Gray multiple times that morning where I was supposed to be at the negotiating table for a labor agreement on behalf of an employer. Emailed her numerous times, 2 or 3 times, saying, what is this? Where is that? What bid? What RFQ? And the answers I got back were odd, but satisfactory for me in that there wasn't anything that was made up and it was just a placeholder. I think that's weird, but this is obviously an unusual process or proceeding. And, I expect these are issues that don't come up often because there's not much constitutional litigation of this sort.
Yeah. And again, just to clarify your previous testimony, you're saying this document that you signed is or is not a contract?
I think what we have heard is a repudiation by the board of it, and I stand by the board in that respect.
All right. So yes or no? I may have missed that. I may have stepped out. Repudiation, saying it is not a contract. They're just trying to get it before. What is it when it says contract throughout, and it gives priority of weight in legal terms of the documents to consider in disputes? But if that's all irrelevant, then we didn't need your signature anyway, did we?
Well, apparently not for something to get uploaded into the portal, because what was uploaded into the portal I had not seen nor had I signed. So apparently you didn't get my signature on it. Or if you did, no one asked me for it at that time. But to the extent that it says services contract, what I was trying to say is that the board came before the ALC under the pretense that it was a ratification request. And there was a ratification letter submitted to the ALC. That is what brought them here. Right before, I believe, the ALC met, they were told to sign this document. And I think you can defer to Chairman Magnus or Mr. Watson or Dr. Byers, I think their understanding was that this is just part of the ratification process. Mine was of the same variety. What I attempted to do is make this document as consistent with the terms of my engagement agreement and with the practice in which had been engaged for the months prior to receiving this document.
So clear. Last question, I promise, Chair. So clearly you read it. There were there were some things that you've referred to that gave you cause for pause. Clearly you read it. You're an attorney. You're paid to read documents, and it says throughout it's a contract, and you signed it ultimately. So you opined to everything that was written. Maybe you didn't agree with it, but you got comfortable with it. I just have a hard time understanding what the goal was by doing this if it's not a contract? It says contract throughout.
It does. The goal, as I understand the Department of Corrections from Chad Brown's statements and Dr. Byers' analysis, was to pay my legal bills. That was the goal. I understand that it says services contract, and I accept that. I don't want to disagree with you. I accept that it is an agreement. It is a contract. It is mutually signed by both parties. It identifies the substance and scope of the engagement. My effort in the revisions that I supplied while it was an offer was to make this document consistent with the engagement to which the board entered into with me, without changing anything in terms of how our legal arguments were proceeding at that time. And one other point that I'd like to make, and I heard Representative Springer ask this question earlier about whether the order was on appeal at the time that whether Judge James's decision in the Amendment 33 litigation was appealed. There's an annoying lawyer answer to that question. Yes and no. Yes, a notice of appeal had been filed, but that does not divest the Circuit Court of Jurisdiction. The act that divests the Court of Jurisdiction over most issues anyway is the lodging of the record, and that had not occurred. The state had not lodged, the Attorney General had not lodged the record in that case until after I had submitted this. And so at that point, when I had signed this document, all that stood was Judge James's order, and that's really still the case. So I did want to clear that up for you. But to answer your question, this is obviously, again, an unusual situation. My team spent a substantial amount of time working to advance the interests of the board, which I want to make clear here. We all took oaths to support the Constitution, and they're doing it at great personal expense as unpaid volunteers over this board. And whether we disagree or agree with the policy behind it, that deserves respect. They've stuck their necks out to do something that's important that my two kids will benefit from. I benefit from a state that supports its Constitution and enforces it. And I think there's value in that should be respected, and it should at least be acknowledged that these folks did not have to do this. The easiest thing to do would have been to do what they were told. But that's not what the Constitution says. And I think that deserves respect, just like the labor that my staff poured into defending the Constitution.
So, excuse me, is there an answer to the question there somewhere without all the editorializing?
I believe, I hope I answered your question.
He did. Thank you, Mr. Chair.
Okay, thank you, Senator. And Senator Hammer, okay. And how many hours have you billed the Board of Corrections thus far?
I am not certain off the top of my head. I believe what has been billed is approximately 337 hours as of my last look, but we're in the middle of actually an update in our billing system, so I couldn't, as of I think March, that number I believe is accurate.
Okay. And let's go to Representative Beatty.
And when I say billed, I don't mean to say me personally, I mean my firm.
Okay.
Thank you, Mr. Chairman. Obden, I'm here on this side. A quick question, my question's in reference to your March 12th letter to the Board of Corrections, I think an email, where you state, I guess in the closing paragraph, you look forward to clearing I quote, I look forward to clearing my name and answering any legitimate questions that the ALC or any of you may have. Do you feel that the questions asked by this committee are legitimate questions?
100%. I didn't mean to misread into that. Questions that I can answer is what I meant to say. A question that would not be unethical for me to answer.
All right. And then a quick review. You said you've represented other agencies in the state in the past, and a quick review of Transparency site does show several agencies that your firm's represented and billed for legal services. Have you ever signed an engagement letter with a board that does not have a budget or appropriations to pay your legal fees?
Until
now.
Want to answer your question. I don't know that I accept I don't want to disagree with you, Representative.
Oh, you
I'm not
can.
trying to
A lot
make-
of them do.
There is a statute, for instance, that allocates the board the power to hire a compliance administrator who happens to be an attorney. And there is an appropriation for the board to do that. And so the board does have an appropriation, as I understand it. I could be wrong in terms of kind of ordinary parlance, but there is a statute that authorizes the board to hire, and and it specifically says the compliance administrator reports to the board, and the appropriation has a position for the board to hire that person. So I do believe the board has an appropriation. Or the inherent, to be more clear with you, if the board is responsible for the entirety of the Department of Corrections, then it oversees and sits in judgment of the Department of Corrections and has superintending control of the department's appropriation.
Well, again, your letter, you kind of foreshadowed exactly what we're looking at here, where you state that you're not going to be surprised that the same legislature may be looking for reasons to avoid paying a legal bill.
It doesn't surprise me. Again, this is an appropriate illustration of the balance of powers the people of Arkansas chose. Your job, and you're doing it well. I do not begrudge any of you, and I respect all of you for the public service that you do and the positions that you're taking. I have no grudge with any of you, and I appreciate the questions, and you're doing your job, which is to be this branch of the government. I challenge the law that you passed. It would not surprise me that you might be frustrated about that. It is not my intent to frustrate. It is my intent to do my job as best I can with the best team that I have behind me, and to support the Constitution. I read my oath as an attorney frequently. I think more attorneys should, and some of the provisions of it. Do not turn your back on the defenseless or the oppressed. I'm not suggesting the board's oppressed, but they're defenseless when the Attorney General is chastising him at a press conference with the legislature, with the governor. Not to turn our backs on causes that might bring us into positions like this, where I'm hitting articles in the Democrat Gazette, having this intimation of some type of untoward conduct, when all I did as a lawyer was edited a draft of an agreement and sent it back. But that's your job to do this, and I respect it. And I appreciate that you're doing it, and y'all are, again, doing it well. I don't want to misread, and I appreciate the question you asked. I don't want anyone to misread my email to the board. There are legitimate questions that I can answer, and there's some that I simply can't. And so that's all I meant by that. And again, it wouldn't surprise me, given all of the media surrounding this, that y'all might not want to pay my legal bills. I would ask, and I don't think I'll change any minds here, I would ask that y'all give that fair consideration. There was a lot of time was spent on it, and I don't want to say look at the scoreboard, but we've won, and we've won consistently. And I say all that in suggesting this: there is an easy path to de-escalate. All that we should do, a meeting with a representative from the governor's office, from the board, and from the Attorney General's office, and myself, I think would get all of this wrapped up. And I have been begging the Attorney General to meet me at the table to do that. I hope that they take that invitation at some point, because we can save the taxpayers dollars, and my staff can get paid for the time they spent doing their jobs.
Okay, Mr. Beatty, did he get your question answered?
I did. I want to appreciate you for clarifying your comments in your letter and for your testimony today. Thank you.
Thank you, Mr. Beatty. Mr. Gasaway.
Thank you, Mr. Chairman. Mr. Abton, I do want to take a little issue with something that you said. I mean, you sit there and act as if the if applicable is just a simple edit that was made in the regular course of submitting edits to a contract. This is not a normal situation, as you've acknowledged. You said once in a century. It's been a matter of public concern and controversy. This is a pretty big deal. Wouldn't you agree?
Yes.
And it's not just as simple as making, again, edits in the normal course of business. What you did was you made an edit
on a portion of the contract that specifically says non-negotiable in red. This provision is non-negotiable. Now, I suppose if you're just making edits to the document, you could make edits to any portion of this. It's either all editable or not editable. And this says non-negotiable. In other words, this is not up for negotiation. You didn't amend lots of other sections of this, but you did amend that one. You did edit that one. And you edited it by adding if applicable. Now, why would you edit that section to the exclusion of the others? Well, it just so happens that the issue regarding sovereign immunity affects whether or not you may be able to get paid under this contract. And that's why you edited that portion of the contract, isn't it?
No, if I may, Senator Gazaway, Representative Gazaway, excuse me. If I may, any time where there was a reference to a statute that I didn't have time to research what it meant or to understand whether or not it applied to constitutional officers or constitutional departments that have special procurement rules, I wrote if applicable. And so I did that on page.
Okay, let me stop you just for a second. So, if we were to go through this contract, we could say where you get to the provision about governing law, choice of law and venue, if applicable. There may be some legal theory out there that would say some other law should apply. There may be some legal theory out there that would say maybe Pulaski County isn't the best venue for this because these actions were taken in another county. You could have added, if applicable, to that provision. The intergovernmental cooperative use about the state procurement unit may participate in this contract and participating addendum signed by the contractor and approved by the chief procurement officer. You could have added, if applicable, to that. Disclosure required by executive order. You could have added, if applicable, to that. You literally could have added, if applicable, to nearly every provision of this contract if you wanted to take issue with it under some legal theory. But you really only added it to the sovereign immunity section.
Respectfully, no, I didn't. Representative Gazaway, as I was saying, if there was a statutory reference, but I didn't understand what it meant, I did that. So if you go to section 15, amendments, it quotes statute, Art Code and 19-11-265. I wrote if applicable. And I do want to just explain why I use the typewriter.
But hang on, let me stop you first.
Sure.
So section 15 deals with an amendment that increases compensation. So once again, you added, if applicable, to a section that deals with the way that you would be compensated under this contract. It appears that the only provisions in this contract that were worth amending or that were worth adding, if applicable, to were the ones that concerned whether or not you would get paid.
No, respectfully again, so I'd point you to 12A on the same page. 12B, excuse me. I have no problem being ethical and complying with whatever ethics provisions apply. I did not have an opportunity.
Well, the way I read that, subject to the relevant ethical provisions of whatever, you say if applicable. In other words, that's an out. I'm subject to those ethical requirements if they apply. I mean, that's not because I want to be ethical. That's so I can have a way out of being ethical.
No, it's not. That's not my function. My purpose here is I didn't want this signature to represent an admission that the Attorney General would then wave around in court to say, aha, Abton agrees that this section applies and this statute comes from this section of the procurement law, and therefore this procurement law applies and 711 doesn't.
And so,
my only effort was to not give up any ground on the status quo.
So I would go back. Yes, no, absolutely. The point is that you edited this contract in every portion that was beneficial to you. If it would be beneficial to you so the Attorney General couldn't point out about ethical obligations, then that's if applicable. If it's about whether or not you can get paid under whether or not the legal theory of sovereign immunity applies, then it's if applicable. If it's the portion about payment for professional services and compensation, it's if applicable. At every turn in this contract where it was beneficial to you personally, whether that was from an ethical consideration or whether that was from a financial consideration, you edited the contract to say if applicable. All the rest of the provisions don't matter. All the rest of the provisions, fine. Don't touch those. But if it's ethical or financial, it's if applicable. It's clear.
No. And may I respond? No, respectfully, no, that's not the case. And let me just make this clear. The statute, 711, deals with the ability to hire counsel and for the counsel to be paid. So those two issues are married together. And so the board's interests and mine in this respect are aligned because the Attorney General has moved to dismiss the complaint, arguing that it is a nullity because they argued that 711 doesn't apply. And so if 711 doesn't apply, it means that the lawsuit goes away and the board loses. And so whether or not my payment is a part of that calculation, it also goes to the heart of the ability of the board to proceed with its litigation and to vindicate the Constitution that we have all sworn to uphold. And so those two issues are married, and I understand it's a nuanced legal issue that you and I might be some of the few capable of understanding it and unpacking it. But those two issues are married. And so, no, it wasn't anything to do with, well, I don't want to agree with the ethics rules. I don't want to agree with this. I didn't want to make an admission on a short notice basis because I didn't have the opportunity to do the research because I was told to sign it that day. I didn't want there to be any argument that 711 doesn't apply because 711 goes to the heart of the board's ability to vindicate its rights under the Constitution and to pay me. And I absolutely accept that. And let me be very clear, Representative Gazaway. I want my firm to be paid, and we deserve to be paid. And we've done good work to get paid. But if the payment issue if I cannot get paid because of some procurement law, then there is an inherent concern around whether the board had the ability to hire me. Now, Judge James, in her order, I think has clarified that concern. But I will also tell you that I've consulted with ethicists at the highest level of our state and asked their opinions and spent my own personal money to get an ethics opinion about what I ought to do moving forward and whether, how this kind of unique dispute, whether the Attorney General and the governor should have some control or say over whether the board gets to hire a lawyer. And the ethicists with whom I consulted said, no, proper constitutional litigation requires competent counsel on both sides, and the defendant doesn't get to choose the plaintiff's attorney. And so I've attempted to operate in the highest ideals of our profession, and I hope whether you disagree on either side of it, I hope as a member of the profession you're proud of the work we've done.
I can see your theory. Once again, I just can't help but notice that in every portion that it would be beneficial to you personally, you added, if applicable, and all the rest of the contract was fine. And I don't think that is, again, I accept your explanation for what it is, and it may be very well be the case, but I just seems more than just mere coincidence to me.
I can appreciate your position. I appreciate this ability to engage in the dialogue. Thank you, Representative Gazaway.
Senator Hammer, you're recognized.
Thank you. Just on the timeline of things, you handed Mr. Watson an engagement letter, if I'm using the terminology right, because you thought things were getting hot. Is that correct?
That is my recollection, yes.
Okay. And then after that, entered into the actual contract. Is that correct?
I'm sorry. So I know that there'll be a record made of this. I want to be accurate. I provided a copy of my engagement agreement, and the board on December 8 voted to hire me, and they signed it. So yes, that became the contract. And then again, it was supplemented on December 22 after the Attorney General sued its own client.
And then it was, because I'm looking at it, it says this letter serves as a supplement to my engagement agreement. So that is after the original contract. Is that correct?
Correct.
The letter's not dated. Do you know when that supplement was actually submitted?
The board voted on it and approved it and signed it, I believe, on December 22.
On December 22. Okay. All right. I'll go back in the queue in a minute. Sure. Thank you.
Thanks, Senator Hammer. Senator Dismang, you're recognized.
All right, just real quick, because there is one difference between every other agency or department or whoever that you've represented. They had the ability through appropriation to pursue you through professional services appropriation or whatever it may be. They are different, and I just want to be very, very clear. Even if there was a which there's not, but even if they did have the authority to hire a compliance officer or whatever, they are beholden to what that appropriation requires to be able to expend funds through that. And there was a comment made, and I just want to make sure that we're all inside the same room here, and they are not in control of their appropriation. That we set appropriations, we control the appropriations. These are the throttles that we put in place as the legislative branch. So
I do not want to get into a disagreement with you, and I understand that this body should push back on what I'm about to say. But there is a case, the Cheffin case, Chaffin, Chaffin, and it deals with it, again, it's from the Secretary of State's brief in a lawsuit Matt Campbell filed against them. It's quoting, and I think this is insightful. The Supreme Court said in Chaffin, the advice offered by the legislature to a constitutional agency is tantamount to a legislative order on how to execute a contract. The Arkansas Constitution contains explicit separation of powers provisions which declare that one branch cannot exercise any power belonging to another branch. An unconstitutional encroachment may not always take the form of outright invasion. A subtle coercion exercised by a powerful branch of government can effectively tie the hands of a coordinate branch. The executive authority should be free not only from blatant usurpation of its powers, but from paralyzing interference as well. The legislature cannot hold the executive branch hostage to its will, while it can and should hold hearings and investigate at length the performance of state agencies. It cannot intrude on the prerogatives of the executive branch of government. And that's Chaffin versus Game and Fish.
Still, every one of those agencies have to have the authority to spend. That can't be taken away. I understand. I think your argument is since we didn't give the authority to spend, and we've hung them out to dry, so then they can't defend themselves, and so then they get to get whatever they want to get. I mean, appropriations are put in place for a reason. It was not too long ago we had a constitutional officer that was being sued by an employee, and we were the ones that allowed that constitutional office to have a re-up in the appropriation because the bill kept growing and growing and growing. We could have made a determination not to as a committee, and then those bills would not have been paid. But again, I would just tell you the difference between all these other entities that you've been talking about or maybe represent, they had appropriation authority. These folks did not. And in fact, I mean, just to even play it out a little bit farther, it seems if you can do and make it make sense in your mind that you are suing the entity that's going to pay you, then good for you, because I can't. Which then brings you back to the whole deal of none of this makes sense, and why we're here doesn't make sense. And so and that's for the members. Just for the members, there is no appropriation for the department or the Board of Corrections to pay an attorney out of. And so what I would say would be, there's been mention, we talk about, the pieces or what's got to be contained in a contract. There's got to be an offer, an acceptance, awareness, consideration, which they had no authority to provide to you because they have no appropriation to even provide you consideration, capacity, and legality. There's at least two of those that lacked from this being an enforceable contract, in my opinion. And so I don't know if and I apologize they didn't advise you that they didn't have an appropriation, but they don't have an appropriation.
So if I may respond to this, it's two things. Number one, y'all can fix this and make this drama go away. Y'all have the power to do that, but not this committee itself, but as a legislature, this branch of government's pretty powerful. You could help us learn from this, and it probably won't ever happen again. So y'all can fix this problem for us if you are interested in doing it. But number two, and more to the point, your point's well taken about the constitutional officer issue. What I want to say is that if this body, for instance, passed a law that, for whatever, intentionally was unconstitutional, and didn't want that law to be challenged by the only person who could have standing to challenge it, then you'd also say, okay, we're going to pass this unconstitutional law and not give them an appropriation or not give them a specific appropriation for outside counsel.
But I would argue it's not unconstitutional, so I'm not doing any of those things.
I get that, but
I would also, and one of the things you said earlier, you were agreeing with an attorney general's opinion earlier. I wish you would agree with some of the attorney general's opinions that's been put out so far, because I would argue most of these members here, just so you're aware, did not seek out this fight, did not seek out to be a part of this argument. There were certain letters written by board members, accusing the legislative branch of doing things that were just, quite honestly, not true. But most of us did not have a desire to be a part of this until we started finding out more and more and more. And I think, there are clear FOIA violations that have occurred. I don't think that's disputable. I think when you listen to the board members, they acknowledge that they occurred. That's a breaking of the law.
Can I speak to that?
I'm not. Be careful for what you say. I would advise, because you have your own track of FOIA laws or FOIA issues that you're dealing with. There was testimony on some earlier that clearly violated the law.
And what I will say is that those violations can be addressed through civil litigation or through criminal prosecution.
Correct.
In a different branch of government. However, from the testimony that I heard, you heard Dr. Byers and Chairman Magnus, these are nice people. They're
No
also
one said they're not nice people.
They can get intimidated, and I think they misspoke a number of times. And I think I heard from someone here today. We asked if we sent the legislature a FOIA request. We can, as far as I'm aware, I can't send you all FOIA requests. And so my point is that the FOIA is confusing, but because of that, the FOIA also allows bodies to retroactively or prospectively cure a violation. This is not, they're not held to a standard of perfection. They're volunteers.
Oh, no, I'm fully aware.
When an issue is addressed, so what the Supreme Court says, when the remedy the FOIA litigant seeks, in this case the Attorney General, when that remedy is invalidation of an official action, you have to give them notice of the issue and give them an opportunity to cure. And the AG letter says cure it by December 15. They did that. They met on December 14 and in the air talked extensively about all of their discussions and everything else. All records have been certainly turned over.
That is absolutely not true. Unless records were, as you pointed out, deleted so that they couldn't be FOIA'd, they have not all been turned over.
Senator,
we've acknowledged amongst members and you and everyone else that there's been written communication that has not been supplied to this committee and was not supplied when requested.
If it wasn't supplied, it doesn't exist.
Well,
I can't
Okay.
make something for you, Senator. But no violation of the FOIA occurred as it relates to documents. If a request, and I have been consulting with another law professor, Robert Steinbuck, extensively.
Are we having to pay Robert too?
No, he's doing it for free, although his
He's
hourly
doing it for
rate's
free too?
$1,000 an hour, but he's doing this as a public service. And in speaking with Professor Steinbuck, I've consulted with him extensively about this. He literally wrote the book on it, and the board has cured both on December 14 and on December 22. And so as far as FOIA violations, without conceding any that existed, I wasn't in the executive session, so I couldn't tell you. I don't know. But
none of us were, and they don't keep records.
But there's subsequent discussions on the record, cure all violations of
a 3-minute conversation about hiring an attorney is not a conversation on the record.
Senator Dismang, I think you're aware that was December 8th, the date on which you're referencing. On December 14, the board had a much lengthier conversation about the decision to hire outside counsel. And then again, on December 22, the board had an extensive conversation about it.
To try to cure. I agree.
And I think that's all we can expect. If the Attorney General says we did something wrong without conceding it.
If you're going to call yourself a constitutional officer, which I would question, I don't think that's anything that's stated in the Constitution. The board was created by the Legislature Act, or Amendment 33 simply states that we cannot take away from the authority provided to the board, but then there's some other provisions that nuance outside of that. I don't think anyone, you have a judge that has said they're constitutional officers. I believe that will not carry itself out. And I don't even believe you're challenging that, to be honest, the Attorney General's assertion that they're not. But that's okay. That's a whole different deal, and we're not going to argue the court cases.
The legislature passed a statute, 25-1106, that defines this board as a constitutional board. It's not just Judge James. It's also this branch of government that construes them as special. All throughout the Transformation Act, it deals with unique attributes of Amendment 33 bodies like the board. All throughout the board's legislation, it says subject to Amendment 33. In this way, you can't look at the Board of Corrections without also looking at Amendment 33.
I didn't say you could.
If their office is created by the Constitution, the law, the Supreme Court.
They're not created by the Constitution.
The Office of the Board of Corrections.
No, sir.
Literally
Thank you. No.
The second word of, the third word of Amendment 33, Section 1 is office.
So, Senator Dismang, did you get your question answered? Generally, thank you. And Mr. Zadigan, we have no more questions from the committee for you. I'm sorry, go ahead, Senator Hammer.
Thank you. Have you provided services for the Department of Correction prior to this contract?
No, sir.
Okay, and on the contract, you reviewed it and signed it yourself, or did staff sign it? The contract that you entered in with the department, you reviewed it, and you're aware what the content of the contract is that you signed with them, correct?
I'm aware of the content of the December 8, December 22 engagement agreements and the procurement document that was signed March 6, yes.
Okay, and if I'm not looking at the wrong document, there's a statement that says this is provided for informational purposes only and is required under Arkansas procurement law and is not performance obligation of the department as an unconditional promise to pay from the source identified, which is the general revenue. You're aware that that statement was in the contract?
If it's in the contract, yes.
Okay, so there was the possibility then that you knew that you might not get paid based on that statement that's in the contract?
No, not. This document was trying to change the game on us by the defendant. The defendant told us to sign this if you want to get paid. I considered it an unusual process and an unnecessary one, or one that could have honestly been dealt with by a ratification letter, which is what we were told in the first place. So I have concerns with the premise of this document or its propriety. I understand that there's always some potential that a bill goes unpaid. And I hope that that is not the case here, because a lot of people who worked really hard will suffer unduly for it.
And then one last question. You invoked Dr. Steinbuch's name a while ago. Did you just make the statement that what he provided to you as far as it relates to the services he provided to you is at no cost? He's not billing your firm, nor is he collecting anything?
He's not billed or collected anything. Professor Steinbuch gave generously of his time and signed an affidavit, or declaration technically, that included his review of the documents, the board minutes, et cetera, and quoted from his treatise on the topic. He ordinarily charges $1,000 an hour. I did not have approval or authority from anyone, the board or otherwise, to hire or pay Professor Steinbuch's fee. And he did not, I want to be very clear, Professor Steinbuch did not ask me for payment or did not suggest an engagement agreement or anything of the nature. As a law professor expert in the FOIA, I conversed with him in the academic context, and he supplied his time free of charge, free to the state as a service, because he is, again, a knowledgeable subject matter expert in the FOIA.
And that was done on his own personal time, not on time as the University of Arkansas. Did he render that opinion as a private attorney, or did he render that as a professor of the U of A?
I believe most of our conversations with Professor Steinbuch were on weekends. I don't know what capacity he was in. I'm not going to answer for him. I don't know. My view is that he was providing the affidavit as an expert in the FOIA,
of which he would charge $1,000 an hour for any FOI content. Was that what you said? $1,000 an hour?
No, I just think his hourly rate. I think I've had a conversation with him at some point about. At the time, I think there was some negative commentary about my hourly rate of $285 an hour, which is discounted for this body, for the board rather. And I said, Professor, what's your hourly rate? He's like, it's $1,000 an hour. I'm worth every penny, and you're worth every penny. But
I don't get paid $1,000 an hour, but thank you for the compliment. I just wanted to clarify your testimony was with regards to if it was work for FOIA advice, $1,000 an hour is a lot for an attorney to bill for advice on it. Am I misstating or misquoting?
I think I'm conflating the two issues, and I probably misspoke and should have just not said anything.
Okay.
Professor Steinbuch did not ask for or receive or charge anything to me or my firm or to the board or anyone in connection with his public service and pro bono work for me on behalf as a FOIA expert.
Thank you for that clarification.
Thank you for being here today. You're excused, and with the understanding that you're subject to being recalled. And the committee calls Mr. Lee Watson, please.
General Barry, may I ask a clarifying question? I'm very happy to be recalled. I have a meeting to get to at 3:30. May I, if I'm not here and someone asks me a question?
We'll be back on the 11th, so
Okay.
there's potential you may have some more questions on the 11th.
Thank you.
Very short, please. We'll stand in recess for 3 minutes. to order, and I see Mr. Lee Watson's there. If you please stand and raise your right hand. Do you solemnly swear the testimony you're about to give shall be the whole truth, will be the truth, the whole truth, and nothing but the truth, so help you God? All right, please take your seat, and if you would, state your name and position for the record.
My name is Lee Watson, and I'm a member of the Board of Corrections.
Thank you for being here, Mr. Watson. So, did Mr. Metazadigan provide you with any preparation for today's questions?
No.
Okay, thank you. So, what is your prior relationship with Mr. Metazadigan?
Well, back sometime in the middle of last year, when through a series of, you mind if I give you a little background of how that came to pass?
Briefly.
Okay. Through a series of executive sessions where the board discussed Joe Profiri's performance, in particular, in relation to, we went a period where we were used to the secretary requesting board meetings. By law or by, I forget whether it's in statute, we have to have a board meeting every 4 months. But we had a period where we didn't have any. We were used to that being precipitated by the secretary. And this was middle of last year. And also, we were asking for information from Joe Porfiri, and we weren't getting information that we felt like we were used to getting and should be getting, especially with the emphasis on the Protect Arkansas Act, building a new prison. And through the course of that, when I became aware of what eventually became Act 185, not part of the Protect Act, but Act 185, which changed the wording to say that he serves at our pleasure to the governor's pleasure, Benny and I talked after a board meeting. And it's my understanding for there to be a meeting, there has to be 3 or more. So not 2. And as far as FOI purposes. And I said, this may cause an issue. This person for 82 years, whoever's in this position, whether the title was secretary or director, reported to the board. And Porfiri had been indicating, he'd referred to me personally when we'd talk. Well, I got to do what the boss says. He's talking about the governor. And as time went by, and I was only aware of Act 185. By the middle of last year, I really hadn't seen the 2 issues with in the Protect Arkansas Act that had to do with the directors, serving at the governor's pleasure instead of ours. And I said, Benny, I don't know if this is going to cause a problem, but it may, and unfortunately it did. We wished it hadn't. We tried to communicate with Secretary Porfiri. But as it became a bigger problem, Chairman Magnus didn't authorize me or give me a special label of litigation liaison. That didn't come until after the litigation was filed in December. He said, you're an attorney. Would you look to see basically if there are any attorneys out there? And sometime last summer, early fall. And so I started asking around and doing what I've done before. And I'm in-house counsel for a company. I've worked for several in Fort Smith. And by asking other attorneys I know, and the Fort Smith bar and the Little Rock bar, there's a little crossover, but I asked attorneys in Fort Smith, hey, these are kind of issues. It's an employment law issue. Who might be out there? And this might be public. And a lot of attorneys, hats off to Mr. Metazadigan. Most attorneys would not want to be involved in this sort of litigation and situation. So as I started basically asking around, talking with fellow attorneys, like I've done before, and I've hired attorneys all over the country for the company that I work for, I ask other attorneys' opinions. Sometimes I call them, and even though I'm basically under the guise of I'm looking for somebody that can handle this kind of action, and many of those have been employment law actions, I learned of Abdon Metazadigan. I'd been told of others, but for different reasons, I either researched them online and I kind of discounted them. And finally roll forward to November. And to be honest with you, I'd forgotten until Abdon said it today. But around November 9th, somewhere in there, he and I talked on the phone. I called him. And I'd looked him up on the internet. I'd seen what he'd been involved in, understood he was an employment law professor. And at its heart, this started as an employment law matter. We had a secretary that had always reported to the board and been answerable to the board, and now wasn't. We, as Amendment 33 and the statutes tell the board, we have to manage the affairs of the Board of Corrections. Well, how do you do that when the president of the organization is saying, I don't have to talk with you. I don't have to work with you. So we're like, what do we do here? We continue to see performance issues. And we talked about this in executive session about how to address this. Do we discipline him? Do we suspend him? And so when I called Mr. Metazadigan, I explained the background. And I was impressed with him very quickly because he grasped the issues. He understood at the heart of this, it was an employment law matter. Because as a board, if you're the board of a corporation and the president of the corporation is thumbing their nose at you saying, I'm going to do what I want to with the corporation, you become a toothless tiger. You can't effectively manage that organization. And I remember in one of these conversations about him in that situation, one of the other board members said, we're quickly becoming the board of nothing because we had a secretary that at that point wasn't responsive to us. So I talked with Mr. Metazadigan. I have a son who lives in Conway, and we met for a bite of pizza and to talk. And I was very impressed with him. We continued to have conversations, and that was Sunday before November 17th. And then the press conference happened on November 17th, and I was shocked. I mean, like, here we have the governor flanked by, well, not just flanked by, but with the secretary that reports to us and the attorney general stand there and repeatedly say that we were failures in our job of managing the Department of Corrections. So I'm thinking, as an attorney, I've never seen an attorney before publicly basically demean their own client. And the attorney general at that point was actively representing us in litigation. So it's like, so anyway, I continued to talk to Mr. Metazadigan. Fast forward to December, or shortly after that, first Mr. Magnus sent the letter to the governor, made overtures to try to resolve this, to try to explain the situation so we could get past this without any of this happening. None of us wanted this to happen. I mean, it's not been good for anybody, not us, not the efficiency of government, not anything. But we were faced with this situation with 82 years, and to parse words a little bit, Senator Dismayne, the board existed before Act 33, but Act 33 in part is what made us constitutional officers in the statutes. But, whatever that is, and that's what we're trying to sort out. And so in talking with Metazadigan, Mr. Metazadigan, frankly, I don't think he realized it. I was basically interviewing him, and he spent, frankly, more time with me than I expected that he would discussing these issues. So the governor didn't respond to Chairman Magnus's letter. Things moved forward. And, we didn't want to get into a fight, but we're at the point, I think, where we either had to do this or we all just needed to resign and walk away because we were no longer effectively managing the department. And so we chose to fight. We chose to, in talking with Mr. Metazadigan and this conflict between the new Act 185 and Amendment 33 and the 82-year history, it's like, well, and he felt like, yeah, you're in the right here. He formed an opinion. I did too, as an attorney. And then, and I'm terrible with dates. We got to the point where we had to take action, and it was an emergency matter. And it became an emergency when the governor publicly said, I don't care what the board has voted. I don't care what they've done, even though in their judgment they've been trying to manage these Department of Corrections facilities and comply with national standards, keep inmates from getting hurt. we had and I've only been on the board 4 years, but there's a severe shortage of guards at our prisons. So, we're between a rock and a hard place. If we start just, putting beds in the halls or places they don't belong and we don't have adequate supervision, the state's going to suffer more liability. We're going to have lawsuits. We're going to have bad things happen, and we know that. I mean, all the experience of the board members tells me that, and common sense does too. So then the governor comes out and says, well, I'm directing the secretary to add those beds regardless of what the board has determined in its meetings. So at that point, what do we do? And so when we had our executive session before hiring Mr. Metazadigan, I said, this would normally be an employment law matter. We have an employee here that won't respond to us, that won't follow our directions, which has been the status quo for 82 years. And now we have this statute, and we've had him telling us, hey, I work for the governor, I don't work for you. And there had to be a resolution. And one thing I want to make clear is...
Well, and if I may, Mr. Watson,
okay.
So you pretty well answered my question
Okay,
in relation to your relationship with Mr. Metazadigan.
Well, and I recommended him to the board because I'd had multiple conversations with him. You saw today how intelligent he is, how quick he is.
Yeah.
And I went to him and I said, I've interviewed and I've hired attorneys for 24 years for different companies I work for. When I find the right one, I stop.
Gotcha.
And
so have you, the two of y'all ever worked on cases together?
Nope.
Have you ever received a referral fee from Mr. Or your firm from Mr. Metazadigan?
No.
No? Okay. No. And Senator Dismang, you're recognized.
Yeah, so just to kind of go through the timeline just one more time, and I'll just ask for a date, and we'll just kind of say yes or no or whatever. So I think, on around November 9th is when you initially called Apton, and in that conversation, there was no talk of employment.
No.
Okay. And then, you had conversations on and off again with
I'd hope
him.
that we wouldn't need to employ him.
Yeah. But, and I guess just to back up one more time, so when did the chairman ask you to find an attorney?
It was several months before that, because I told him.
I think he testified in the summer.
Yeah.
Okay,
And
so in the summer
it
you started
wasn't go
looking.
hire somebody. It was start checking the field to see if there's somebody out there that was competent.
Okay.
And better than competent if possible, and willing. Because, frankly, there's a lot of attorneys that wouldn't take this on.
Gotcha. Okay. And so then you had a couple of conversations since then, shared some pizza. Then there was a press conference on November 17th. He was part of the response that was given to the press conference. Was that made on November 20th? Is that the way I read it? I can't remember I can't read my own writing.
I think that's
so. But anyway, he was a part of what do we need to say and how would he need to say it? Okay. And at that point, up to that point, there was still no conversation of him coming on or being hired as an attorney. Is that correct?
Correct.
Okay. And then we get all the way to December 8th, 2024, and sometime between November 20th and December 8th, according to his testimony, you didn't ask him, hey, would you be interested in being an attorney? He just happened to have one of his engagement agreements, and he gave it to you. Is that how you remember that?
He did, and I don't remember just when. And I was still at the point, I think the board was, of hopeful that we could resolve this.
But that was sometime before December 8th.
It was. I don't remember just when.
Okay. And so, but in that, you never said, hey, we may want to look at hiring you. Do you have an engagement letter? Do you remember it that way, or do you remember it his way, which was, I wasn't soliciting or even telling them they should hire me. I'm just going to give them an engagement letter.
I think at some point pretty close to December 8th that we did have a conversation, and I knew I couldn't hire him, that it had to be a board decision. And I made that clear to him early on.
When early on? Say that. Give me a date.
Like one of our first conversations, if not our very first.
So there was a conversation about employment. These are the questions I'm trying to ask.
Well,
was he aware that there was a possible? Let me rephrase the question. I'm going to go back to the beginning. November 9th, 2023, you gave him a phone call. In that phone call, a minute ago, you told me there was no talk of employment. And just a second ago, you said early on in the conversations, I told him I couldn't hire him, that the board would have to hire him.
When did that occur?
I think one of those first conversations.
Okay, so he was aware.
I wasn't hiring.
But he was aware that there was a conversation about hiring someone because you thought enough of the conversation to let him, or there was enough of a conversation, you thought enough of it to say, hey, by the way, I can't do this on my own. We'll have to go before the board. That's a very different thing than what you just told me. I asked, was there no?
Yeah.
I wish I was an attorney because attorneys are really good at something that I just can't do.
Sure.
And that is dance around and answering a question. And so my question is, did you talk to him about employment? Yes or no, on or about November 9th in one of your first meetings?
I don't think it was then. I think it was later. Because I told him at first, I'm calling you as a board member. This is just us. And somewhere in that process, over several conversations, I made him aware, I can't hire you. If that were to ever happen, it would have to be a board decision.
Okay, and so November 9th, somewhere may or may not have been right after that, there was a conversation about employment in which you let him know the board would have to hire him, you couldn't. So there was a bigger conversation of some kind because
somewhere in the middle between the 9th.
You wouldn't just set it out of the blue. And then so in all of that time, so from November 9th to December 8th, let's just say, was there any written communication between you and Mr. Apton?
Very little. And I will tell you, in one of my first conversations, I asked him about attorney-client privilege and about.
Oh, no. You please don't tell me you did that.
Yeah.
You asked him about a clear. He just testified earlier that all he was doing was giving advice. You can't ask about it. I'm not an attorney. Some other attorneys are going to have to cue in here. But there is no attorney. He was representing that there was no attorney.
I'm an attorney also. We were just, it was. I didn't know. My concern was, what if I have these conversations with him and he goes public with them the next day? And at that point, I would have backed up and said, wait a minute, Benny, we can't do this.
I apologize, committee. I'm an attorney. You are, and I think you all that are attorneys probably need to hop in here in a second because there's things that you just said that conflict with what he said, and he stated things very specifically on purpose. You told me a minute ago there was no talk of employment. Then you talked of attorney-client privilege. Then you talked, and just prior to that, you explained to me that you told him you couldn't hire him, but the board would have to. So in all of that, I'm going to tell you, you haven't been very clear.
Okay.
And I think on purpose, but
no,
I'll leave it there. So let's just fast forward December 8th, okay? Because I was going to ask you about solicitation. It sounds like to me that happened. You all made a decision to then hire Mr. Apton as an attorney.
Yes.
You went into an executive session to talk about the secretary. You went to lunch. That was a 30-minute executive session. There was no mention in the minutes otherwise.
Right.
There's been no mention anywhere else of a conversation about hiring an attorney in any of the minutes. My understanding that I guess it's happened through executive, which even though I don't think that's allowed to happen in executive, we've asked, other people have FOIA'd. There is no documentation of these conversations between you and Apton. They just don't exist. There's no conversations between you and the chairman about hiring an attorney. There's no conversations anywhere to be found anywhere. Pizza, phone calls, whatever. But in that 30-minute meeting, you talk about the secretary, we're going to have to do something, you go to lunch, you come back, you meet for 3 minutes, and you have an engagement letter that no one else could have seen because we would have known about it because it had been FOIAble, right?
Yeah.
Right. So no one else has seen the engagement. You've been holding on to it for a few days. And then in 3 minutes, y'all decide to sign that sign that engagement letter and move on. Do you do that in your business? We both know the answer is no.
My employer trusts me. And if I came to them and said, I found the attorney we need to hire for this job, they might, it would be.
There'd be some questions,
not
right?
Much.
You wouldn't I would say, how much does he want to charge? But that didn't even happen publicly. Right. There's no record of that in the minutes. It's just the fact, hey, we need to hire an attorney. Okay, I know this guy, Apton. Okay, here's an engagement letter. Okay, let's sign it. And I'm not making it up. It's in the minutes. In a 3-minute span. So there was more conversation about needing to hire an attorney than there was actually hiring him, but
Without question, we moved on, which leads me to believe there were a lot more conversations taking place behind the scenes. And you said something earlier about FOIA. And there's reporters in the room that can speak to it more than I can, and I don't know. But if there are two of you having a conversation about board business, and it's written or whatever, and it can be produced as a document, that's subject to FOIA. Now, I've messed that up some, but generally that's the premise of how FOIA works. So it's not three for a public meeting, 2 is FOIA, okay? And just, you may want your attorney to talk to you. You're an attorney. You probably know how these things work.
I was thinking of the meeting. That's why I was thinking of 3. Because I know there are cases that say 2 people that are on a board can go have supper and be friends. And
that's correct, but you can't talk about board business, which I'm assuming y'all didn't do. I asked earlier, you didn't talk about board business at that lunch, did you? You didn't talk about hiring Apton at that? Y'all just sat across from each other, enjoyed McDonald's or whatever it may be?
Yeah.
And then came out right after that and had a 3-minute vote on a $285 an hour contract.
Correct.
And you understand from my perspective when I look at this, how odd that all seems.
I understand. And the thing is, I'm the only attorney on the board.
I agree.
And,
yeah, okay, fair enough. I don't think you're the only at this point, but.
Well, and I recommended that we hire Mr. Metazadigan, and they trusted me and followed through on it. I mean, it's that simple.
Did you ever let him know that y'all didn't have an appropriation to pay him with?
Frankly, I didn't know that. And, and that's part of the awkward part of this, because you have the Board of Corrections, you have the Department of Corrections, you have the Department of Community Corrections.
Were you all aware that you were going to be suing your own employees, the Department of Corrections?
Well, and in part, that was Mr. Metazadigan's recommendation so that we wouldn't have to name the individual directors. And because those are the 2 positions that were affected by those changes.
Were you aware of how he felt about your employees?
In Act 659.
Were you aware of how he felt about your employees, that they were working to undermine you and what he was trying to accomplish?
Whose employees? I mean...
Well, I'm sorry. You're right.
I'm confused.
There's a differentiation between the board and the department. The department employees, Mr. Apton represented a minute ago,
right,
or 20 minutes ago, whatever, that essentially that he was always concerned that the employees of the Department of Corrections were undermining what he was trying to do and the contracts and everything else. Were you aware that that was kind of his position?
To some extent, I always try to think best of people, and that they're trying to do the right thing. I think attorneys by nature become very suspicious of people, and I think it's a hazard of the job.
I'm not an attorney.
Yeah, and throughout my life, I've always tried to think of and expect the best of people. And I thought, well,
So you were the only attorney on the board.
Right.
He was only going to represent you and sue your employees over the Department of Correction, or that entity. Mm-hmm. And in that process, you didn't think that, and then there was already some reluctance. You yourself, Apton, everybody kind of distrusts a little bit, but we're going to, try to hope they're doing the best thing in the employees. And what I'm talking about is those that were, it's been alluded to that by several board members, well, it's the jobs of the employees to review this contract. Well, Mr. Apton made it very clear that it was not their job because he was suing them. So how could they review that contract?
I know.
And then you were copied on the email. So now my question is, did you review the contract, the one that was ultimately uploaded?
I did not.
Even though it was emailed to you?
I did afterwards. And I was at work the day that I got that. I have a very demanding job. I normally don't check my state email. I work for a private employer. And I happened to look at it that day, and I saw that. I popped it open. I thought, and my gut reaction was, this is a form that has to be filled for procurement, because they'd already provided a copy of our engagement letter, which we considered to be the contract. And so if I had thought for a second, hey, this replaces or somehow modifies our engagement letter, I would have put on the brakes.
Were you comfortable with the changes that he had made?
After the fact, yes. I've looked at them, and I'm 100% confident. Those changes weren't made for his benefit. They were made for the benefit of the board in our litigation that's pending, so that we didn't waive or give up any rights.
Well, the payment would have been for his benefit through an appropriation that doesn't exist for you, that was going to come from the department that was actually being sued.
But he was representing us, and I believe every change he made was in furtherance of his ethical duty as an attorney to give us the best representation and make those changes so it didn't look like between us as parties to that contract, it was harming us.
But I'm coming back. Thank
Go
you.
ahead. Go ahead. I'm sorry.
Thank you, Senator Dismang. And so were you aware, over here, in front of you, right here? Oh, Chairman.
I'm sorry.
So were you aware that Board of Corrections did not have an appropriation?
Not really. No, I mean, I knew that our appropriations.
When you say not really, what does that mean?
I mean, we had limited appropriations. We have staff. So, but, you know, and earlier there's a lot of conversation about contracts that we review and approve. Those are for the departments. That's why they take them back and they push them through the appropriations process, and we're not involved in that. We approve of the contract. We review them, and trust me, we take them to task if we don't think things about them are the way they should be. But this was a unicorn. This was a contract to be signed by the board, and it was between the board. In 4 years, and then talking with Chairman Magnus, he doesn't remember the board signing a contract on its own behalf. But we were the ones being impacted by the statute and Amendment 33, and the department was indirectly. So this is a unicorn for us.
So
we've never had this situation.
So you didn't have a conversation with Mr. Metazadigan that there may be a possibility that he might not get paid?
Not initially. I think at some point I said, you know, this is going to be difficult. You know, because we're fighting City Hall in some ways here, and you know, and it's you know.
Exactly. Okay. Representative Beatty.
Thank you, Mr. Chair. You said something just a moment ago, Mr. Watson, where you said all the changes that Optum made on the contract benefited the Board of Corrections and benefited you. Explain to me and this committee how the waiver of sovereign immunity benefits you or the Board of Corrections. Explain that to me.
Well, can I give just a little background?
Whatever it takes to explain that so that we can understand that, because I don't think you're going to get there.
And if Abden were here, to some extent, I'd defer to him on this. Because
I want you to explain it.
As Senator Gazaway touched on with the Andrews case, some of the sovereign immunity is unsettled law. There's some cases that seem to indicate that it really just applies to cases where somebody sues the state asking for money damages. That's not what we did. We don't want a dime. We don't want a penny. What we filed was a declaratory judgment action asking the court to say, between Amendment 33 and Act 185 and those two word changes in the PROTECT Act, are those constitutional? What's the law? Because we were sitting here trying to make a decision about an employment matter, but we're looking at this, I'm like, we don't know the answer. So if we tried to do anything, and we had tried to communicate with Joe Proferi, and he wouldn't provide us information. We've only learned after he's gone the multiple contacts he had with other agencies regarding building a new prison. He never told us about any of those. And I asked him.
Okay, we're getting away from
I'm sorry.
Benefit the Board of Corrections. You said every change he made in that document, because I'm not going to debate if it's a contract or what, benefited the Board of Corrections. He was looking out for you. How does that benefit you?
His concern, and I agree with him reading his changes, was that without those changes in the pending litigation,
I'm just talking about the change on sovereign immunity. How does that benefit the Board of Corrections?
That could harm us because the Attorney General could use that to claim, oh, their lawsuit should be dismissed because somehow sovereign immunity prevents it. And blocks our lawsuit.
I still don't know how you arrive at that consideration, because I don't think that in any shape, form, or fashion that benefits the state, the Board of Corrections. It would only benefit payment for the law firm. So let's move on to another question, since we're on sovereign immunity. Sure. At what point in the discussions that you had with the attorney did sovereign immunity ever raise its head and y'all have a discussion about sovereign immunity?
I don't remember just when. It was before I ever saw that form or the follow-up. It was, he and I talked that in general terms about issues that might arise in the course of our, the declaratory judgment action.
Another question for you. I serve on several boards and committees, and a lot of times, and I see other members that when we're in meetings, they keep a journal or they take notes so that we can keep facts straight and follow things of the day and reflect on them at the end of the day. Do you keep any such records on our meetings, or do you just operate from memory?
Occasionally I do, but then I end up, I look at them later and I throw them in the trash. I mean, I don't keep them.
So you don't keep any written documents, records, or anything from your board meetings or anything like that? You don't maintain any of that? It's in and out?
Yes.
All right. Thank you.
And most of our business is very routine. We consider contracts, personnel issues, we make decisions. At the end of the day, on my cover sheet, I might put check marks, and there's almost, regarding everything we approve. I may glance at it later, but then I either leave it there and it's disposed of, or, when I get home, I put it in the recycle bin.
I find that hard to believe. Anyone that would write a 5-page open letter to the legislator, the governor, and attorney general, and doesn't keep any notes or details, I find that a little hard to believe. So I appreciate you.
Senator Hammer, you're recognized.
Thank you. I want to go back to the initial conversation you had with the attorney and get you to clarify something. And maybe put it this way, how could you have an interview with an attorney that you were tasked with the responsibility of going out to find to represent the board and it not come up in the discussion that could lead to possibly being hired?
As best I can recall, when things first started, there were issues that, I didn't know the answer to regarding the conflict between the statutes and Amendment 33. I was looking partly for a sounding board, and I told him, I don't know where this is going to go. We want to work this out. And one of the things that Chairman Magnus had told me was earlier in the year, he had reached out to the governor's office a couple of times to try to, and through intermediaries, say, I would like to meet with the governor. And that just wasn't happening. And he had previously always, whenever he had done that, previous governors had always sat down and talked with him. And we just didn't know where it was going to go in November. And then all of a sudden in December, frankly, kind of the wheels came off and everything, we realized we have to do something, So it was further into that conversation where I really even got the feeling we may need to hire him for sure,
Okay, and then you made a statement a while ago I wanted to get clarification on. Did the attorney advise you to sue, or was that the decision of the board that made the decision to sue based on something you said a while ago?
We knew at that point that one of our directors, the director of the community corrections, was retiring early and leaving employment because of Joe Proferi and because of his treatment there and the morale he was creating with staff. We did not want to lose Jerry Bradshaw, but we did. And one of our considerations was, because in the lawsuit it named Joe Proferi as Secretary of Corrections. And Abden at some point said, well, I'm going to have to say Jerry Bradshaw as Director of Community Corrections because his reporting up was changed in the new statute. And we pushed back on that. And I don't remember, I did. Because I'd said, it's going to be offensive to them because their name's going to be out there in the press. Is there some other way we can do that? And anyway, his answer was, well, we will name the department. But our intent there was really, it was because of their position as director,
Okay, and so in that initial conversation you had with the attorney, the discussion of possibly suing was never in that initial conversation where you were interviewing him?
No, that didn't come for, weeks.
Okay.
I was trying to figure out for the board, what our options were. This was like the last ditch op. What happened? We were trying to find some way to work this out. And unfortunately, it,
Okay. And I want to make this statement. I'll be done, Mr. Chair, on this, but you brought it up, so I want to respond to something you said about the morale and how you felt it urgent because of, what Joe did in his leadership role. I can tell you for a fact that prior to even Joe being hired, that I've been approached by multiple employees, both present and that have left because of the morale that's been created by the middle management of the agency, of the department. I don't think it's fair to lay it off on him, given the fact that the problem preceded him and even continues today. So I think I would be giving you free advice that maybe one thing y'all need to look at is the management, middle management of the system that's running people off.
That is very much on our radar. We talked about it at the last, when we were interviewing candidates for the director of corrections position last week, director of community corrections. When we were interviewing, we asked them, the ones that would know, what do you see as a big issue, things that need to be fixed within the department? We already knew it, but we were wanting to gauge what their response would be, and they said morale. We have some issues here, and so we want to do everything we can to improve that.
All right. Thank you. I got off subject. Thank you, Mr. Chair, though, for latitude.
Thank you, Senator Hammer. And Senator Irving, you're recognized. Oh, we punched you. Oh, yeah. Oh, I'm sorry. How about that?
Thank you, Mr. Chair. I've actually been watching all day as I've been driving around the state of Arkansas, or listening, not watching, as I've been driving down. So thank you, Mr. Chair, for the latitude to let me ask a question. I think one of the questions I had from the review subcommittee that was listed in this document here as our handout one, my question that I asked during that committee meeting was, how did the contract get entered, changed, and submitted through the portal? So that leads me to what was provided by Mr. Byers with his analysis. And in that, on page 3, and I apologize, I had so many things I couldn't get here before until now. But it says that under Mr. Magnus, it says, we believe legally standing, we can pay the bill out of professional services. And that was what Mr. Magnus said, and that is in this handout. So you're the only attorney, or at the time, the only attorney on the board. So my question to you is, what led to the belief that y'all had, that the Board of Corrections had, that you believe legally standing, we can pay the bill out of professional services? Because that speaks to the appropriation issue that the Department of Corrections does have a line item for professional services. So how did you, as a board, come to understand that line?
I'm not sure that we ever did. The way that I looked at this.
Were you ever told that?
I don't recall. I just don't. But, I believed, and I forget the entire code citation ending in 711, says that when there's a conflict between constitutional officer and the Attorney General and another constitutional officer, we're entitled to hire counsel, and they're entitled to be paid a reasonable fee. In Judge James' order, she agreed with us, and she said that under 711, we were justified, entitled, I forget her exact word, in hiring counsel. And that gave me a big sigh of relief, because I thought, okay, well, we have a statute that says, we have a judge that says we're entitled to hire him, and the statute also says in the same sentence, and he's entitled to be paid a reasonable fee.
So we know that the Board of Corrections does not present before this body an appropriation request through the budget process, correct? Y'all have never done that. Y'all have never had an appropriation that's separate and apart. So who pays for your staffing?
I'd have to defer to Chairman Magnus.
Okay, so, but is it safe to assume that your staff is paid through the appropriation of the Department of Corrections?
I believe so.
And Mr. Brown is one of the attorneys. Is Mr. Hodges one of the attorneys?
No, they both work for the Department of Corrections.
I understand, but they
don't
also
report.
advise you, right? I mean, all through this,
Mm-hmm.
Mr. Brown is working in the capacity as a staffer, so to speak, for the Board of Corrections. For example, we have boards all the time that may or may not have their own appropriation, but
True.
they're staffed by attorneys that are with either the Attorney General's office or other agencies.
And as Senator Dismang has pointed out several times, that's just part of the awkward part of this whole situation.
Right.
We've never had this happen before. Frankly, I don't think any of us really knew. You know, we were in uncharted waters.
Okay, but at some point, and Mr. Magnus may need to answer this because it was his statement, at some point, either y'all were advised that you could do this out of professional services or somewhere you got that idea from.
Well,
is that safe to say?
What happened after Chad Brown provided that memo in a board meeting, part of the open meeting, we talked with him about that, and you know, Chairman Magnus asked him to basically, you know, tell us what to do to how to process this, because in his memo he said there's two avenues, either what we've done,
submit to Office of State Procurement, or
we tell him to go to the State Claims Bureau.
Right.
And this whole process, it's just, again, this is a unicorn. It's never happened before. We were just trying to basically follow through. We'd submitted his contract, the engagement letter as updated, and it was only, you know, basically a day before, in order to stay on the ALC agenda, we were provided with that form agreement. And none of us had ever seen it before. Benny says he's never seen that document before, and for any other purpose. Abden hadn't, despite representing the state multiple times, and it kind of came out of left field. He was busy all that day. Like I said, I was.
I understand.
And I wish I'd seen it as something that might modify our contract, our engagement letter, because at that point I was like, whoa, wait a minute, put on the brakes. And,
right.
You know, and I do believe that Abden tried to modify it so it would not conflict with that engagement letter.
Well, and that's the thing that I mean, I see blame kind of all across the board here, but I do think that if you have it should also be the attorneys that are submitting the information that, in my opinion, should say, hey, this is a red flag. We may or may not need to do this, or there's needed to be some sort of an advising role to the Board of Corrections, because you're not hired to be an attorney for the Board of Corrections.
Right.
You are an attorney who serves on the Board of Corrections, and so. You know, I think we have to rely on that. And I think the procurement's probably more of an agency type of a tool versus what y'all are used to. So it's your testimony, though, because of this unique situation. Is that why the latitude was taken to change the procurement form so as not to kind of tie your hands legally because of the ongoing litigation? I think that's what somebody testified to earlier. I just wanted to hear that.
Yes. And when I read it after the fact, that's how I interpreted it. And especially when it became apparent, because we started getting feedback that, well, this somehow replaced our engagement letter. I'm like, whoa, wait a minute. No, I thought they would work in tandem. And when I read it, it's like, okay, Abden's making sure that there's nothing in this composite agreement, if you will, that steps on each other. You know, that we give up some rights or some issue by signing the form, which again was between us and him, or intended to be.
Right.
So.
No, and put any issue aside about however you view this whole situation. I think at the end of the day, it becomes a question of how and why. And I really appreciate the answers and the testimony that y'all have given as to how and why. but I don't know if it's still, I don't know if it fixes the problem for the legislature moving forward, or for the Board of Corrections. And I don't know how we rectify that, but I mean, I appreciate the transparencies and the questions that have been asked have been excellent questions by the members of the legislature. And I appreciate the answers as well, but.
And may I comment on that?
Sure.
And thank you very much. But it begs the question. We have a statute that says if there's a conflict, a constitutional officer is entitled to hire counsel. That's what we did. We had a circuit court judge that says, yes, you were justified and it was good for you to do that. That statute also says that attorneys are entitled to be paid a reasonable amount. This happened basically on an emergency basis. So there's no time for bidding. There's no time for RFP. In the procurement world, so then how does that get addressed? Because that's the question.
And that's why emergency was put on the procurement form.
I believe so. Because that's what it was.
Okay, and
thank you for the latitude. I appreciate
thank you. And if you can get back in the queue if you would like, Senator. So, Senator Stone, you're recognized with my apologies for knocking you out of the queue.
Oh, no worries. Thank you, Mr. Chairman.
Pardon me.
As litigation liaison, are you familiar with the claims in the two lawsuits, both of Amendment 33 case and the FOIA case?
Yes.
In which case has the waiver of sovereign immunity been raised?
I don't recall that it has. I think that's something that Mr. Matazadigan and I talked about being a potential issue. I don't recall it specifically in the pleadings. Granted, there's been a mountain of pleadings, hundreds of pages, and I think it's referenced in there, but again, I don't, part of what I do is I review contracts and I read sometimes thousands of pages a day and I don't recall just.
Well, I don't believe that it has been raised, but it's, if Mr. Apton were to bring a lawsuit against the state to pay his legal bill, would sovereign immunity likely be an issue to be raised?
I think it potentially could be, yes. But then we have a statute that says in this situation, he's entitled to be paid. So there's the rub. I mean, how do we resolve that?
All right. Thank you.
Thank you, Senator Stone. Senator Dismang, you're recognized.
And I think that statute's a little more complicated than you're giving it credit for. So I would recommend, again, I'm not an attorney, go back and read it. There's a couple of more hoops that you have to jump through before that. One thing I want to go back to, and I meant to ask it a minute ago, have you provided all the documents, anything that may exist with your communications with Apton,
yes,
with your communication with the board members? And so there's just really nothing then?
Yes. Yes,
there's nothing.
I've provided everything that I possess.
But there's nothing, because I'd ask in the meeting, then we got nothing. Then I ask our staff to reach out and ask, and then they got nothing. So you're telling me that there was really no communication that was nonverbal, nonverbal between you and Mr. Apton?
Very little. And unfortunately, that's reflected in some of his fee statements. And I know there have been articles written about my many conversations with him. And it's just I'm busy through the day.
I'm asking you, I'm saying prior to, I'm saying starting on November 9th, whenever you started having your conversations in which, in one version of it, you said you didn't talk about employment. The other one, you talked about employment. That and all that, there was no correspondence between you and Apton besides phone calls or pizza.
None that if I had it, I turned it over.
Do you have his policy, which is, he stated his policy was to delete all communications almost immediately so that it doesn't build up in his inbox, but also because that prevents him having to be subject to FOIA?
I do, simply because of the volume.
So you delete all of your communications, and so if there even were some, they wouldn't be available because you delete your communications.
Correct. Yeah.
Okay.
But at the time I've received any request, if I was in possession of it.
How quickly do you delete your things? How often do you do that?
Pretty quickly, and especially if
does that mean 30 minutes or like immediately? Someone text and I delete it out.
Usually it's
Immediate.
Almost immediate.
Okay.
Yeah. And, you know, it's,
Because that also just complicates this conversation we're having here.
I know.
Because you're anticipating me to believe that there was no conversation about employment with a man that wanted to be paid $285 an hour, that you go into an executive session, which you couldn't have talked about hiring him, that was called by Mr. Feltz, I believe, who then later, after that, after everybody goes to lunch, comes back, there's a 3-minute meeting, and then which we hire an attorney. So, none of the other board members had a conversation about Apton. None of the other board members were even aware we were talking about hiring anyone until we go into a 3-minute meeting. Is that, and I'm supposed to, that's how that worked?
you know, pretty much, yes.
So
And
when he gave you his engagement letter, that was, that you destroyed it also, the one that was unsigned?
I believe so.
Oh.
Yeah. You know, at some point, it seemed like he gave me an updated one.
Oh, he gave you 2 engagement letters?
I don't recall for sure.
Over what period of time, do you think?
Sometime in early December, you know, because it was, and I'm not trying to argue with you.
I'm not arguing,
but
I'm trying to understand.
When I said we inferred that we discussed employment, it was more like, I can't employ you. And, you know, I want to talk with you.
That there was a conversation that had to be about employment.
Very late in the game.
Well, you told me a minute ago it was one of the first couple of meetings you had.
That was to tell him I couldn't employ him. And that we were not employing him, and I was not.
All right, so just to make sure I understand, there is no communication with Apton to be had by anyone because none of it exists, or if it did exist, it's all been deleted. None of the other members knew that we were talking about hiring an attorney because if that had been talked about, it'd be somewhere there would have been a board, minute that would have talked about hiring an attorney. So none of that exists. And then, so you brought all of the board members into an executive meeting, which we complained about the secretary and things we was doing. Mm-hmm. We can't talk about hiring an attorney in that because that would be against the emergency session rules. And so then we come out of that, we go to lunch for however long it was. Then we have, in a 3-minute meeting, you say we need to hire an attorney. Everybody says yes. And then we say, we're going to hire this attorney. Everybody says yes, and we're done. And there was never any communication about that to be had or to be seen.
You know, at some point there toward the end, I told Benny that I'd been talking to an attorney that I thought highly of, but no decision was made. You know, it was just, because the idea was I was going to start looking around to see if there was somebody out there suitable. And my communication was basically to say, maybe, and if that becomes necessary. But it was not at the point where, Mr. Metaxadigan had not been engaged. He'd not been.
Well, you'd already talked to him about attorney-client privilege. I believe that constitutes engagement. I believe, and I'm not an attorney.
Well, I think I brought it up in the context, I'm on a public board, and he said, well, it was a real simple conversation because he said, as a public board member, there is no attorney-client privilege. Only the Attorney General has that. And if the Attorney General had been representing us as a board, we could have met with the Attorney General, we could have had multiple conversations, and none of that would have been FOIable.
Well, you were already meeting with Apton prior to the Attorney General's press conference.
Yes.
Right.
We were talking on the phone, yeah.
All right. All right, look forward to asking some additional questions to the members.
Senator Hammer.
Thank you. When you were originally charged to go out and seek out an attorney, was the directive that you were given just to research or to research with the intent to hire?
It was basically to research, to see if there was somebody out there that if we ever needed to hire somebody. Again, we didn't want to hire anybody. That was worst case scenario.
Okay. And so I just want to ask this question so you have a chance to respond, okay? it seems to me, and that charge was given to you in August, did you say a while ago? Ish.
Somewhere back in there, and it wasn't really a charge. It was just a conversation. Hey, if this gets off the rails,
okay,
you might want to look around and see if there's somebody out there. There was no plan.
Okay, so I just want to ask you, so you get it on the record, was there any discussion, obviously, unless you violated FOI, you probably couldn't have done this with any other member, but was there any discussion as to a strategy to stall this thing until it got to an emergency situation to where it wouldn't have had time to run through the normal channels to get in front of ALC for us to approve that contract?
No. I mean, this is, again, we would all much prefer that this had been resolved a long time ago. The board wanted the same thing the governor wanted, the same thing that this body wanted as far as the Department of Corrections. Because I think I didn't poll them, I didn't ask them, but I bet, when the governor and you guys announced basically, we're going to build another prison, we're going to add beds, you would have heard a round of cheers because we all know that's what's been needed. It's been needed for a long time. And in my letter, I didn't mean to point fingers at the current legislature. This issue goes back to the early 1980s. And, we've had a continuing problem with capacity. And I get it. It's money. It's expensive. But no, trust me, if Benny had been able to talk with the governor early, we all would have been very ecstatic at the idea that this could have been resolved without any of this happening. I promise you I would. My wife would too, because I've probably kept her awake a lot of nights tossing and turning in bed worrying about this.
Okay, all right, thank you.
Mr. Gasaway, you're recognized.
Thank you, Mr. Chairman. Mr. Watson, thank you for being here today. I want to follow up on a question that Senator Dismang asked about the attorney-client privilege. It sounds like when you and Mr. Apton were having these discussions, it clearly came up about whether or not the communications that you were having were privileged. Is that right?
No. The topic, and maybe I misspoke, it wasn't about them being privileged. It was about them being subject to FOI.
Right. And so Apton told you in the course of these conversations that the two of you were having that whatever you tell me, because you're a public board member, is not attorney-client privileged. In other words, it can be discovered, right?
Correct. Yes.
And I think the point is, if you're having a discussion about the attorney-client privilege, it essentially assumes that there is an attorney-client relationship.
Well,
otherwise, why would you talk about the attorney-client privilege?
We weren't talking about it, and I misspoke. We were talking about the FOI aspect of it. Frankly, I think one of my first conversations, I brought up FOI because I was concerned. One, if we managed to patch things up, I didn't want this information out there to cause a problem, but it was about the FOI aspect of it, not attorney-client privilege.
Okay. So it sounds like you were having regular conversations with him.
Yes.
Prior to the official hiring, and is it your contention that official hiring took place at the December 8th meeting?
Yes.
So you absolutely were his client on December 8th. In your opinion.
The board became his client,
yeah,
yes.
in your opinion.
Yes.
But prior to that, all the discussions that you had leading up to that, you don't feel like it at any point that through the research that he did for you, through the advice that he gave to you, through the very nuanced issues of law that you discussed about the Constitution, Amendment 33, and the employment matters, and all the things that you discussed with him, that at no point that ever ripened into an attorney-client relationship?
No, I don't. And, I've had other pending litigation where I've sought counsel from other attorneys, even though I might have had an attorney or maybe not, where, I was trying to figure out the best course. And as a board member, I was trying to figure out what are we going to do if. And I wish I hadn't come to that. I really do.
Well, and I'll go back to the point that has been made several times now. On day one, December 8th, the day that Abton was hired after the 3-minute meeting, he spent 6 hours drafting a complaint. And he also included a couple of other hours where he specifically referenced conversations with you that day. The very next day, he spent another, I believe, 8 hours working on the complaint. It was somewhere around $4,000 in legal fees just on the complaint, which is a lawsuit. Do you see why it's hard for us to believe that all these conversations are happening? It's clearly involved Amendment 33 and the subjects of what were ultimately the lawsuit, and that somehow you weren't, and the board really wasn't his client until December 8th, and he just happened to start drafting a complaint on that day. You see why that makes it hard to believe?
You know, again, best case scenario, we wouldn't have had to do that. And he would never gotten paid for a dime of that time up until December 8th. And he didn't get paid a dime for any of his time up to December 8th. I didn't give him a penny. To my knowledge, no one else did. So, yeah, we had quite a few conversations, you know, and he was very engaging. And it was obvious he saw this as an academic and very unusual situation, but of a constitutional nature and an employment law. And you know, it's one of the things that really engaged me with him and made me think, okay, this guy's sharp. He's very sharp. He got the issues very rapidly, not pretty rapidly, but very rapidly. And, you know.
So, and I appreciate that. And we're going to talk about payment for his services here in just a minute. But, you know, I find it hard to believe, I think members of this committee find it hard to believe that all of those conversations that were taking place about these very specific areas of law, and then the day he's hired, he begins drafting the lawsuit against the state, that those communications did not ripen into an attorney-client relationship at some point prior to the day that you had your board meeting. But we'll set that aside. The sovereign immunity issue. Actually, no, let me go back. So the hiring of Abton, let's talk about the 8th.
Yes, sir.
Because you've been having these conversations with Abton. The 8th, in your mind, is when he officially became your attorney. But there were a lot of other law firms that you could have contacted here. I mean, I mentioned several of them earlier. You have the Rose firm, you have the Friday firm, you have Mitchell Williams, you have Wright Lindsay Jennings. You have a lot of really good law firms here in Little Rock that do employment law. Did you ever talk with any of those firms?
I did not, but when you say those names, as an attorney who's hired counsel to represent companies in personnel matters, all of those I see as big dollar firms, expensive firms. And one of the things I noticed about Abton early on, it was a smaller firm, at least smaller footprint here. And, you know, my experience, the larger the firm, the bigger the bills. And one of the things that subconsciously factors in with me is I want the best for the best price.
Okay. All right. Well, let's talk about the contract that was ultimately submitted in March and the issue of sovereign immunity. So I noticed when I look at the contract, a few things that I find very interesting about it. The changes that Abton made to the contract, specifically in Section 5, he added language about that he was to be reimbursed expenses incurred during the representation, and he added $7,000 to the bottom line of the contract. It was $200,000. He made it $207,000. Did you know about that?
Not till after the fact.
Okay,
but that's normal in engaging counsel. They very often itemize business office expenses.
But my point to you is let's take that aside, and I understand that. But one, that's about money to Abton. Okay, right?
Sure.
All right. He went on that the board's litigation liaison, which would be you, shall be solely responsible. Now, you're the guy he was having all these conversations with before this contract was submitted, that you would be solely responsible for determining whether or not his performance was satisfactory. Mm-hmm. Well, that's quite convenient, isn't it? I mean, you're the one he had the relationship with, and you're the one who's hiring him. essentially recommending him to the board, you're the sole person who's going to determine whether or not his performance is satisfactory. So that, and then as it continues, and the litigation liaison, of course, being you, shall be responsible for authorizing payment under this agreement. Again, he's adding provisions that were not in here previously that relate to him being paid and changing the terms of the contract by $7,000 for him to be reimbursed expenses. Were you aware of that?
Not until after the fact.
Okay.
But again, I look at those, if I can explain, as, I was his contact, his go-between with the board, and I looked at his fee statements, and if I had issues with them, I would have rejected them. And I've done that with other attorneys I've hired. If I think they're billing excessive, that's...
No, I understand that. And I don't want to get too far in the weeds on that, but I'm heading to a specific point.
Sure.
One is then that particular paragraph, paragraph 5, all the changes made there benefit Apton. It was $7,000 more money to Apton. It was you reviewing his performance and you being responsible for paying him. It's about money to Apton, okay? Let's go to paragraph 5. That's where he reflects the $7,000 increase to the contract to $207,000. That's a benefit to him. Let's go to paragraph 9, sovereign immunity. This portion of the contract has written in bold and in red letters, non-negotiable. Okay? And the point is, this provision states, nothing in this contract shall be construed as a waiver of the state's sovereign immunity. And in this particular point, Apton adds a change, if applicable. Okay? And then it goes on. Any claims contractor, that's Apton, wishes to assert against the state in connection with this contract, in other words, to be paid, shall be brought in the Arkansas Claims Commission, and then Apton makes another change right here, if applicable. Mm-hmm. All of that is to benefit Apton in order to get paid. Wouldn't you agree?
Well, I think, if I can explain, the first one has to do with sovereignty generally.
But do you see a distinction between the issue of sovereign immunity and the issue of Apton being paid? And I think that's what Representative Beatty asked you about earlier. Mm-hmm. The point is, sovereign immunity is not an issue in the Amendment 33 case, correct? Never been raised by either party, the issue of sovereign immunity in the Amendment 33 case.
I will tell you that personally, I didn't fully understand that issue, but Apton explained that it could be. This was before we ever even saw this document. But then regarding the Claims Commission, we have a statute that says we're entitled to hire him and he's entitled to be paid. So, it's like, well, does that conflict with what Judge James had ordered in Section 711?
Again, Mr. Watson, I want to ask the question. I've asked a very specific question. I'm going to ask it again. Has the issue of sovereign immunity been raised specifically by either party in the case related to Amendment 33?
I don't believe it has, but
okay.
Apton has told me to expect that it would be on appeal.
Has the issue of sovereign immunity been raised by either party in the FOIA case?
Not that I recall.
And so, once again, there is really no distinction in the issue of sovereign immunity, or there is no issue of sovereign immunity in any of these cases that Apton is representing you on the board on, other than as it applies to his ability to be paid.
Well, no, I disagree. I mean, he's told me very clearly that very often it is raised for the first time because it can be, because the Supreme Court has original jurisdiction on sovereignty issues.
Okay.
Even if it's never raised at the lower court level, the Supreme Court can say, yeah, this lawsuit dies because of it. And he wanted to make it clear that we weren't voluntarily giving up any ground there.
Okay, fair enough. But let's talk about specifically the language in paragraph 9. Mm-hmm. Any claims contractor. This isn't about what the Supreme Court can do in the Amendment 33 case sua sponte if they decide that sovereign immunity applies and the whole case should be dismissed. This is about any contractor. Who's the contractor? Apton. Mm-hmm. Any claims Apton wishes to assert. This is about Apton. This isn't about the board. This isn't about Amendment 33. This isn't about the legal doctrine of sovereign immunity and how the Supreme Court may interpret it. Any claims contractor wishes to assert against the state in connection with this contract shall be brought in the Arkansas State Claims Commission, comma, added by Abton, if applicable. That's all about him being paid.
Well, and it's about the conflict between that and Section 711, which says if we're entitled to him, he shall be paid a reasonable fee.
Okay. Let's go on. Another change that he made in paragraph 15 of the contract, which is specifically about amendments. It says, the terms of this contract shall not be waived, altered, modified, supplemented, or amended in any manner whatsoever without written approval of both parties. Any amendment that, and so this is the pertinent part, any amendment that increases compensation, what are we talking about? Compensation, or represents a material substantive change may require review by Legislative Council or the Joint Budget Committee pursuant to Arkansas Code 1911-265, and Abton added, comma, if applicable. The point being, an issue about compensation, who does that affect? Abton. May require review by Legislative Council or the Joint Budget Committee. Does he want that? No. So what does he do? He adds the language at the end of that, if applicable. Do you see that all of these changes all relate to issues about Abton, his compensation, and his ability to be paid? Do you see it some other way?
I do. I disagree because I think it's, again, about even the inherent conflict there between that and 711 and how he is paid. You know, even Chad Brown, I mean, everybody said, well, he's put in all this work. He deserves to be paid. The question is, under 711, how does he get paid? And that's why we're here. We thought we were doing it the right way. If we weren't, we need to start over.
I'll keep going. Paragraph 19. He made changes, one of which at the very end, which is in a different type font than the rest, outstanding invoices in line for payment. Mm-hmm. Once again, and I think the point is, these changes were made very inconspicuously, I might add, although one was in a little different type font, and submitted, and it sounds like when you guys first appeared before ALC, that no one knew anything about them. I mean, is that not concerning to you?
You know, it's my understanding that Chairman Magnus, as he testified earlier, pulled over, reviewed it. Frankly, I have almost no experience with procurement in that side of the house. I viewed this not as a replacement of our engagement agreement. You know, but again, I looked at it for a matter of seconds, the original one, the blank one. And, you know, I thought this is just an explanation of what the services are that Abton, that we have to follow through in order to get him paid. Now, in hindsight, after I read it, it's like, okay, well, this could potentially alter our legal relationship with him, our contractual relationship. And when I read it, I'm like, okay, now I get it. I know why he made these changes, and I agreed with him. Because I would have if I'd been him.
Does it bother you that he made changes to a section of a contract, a standard form contract that's used by everyone who seeks to do business with the state under a services agreement like that he made changes to a portion of the contract that in bold and red says non-negotiable?
In any other circumstance, I'd agree with you wholeheartedly. But this is an intra-government conflict and decision that has to be made. So this is a unicorn. We're in uncharted waters. And again, we're trying to do the right thing by you guys, by the Constitution. We were in a position that was untenable. I mean, we're like, what do we do here? We've reached out to the governor's office. We don't hear anything back. We're publicly lambasted. And we can't manage the secretary. And then after Act 659 would go into effect, we wouldn't even be able to manage the directors. So we're the board of basically upper management of a corporation, if you will, that we can't affect. We can't, they're no longer be responsible to us. And it, you know, frankly, it's a horrible position to be in. It's like, what do you do here? You know, we can't continue, as one of the board members said, a couple of months earlier, we're quickly becoming the board of nothing. And, you know, we had plenty of other issues, you know, just with the day-to-day when it comes to trying to fit more beds in, trying to hire staff. We've tried to hire staff. Anyway, we have so many things we wanted to be focused on, need to be focused on. And here we're, you know, all of a sudden, you know, what we were saying we thought was very poor, very reckless decisions to cram people into facilities that weren't ready for them, that didn't have adequate staff. And the results there could be catastrophic.
Okay. And again, thank you, Mr. Watson. I appreciate you being here.
But Senator Gasaway, I wish there had been another solution to this. I really do. The whole thing. We all do. This, the state would be better for it. You know, I promise you, as a board member, I can't speak for everybody else. We need more beds in our prisons. We need in the existing ones, but we got to have staff for them. We need more prisons, and we all very much respect the PROTECT Act. I do. You know, I used to be a prosecutor a long time ago. I was a public defender also, and you know, we realize there's got to be consequences for people's actions. I live across the street from a woman who her mother and parents were killed years ago, and in a home invasion. And you know, those sort of issues are very near and dear to me.
Thank you. And Mr. Gasaway, you finished? Okay, real quick before I go to Mr. Beatty, a little bit of housekeeping. We're going to try to wrap up here in a few minutes, but we're going to recall one witness for just a couple questions. So with that being said, Mr. Beatty, you're recognized.
Thank you, Mr. Chair. There are so many things you said that I want to take issue with, and I'm still hung up on the sovereign immunity side as to how that would benefit the Board of Corrections or the state. I mean, I just don't see that, and I don't see how any agent of the state could sign an agreement and waive sovereign immunity.
Well, I don't think it did that. I don't think it has that effect. It says they will not waive it, you know, if it's applicable. Well, as Afton said, it's either applicable or not. I'm not as nuanced an attorney and a student of constitutional law, and that's something we as a board relied upon him for, his guidance and advice. I'm not a constitutional law expert, definitely not on sovereign immunity, and frankly, we had to rely on him. And
well, it is a big hang-up, and I think it was a hang-up with every member of this committee that read that.
I understand.
And it points out everything that Representative Gasaway pointed out in amendments to that contract or into the agreement. We won't call it a contract. We'll use whatever vernacular was used earlier. That only benefited the law firm. The other thing I take issue with is we named some fine Arkansas law firms that are here in the state that could have helped. I know Hall, Booth, and Smith has a presence here, but are you aware that they're in 12 states and they have over 400 attorneys on staff? And you referred to them. Well, they're a small boutique type law firm. They're one of the larger firms in the country.
That was my first impression of them, and really until I dug into it further, I didn't realize that. And that's become so common with so many law firms, you know, frankly, because big law firms are buying the boutique firms all over the country. It's not good for the legal profession, but it's what's happened over the last 20 years.
And then I go back to the initial meetings that you had and your position and authority that was bestowed upon you by Chairman Magnus to be the legal advisor to the board and to seek out someone to deal with a personnel issue, when it really comes back down to everything I heard you say sitting at that table today goes back again to a 5-letter word I said earlier, and it's power. And that the PROTECT Act diminished the power and the role that the Board of Corrections and its members would have over the Secretary of Corrections.
Well, Act 185 did that.
Well,
yeah, which is not
correct.
part of the Protect Arkansas.
It was a separate act.
It's Act 659. But it does beg the question, if that's the law, which Judge James says it's not, Act 33 trumps those, if that's the law, then, we as board members might as well pack up and go home.
So
There's going to be no service that we can provide.
So we're in this all because you didn't have control over one person that I think argumentatively we'd say you had control over, and you said you didn't want to be in this. You just wish we couldn't be in this if there's anything to do. Yet how many times and how many members of that Board of Corrections reached out to the governor's staff, reached out to the Attorney General, or tried anything other than going out and lawyering up and suing to try to declare this act unconstitutional so that you could protect your power and your fiefdom? What actions did you take besides hiring an attorney?
I know that Chairman Magnus told me that he...
I'm asking what you did, other than your open letter that was rather insulting.
Well, I also wrote a letter to the Attorney General as a follow-up to some of his FOI claims, and in it I asked him, we need advice. We need your counsel. But by then, everything was so awkward because of the position we had been in, and we were just trying to find a way out of that because, Amendment 33 vests general management powers over the board. And so if that's, from an attorney's perspective,
I appreciate your position. I appreciate you trying to answer the question. The deal is it all comes back down straight to power. And the position and action you've taken as a board was to protect your power. And I think that's a dang sad state.
Sir, our goal was to protect the Constitution.
Thank you.
Thank you, Representative Beatty, and Senator Dismay, you're recognized.
Thank you. There's a couple of things, just because I know we're closing up. And was there at any point prior to the hiring of the attorney that you sought counsel from your own legal counsel or anyone else in the office about what action to take, how to pay, and all those sorts of things?
I don't think so.
I don't either, because it would have been almost impossible to happen in a 3-minute window. And so there was something said earlier, alluded to, and I want to make sure everybody understands really quick. Mm-hmm. Your staff did not get you into this situation.
No, sir.
And in fact, your staff or your department is being sued by you, which even complicates the matter even more. And to their own credit, they're trying to figure out how to bail you out of the problems that you've created. And that's why professional services came up, because they know there is no vehicle, because you didn't have the authority to do what you did to begin with, because you didn't bother to ask for advice before you entered into the legal contract. Now, there were 2 members of your board, and it's, maybe Mr. Giles comes or not, that decided that maybe this wasn't the wrong path. I look forward to hearing why. But anyway, so before we leave, I just wanted to make sure, I don't want anyone to be confused when we walk out of this room. The staff had nothing to do with why people are here testifying today, because they weren't even involved in the process of the discussion, how we got here. They've just been trying to pick up the mess. One thing you did say...
May I clarify? I mean, we did look to their assistance.
After you made your decision to enter into an engagement.
Correct.
Thank you. That's picking up the pieces after the mess is created.
Okay.
All right, and then on FOIA, you said something. So you told, there was a conversation about how attorney-client privilege was discussed. Mm-hmm. And essentially, Apton had said, that won't apply to us because you're a board member. I just want to make sure you know. Mm-hmm. And to which you said, well, that wasn't, and then you corrected, after some other questions, you said at one point, well, that was more about FOIA. I just had some questions about FOIA because I didn't want this to be subject to FOIA.
Well, it wasn't that I didn't know.
What a thing to say.
No.
No, sir. The fact that you were intentionally asking an attorney, how do I prevent this from being made available to the public? And you were having those discussions after probably, 20 minutes ago, you told us that you intentionally delete all of your texts and all of your emails so they're not subject to FOIA, which brings me back to the whole point of my problem that I've had the entire day. And that is, I do think there were processes in place. The process were to make sure that no one could follow the process. I mean, all day long, I've heard conflicting testimony back and forth. Why do we have conflicting testimony? Because nothing was done in the open. The only open thing that we have to talk about a $207,000 potential bill for the state of Arkansas, is a 3-minute meeting in which someone was hired. That is my disappointment. My disappointment is I think that a lot of this was intentional. I think you've acknowledged in some ways that it was intentional. And I get that maybe you've said something that you didn't really mean to say, so then you try to fix it with something else that you probably didn't mean to say, and now we're about to probably give me some other answer that you don't mean to say.
No, sir. My concern was I just frankly did not know if my conversations with him.
Well, you said a minute ago you didn't want them to be.
No, if I
yes,
said
sir, you said it twice.
I didn't mean to. Was not my intent. I frankly just did not know when I started talking with him.
You said you didn't want them to be because you thought if this whole thing could get smoothed out, you wouldn't want other people to know about the conversations you'd been having.
Well, my concern was, if we're exchanging drafts or ideas that are in their infancy that may change. And so that's why we pretty much decided we're just going to, communicate over the phone. And because I didn't know what the solution was. And frankly, I don't think he did. It's like, we've got this problem. We wanted to find the easiest,
I got it.
The best way.
I got it. We don't need to talk about the fact that there was talk of employment because that would constitute a relationship. We don't need to talk about the fact that we talked about the fact that there might be a relationship that would be subject to FOIA or not be able to be protected from clearance. I get all of those things. He was very careful in how he made his words earlier for that very reason. And again, I wasn't smart enough because I'm not an attorney to understand why. I do understand now, based on your testimony, why he was saying what he was saying. I'll leave it at that. I'm just disappointed in the process. I'm disappointed to think that you think we're naive enough to think that there was a 3-minute, conversation in which we hire an attorney at $285 an hour from a boutique law firm that turns out to not be a boutique law firm.
Thank you, Senator Dismang, and best for last, Senator Irving.
Thank you. This was January 31 of 2024. So again, after the fact, just like Senator Dismang said. So Mr. Brown said something to the fact, on page 4, if we need to go back and fix the way that the contract was established, then that would be my recommendation. That's what he said in this meeting. And then you responded that you do want to make sure that we follow the procurement rules and that the situation is a little different from other situations. So at that point, are you talking about, is he referring to, was the way the contract was established, and we need to go back and fix the way it was established? So is that in reference to the way y'all voted on the contract, or in the letter of engagement versus versus what we have here? I just need clarification.
What I was focused on is, should we've even submitted that procurement document? Was that the right path?
Okay.
Up to that, I believe we were 100% justified under our statutes of hiring Apton and moving forward. But frankly, we didn't know what we needed to do to get him paid.
So that was to produce the procurement document contract. Yeah. Okay.
Yes,
and
ma'am.
then I just needed to get that clear in my head. And then and this may be more of a question for Mr. Brown, but because we're talking about, but you do come into these emails where it says Chad Brown called Lee Watson to get the total anticipated cost, and that you directed Chad to contact Mr. Metazedigan for the information. But the word anticipated cost, did the board understand that this was an anticipated cost? Because that language is later used in an email from Mr. Brown as an anticipated cost of $200,000.
I think that was his reasonable best effort of what it would be to see this through. And what I'm used to doing as in-house counsel, the financial folks will come and say, hey, we've been sued, you hired an attorney, you've given us an estimated budget because they've got to book it. And initially I might say, okay, we may be able to get out of this. It may cost us a total of $30,000. Attorney's fee, settlement, whatever.
Okay.
If it progresses, then I have to go back to the business, say, you know what, this is taking a turn left. I think now our exposure here, because we did some things wrong, or whatever factors might come in, or it's in a city where the council's much more expensive. You know, we need to book a potential expense up to $100,000. And that's what I saw this as, was not, it's gonna cost $207,000. I saw it as, this is gonna cost up to that.
Right.
And frankly, when we started this, had there not been such heavy pleading practice, and had there not been the FOI suit, I never thought we'd hit $70,000. I thought we would get in front of a judge, we'd get a decision on a declaratory judgment action as the constitutionality of this. If it's appealed, sure, that's going to cost more. But even that all, I didn't think would, you know, if you ask me, you know, I just would not have expected that to go north of $70,000, even at $285 an hour.
Right. But I think, you know, the problematic part of it is that the board there's no minutes that we can point to that gives the authorization of up to $210,000, $250,000. There's nothing that we can point to that gives that authorization, which is why there's an issue with the contract that's submitted. I mean, that's one of the issues, but there's several. But there was no follow-up board meeting after this one to give that necessary authorization.
I understand.
Okay, thank you.
Thank you, Senator Irving. And with that being said, thank you, Mr. Watson, for being here today. You're still subject to being recalled.
General Barry,
yes.
I have a doctor's appointment in Northwest Arkansas next Tuesday.
Okay.
Something I've been waiting on for a month. It's with a specialist. If I miss it, it's going to get pushed off another month or so. And, you know, hopefully, anyway, I don't know how serious it's going to be.
Yeah, I think we've pretty well got you covered, so go ahead and keep your doctor's appointment, okay? Thank you. And the chair calls Mr. Benny Magnus back to the table, please. And Mr. Magnus, please remember you're still sworn in and under oath. But if you would, take a seat, state your name and position again for the record.
Benny Magnus, Chairman of the Arkansas Board of Corrections.
Senator Stone, you're recognized.
Mr. Magnus, earlier you testified that neither you nor your businesses have recently done business with the state of Arkansas. Is this correct?
Yes.
You are the current president and registered agent for Magnus Oil Company, correct?
Magnus Oil Company is still a corporation, but I sold the assets and closed down the entity in January of 2023.
You know, if you go to the Arkansas Secretary of State's website, it still has you listed as the president and a registered agent. You know, if you go to the Transparency website, you'll find that Magnus Oil Company is listed 12 times doing business with the state of Arkansas. Is this correct?
I don't know what manner, because I've not done business with the state of Arkansas as with Magnus Oil Company. And
well, if you've sold
the only time that I can recall is the time that we got an exemption from the DF&A to try to get fuel to the farm. And if it says that, somebody's going to have to show it to me, explain to me, because I have not done business with the state of Arkansas as Magnus Oil. I haven't sold any fuel unless
well, if you've sold it, why are you still listed as president?
Do what?
I said, if you've sold your business, why are you still listed as president?
Because we sold the assets. We didn't sell the corporation. And
do you still benefit financially from that company?
Do what, sir?
Do you still benefit financially from that company?
I've benefited from the sale, but there's no longer any action in that company, and we haven't filed the final IRS return and done a dissolution. I can't remember the form with the state of Arkansas closing that corporation out, and we're just waiting for the final return to be done, and then we'll file a dissolution. So Magnus Oil only exists now as a entity for accounting purposes only. It doesn't make any sales.
What about other companies that you may be affiliated with directly or indirectly that are doing business with the state of Arkansas?
The only business I can think of that might be doing business with the state of Arkansas is I'm involved in Magnus Hospitality, and I have 7 hotels, so they could possibly, someone stay there and as a state employee, and I wouldn't really know that.
All right, I believe you're also still listed on the Secretary of State's website as in good standing. So I'm just wondering why all this stuff is still existing on the Secretary of State's website if you've sold it. I mean, I just need to get some clarity on what's going on, because what you testified to earlier and what's on the website is not adding up.
I would like to know where it shows in transparency that I sold
You
the
can go
state
to
of Arkansas any services or
transparency.arkansas.gov.
product, because Magnus Oil Company has not sold anything to the state of Arkansas, to my knowledge, in 25 years, because it was known that I couldn't, except for the time.
You know you're under oath.
Do what, sir?
Yes, and you still realize that you're under oath on what you're saying
Yes, sir.
right now. Okay.
I just said that I realize, that I know. And Magnus Oil Company itself has not been in business of selling products since January of 2023. Magnus Transportation existed from up to August 30th of 2023. That has also been sold, and that also we're trying to close that corporation out. And so, I mean, I'm welcome to see any documentation or anything that would say differently than what I'm testifying to, because never in my mind in 25 years.
Well, I bring the matter up because
you.
it's still listed on the Secretary of State's website. And
Yes, sir. And it will till we do it.
It'll come out one way or the other. Thank you, sir.
And thank you, Senator Stone. And Mr. Magnus, you're excused with subject to being recalled.
Okay.
Thank you, ladies and gentlemen, for your patience today. It's been a long day. I just have one quick thing that I want to read for the record. And the next JPR meeting scheduled to be take up the Board of Corrections investigation will be held April 11th, 2024 at 1 p.m. in this room in Big Mac Room A. Please note we are providing notice to the committee members that that at the April 11th meeting, the committee will discuss whether any subpoenas need to be issued by the committee. This serves as the 1 week notice to the members of the committee as required by the law. That consideration of the issuance of subpoenas will be taken up. And with that being said, no further business. Let me yield to my co-chair. You have any comments, Senator? Thank you, Senator. And with that being said, this committee is adjourned.